ಎಲ್ಲಿ ಮಾಡ್ತೀವಿ ಸರ್ ಅದನ್ನ ಸರ್ ಯಾವ ತೋರಿಸ್ರಿ.
paucity of time could not be reached. But there's an urgency, my lords.
What urgency, sir?
Road widening, my lords, is been done by the respondents.
Ah.
I'm only seeking, my lords, stretch of, my lords, 100 meters to be excluded because it is before the temple and the chariot is being pulled. If the road and, my lords, the project ends at the temple, my lords.
ಆಯ್ತು ನಾಳೆ.
One.
230.
With my lord's leave.
Wait, ಕರ್ಕೊಳ್ಳಿ.
From 2017, employee.
Huh?
2017, employee has been dead, my lords. His pensioner benefits are not has been given, my lords.
ರಿಟೈರ್ಮೆಂಟ್ ಯಾವಾಗ?
Retirement after death, my lord. 2019.
ಕೊಡಿ.
Tomorrow.
ನಾಳೆ ಹಾಕಿ. ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಹಾಕಿ.
Two matters not, last occasion I moved not being spoken to, my lord.
Why?
There is some, the 13D complaint till statement of objection filed, my lord.
ಅದು ಕರೆಕ್ಟ್ ಮಾಡದ್ನಲ್ಲ ನಾನು.
ಮಾಡಿಲ್ಲ.
ಆಯ್ತು ಕೊಡಿ. ನಾಳೆಗೆ ಹಾಕಿ being spoken.
Arrest warrant is issued, my lord. Fresh matters. Already my lord has granted interim order in the three matters. Same, my lord.
Friday.
My lord, arrest warrant is issued. ಅದಕ್ಕೆ ಯಾರಿದ್ದಾರೆ ಅವ್ರ ಮೇಲೆ arrest warrant issue ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು ಕೊಡಿ. 230 ಇಲ್ಲಪ್ಪ ನಾಳೆ. Yes.
Kindly, my lord.
Ask you to escape trial. Why should I show indulgence? 230 ಗೆಲ್ಲ. ನಾಳೆ ಬರ್ಲಿ ಬಿಡಿ. You have escaped trial? Correct?
I'm ready for.
That's all right. You have escaped trial. Shall I send you to trial now? ಮತ್ತೆ ಅದೆಲ್ಲ ಅರ್ಜೆನ್ಸಿ ತೋರಿಸ್ಬಿಡಿ. No indulgence to people who have escaped trial. ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಇಶ್ಯೂ ಮಾಡಿರೋದು. ಪರವಾಗಿಲ್ಲ, ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಅಲ್ಲೇ ಹೇಳಿ. ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಯಾಕಾಗುತ್ತೆ? ಬಿಕಾಸ್ ಯು ಎಸ್ಕೇಪ್ ಟ್ರಯಲ್. ಮತ್ತೆ
Other accused have escaped, not me.
ಸರಿ ಸರ್, ವಿಲ್ ಸಿ.
Kindly, my lord. Serial number 192 and 190.
ಡೈರಿ ನಂಬರ್ ಅಲ್ಲಿ ಮೆಮೊ ತಗೊಳಕ್ ರೂಢಿ ಇಲ್ಲ ಇನ್ನು.
No, my lord. This is fresh matter. Finalized ಆಗಿದೆ ಇದು.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಬಂದ್ರೆ
Writ of mandamus, my lord.
ರಿಟ್ ಆಫ್ ವಾಟ್?
Writ of mandamus, my lord. ಅದು tomorrow, my lord. ಅದು finalized ಬಂದಿದೆ.
ಅದು WP ಆಗಿದ್ರೆ ಮಾತ್ರ ಬರೋದು. ನೀವು FR ನಂಬರ್ ಎಲ್ಲ ಕೊಡೋ ರೂಢಿ ಇಲ್ಲ.
ಇಲ್ಲ, WP ನಂಬರ್, my lord.
ಕೊಡಿ. ಮತ್ತೆ ಡೈರಿ ನಂಬರ್ ಅಂತ ಯಾಕಂದ್ರೆ?
ಅಲ್ಲ, today listed, my lord. 190 to 193, my lord. Last time I mentioned.
ಏನ್ ಬೇಕದ್ರಲ್ಲಿ?
ಅದು ಪ್ರೆಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನಾಳೆಗೆ, my lord.
ಇರ್ಲಿ ತಾಳಿ, ವೇಟ್.
Please, my lord.
ರೀಚ್ ಆದಾಗ ಹೇಳಿ.
One matter pertaining to.
Mandamus is there. My lordships have state the further proceedings in tender. Only mandamus to consider representation.
Give it tomorrow.
Fresh matter.
It's one matter pertaining to
So one matter.
total 6.
ಗೆಸ್ಟ್
Guest like this.
ಕೊಡಿ. ನೋ 230. ಗಿವ್ ಇಟ್.
That's one matter.
230 ಇಲ್ವೇ ಇಲ್ಲ. ಗೆಸ್ಟ್ ಎಲ್ಲ ನಾಳೆ. ಇವತ್ತು ಯಾವ ಗೆಸ್ಟ್ ಇಲ್ವೇ ಇಲ್ಲ. ಇವತ್ತು ಯಾವ ಗೆಸ್ಟ್ ಎಂಟರ್ಟೈನ್ ಮಾಡಲ್ಲ.
One regularization.
One matter pertaining to total 6. Council on record is disabled.
Not that.
ಇಲ್ಲ, he's there. One of the council on record is disabled before total 6. Tomorrow, my lord. Fresh matter.
Regularization.
Declaration ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Extendment covered. Will close. Give it. 230 covered.
230 matter, my lord. 230 matter.
ಏನದು?
Proclamation of attachment of proclamation has been
ನಾಳೆ.
ordered.
Yes.
My lord,
ಏನಾಗಲ್ಲ. ರಾತ್ರಿ ಅಂತ ತಗೊಳ್ಳಲ್ಲ ಕೊಡಿ.
tomorrow is the date before the trial court.
No problem. Give it. ನಾಳೆ
Lordships, one cooperative society matter.
Where are you?
Identical issue, my lords, between same parties has already been, my lords, disposed of. Tomorrow.
ನಾಳೆ ಈ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಎಲ್ಲ ತೆಗೆದ್ಬಿಡಿ. ಬರೀ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕ್ಬಿಟ್ಟು ಎಲ್ಲ ಅದೇ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಹಾಕ್ಬಿಡಿ. ಈ ಬಿ ಗ್ರೂಪ್ ಅದು ಎಲ್ಲ ತೆಗೆದ್ಬಿಡಿ. ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಂತ ಹಾಕ್ಬಿಡಿ.
For regularization, my lord. Second, my lord, your lordship has given date second, my lord. It was not
January.
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಬರ್ಬೇಕಾಗಿತ್ತು, ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು, ಬಂದಿಲ್ಲ.
ಕೊಡಿ. ನಾಡಿದ್ದು ಹಾಕುವ.
ಪ್ರಿಲಿಮಿನರಿ, ಪ್ಲೀಸ್.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಪ್ರಿಲಿಮಿನರಿ,
My lords.
ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇನ್ನ.
ಪ್ಲೀಸ್.
My lords, fresh matter, my lords.
230 ಇಲ್ಲ, ಸಾರಿ, tomorrow.
My lords.
No 230 unless extreme emergency. Yes, VC.
My lords, one matter for 230.
Voting.
Election
ಆಗೋಗಿದೆಯಾ?
It has been stayed and election results has been stayed.
ಆಯ್ತು,
Since 1
covered
year.
by Justice Shyam Prasad's order.
No, my lords.
Then-
We are unanimously elected members and the petitioners are, my lords, they are contesting elections for on behalf of GM OBC, my lords.
ಇರ್ಲಿ. Yes, leave it.
Interim order is there, my lords.
For 230.
Let's see.
Already date was given.
We'll take it on 17th.
Please.
List
My
on
lord.
17th.
With my lord's leave, may I request one matter for 230, my lord. Auction is slated for today. Bank
What
themselves, my lord, of my entire
what
plant. plant and machinery, my lords, of my factory. Proceedings are pending before DRT. I am, my lords, willing to sell it to a third party agent where it will fetch me, my lords, three times more than what is.
Go before the DRT and move it, sir.
No, my lords, matter is already pending before DRT. That is with the respect of completely different.
Sir, why 230 here? Move it there.
My lords, there is completely, my lords, collusion by the bank officials with some third party, my lords, who are.
DRT will not consider, 1 minute, DRT will not consider your collusion.
My lords, this auction, my lords, is not the subject matter before the DRT. Now, my lords, this auction.
File an application there, sir.
My lords, auction is slated today, my lords. I am willing to pay the, my lords, the amount.
No, sir.
Today, my lords, and the market value of the plant, my lords, is 3 times more than what the bank is selling.
What is the amount? What is the amount in due?
My lords, the amount in due is, my lords, about 16 crore rupees. And the bank is now,
Anything else, sir?
Your lordship may grant. Your lordship may grant. Kindly have it at 2:30, my lords. Now, my lords, auction is slated.
These people who are crores together of debt, they play with the law. I will not interfere. Manedidre heli. Yes.
My lords,
Poor man losing his house, you tell me. Not these people who play with the law.
No, my lords,
Yes.
my lords, I am willing to pay the, my lords, I am, no, your lordship, just bear with me for 10 seconds, my lords. My lords, I am selling it.
1 second. I am not 16 crore debt, I will not take it all. Yes.
My lords, your lordships may kindly have it.
No.
With your lordship's kindly, my lord.
Move the DRT. Yes.
My lords, the DRT, my lords, the matter will, my lords, by the time we move the DRT, my lords, all the proceedings would have been completed. Now the market value, my lords, market value, my lords, my only request is this, my lord.
I am not going to interfere when the DRT is seized of the matter.
No, my lord, DRT is not seized off with respect to this auction. Some other parallel proceedings, my lords, between by the same borrower, the DRT is seized off where the
file before the DRT, sir. No.
My lords, bank has.
I am not, sir. Ajay, I am not. Period. Yes.
Okay.
With your lordship's kindly,
Yes,
my lord. My lord, there's a matter, my lord, for 2:30, my lord. The urgency, my lord, is that under the POSH Act, the internal committee, my lord, inquiry committee, my lord, has passed an order to suspend me, my lord. They've gone beyond the jurisdiction, notwithstanding the fact, my lord, that it was a consensual relationship. And now subsequent to that, my lord, there have been...
Which matter, madam?
I'm moving a matter for 2:30, my lord, today. Yes. I'm grateful, my lordship.
Lordship, one submission. Secondly, serial number 10, your lordship, become infructuous, your lordship, as a already passed order.
Second list.
10.
Filing of the requisition,
Villainous counsel appearing for the petitioner submits during the pendency of the petition, an order is passed which is rendered the subject petition infructuous and would seek liberty to challenge the said order. The reserving such liberty to the petitioner, the petition stands disposed. Yes.
Request one matter your lordship says disposed of SBI transfer, my lord. In that locker portion has not been.
SBI
The amount
transfer.
the amount, my lord, which is lying in the account of the husband who has died. So your lordship has directed them to transfer it to my account. But so far as locker is, my lord, your lordship say that it will be added, it is not added.
Oh, yes. I remember.
Yes.
Yes.
List number 1 being spoken to, serial number 1, MS Harvi, Srinande Pachapure.
Petitioner, but injuries, there are 33 petitioners, only 15 petitioners have
All right,
printed.
corrected.
Correct.
We'll upload this certificate
Please,
copy,
please.
proper copy today.
Please.
I see. In the
Serial number 2, BN. Serial number 2, BN Mulimani, Anup J. Deshpande.
This is the case, your lordship, where 60 years has been considered. They wanted the UGC.
Oh, this UGC, other matters alli, I have said await the decision of the full bench. ಇದನ್ನು dismiss ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಇದು ತಪ್ಪಾಗಿದೆ. ಅದಕ್ಕೋಸ್ಕರ I will recall this order and direct ಅದೇ ಇನ್ನೊಂದು ಆರ್ಡರ್ UGC ಮಾಡಿದ್ದೀನಲ್ಲ, await the decision of the division bench. Full bench ಹೋಗಿದೆಯಲ್ಲ, ಅದನ್ನ will ಈ ಕೆಲಸ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಇಲ್ಲ ರಿಟೈರ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇತ್ತಲ್ವಾ? The subject petition No, madam. It's my mistake. One order, idರಲ್ಲಿ ಇನ್ನೊಂದು order ಮಾಡಕ್ಕಾಗಲ್ಲ.
One matter, Your Lordship, wherein I have filed vacating stay, Your Lordship, in that
I
matter.
said that await the decision of the full bench. ಅದ್ರಲ್ಲಿ ಸ್ಯಾಲರಿ ಕೊಡ್ಬೇಕೋ ಬೇಡವೋ ಅಂತ ಇಶ್ಯೂ ಇರೋದು. ಹೌದಾ? ಇಂಟರಿಮ್ ಮಾಡಲ್ ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನೀವು ಹೇಳಿ.
Guest faculty, Your Lordship.
ಇವ್ರ ಗೆಸ್ಟ್ ಫ್ಯಾಕಲ್ಟಿನ? ನೀವು ಗೆಸ್ಟ್ ಫ್ಯಾಕಲ್ಟಿನ?
There is a order not to terminate my services.
ಗೆಸ್ಟ್ ಫ್ಯಾಕಲ್ಟಿ ಆದ್ರೆ ಕಷ್ಟ.
State consider anta ide, Your Lordship.
Guest faculty or not, they will be appointed on the year
ಅಲ್ಲ,
basis.
if Patil sir, if it is guest faculty, what I have written is correct.
Guest faculty.
If a regular faculty.
Guest faculty.
Then what I have written is correct. I will just modify the order to say that Jagdish Prasad Sharma ಎಲ್ಲ follow ಮಾಡಿದ್ದೀನಿ. ಅದನ್ನ it is restricted to the petitioners ಅಂತ ಮಾಡ್ತೀನಿ. This court on had disposed the matter in terms of its order dated 26 November 2025, owing to certain obfuscation generated by the court itself. The matter is being posted for being spoken to. The obfuscation is qua the service of these petitioners. It is now indicated by the respondents, which is admitted by the petitioners, that the petitioners are guest faculty. In the light of them being guest faculty, the order that is passed would not require any change. Only the observation that the order passed is on the strength, also is on the score that the petitioners are admittedly working as guest faculties. The subject order shall be treated as part and parcel of the order dated 26 November 2025. Rest of the order would remain intact. For the outer limit of 12 weeks would commence from the date of receipt of the copy of this order. ಇದು KGKPSC.
Number 3, Naveen GS.
Lord, I appear for the petitioner in this matter, Lord. My Lord, there is a mistake in the order, my Lord. Here, a refund of GST has been marked as covered, but I have produced the order which is squarely covered in my matter, my Lord.
Which is that, sir?
My Lord, it is writ petition 103813. I have produced it along with the memo.
The subject petition stood disposed on the score that the matter was covered by a judgment of the coordinate bench. The judgment so printed in the order is not the one that covers the issue, but the subject petition, the subject order. Therefore, the order stands recalled and is disposed by following the order passed by the coordinate bench in 103813 of 2024, wherein the coordinate bench has held as follows. Para 4 in the end order. Next.
Fresh matter, seal number 4, Anil Associates, Mrutyunjay S. Hallikeri.
Weeks timing.
List after vacation. Yes. Whoever is interested will dispose. Yes.
Seal number 5, SC Bhima Reddy, BS Kamtek.
For the petitioner, Your Lords, I have asked for only mandamus to consider the application.
We will grant only mandamus.
Yes.
Yes. The petitioner is before this court seeking the following prayer. The petitioners submit, who are you all?
Teachers and ayahs, Your Lords.
Teachers in?
Ayahs, ayah.
Yeah, teachers and ayah.
Ayahs andre nursery schools alli.
The petitioners are said to be teachers and peons working in the school run by the first respondent Karnataka Power Transmission Corporation. Owing to the non-grant of certain benefits, representation had been submitted by these petitioners on 16/1/2009, non-consideration of which had led these petitioners to this court in WP 64836-64838 of 2009, which comes to be disposed by an order dated 12/12/2011. The petitioners were granted certain benefits but those benefits were short paid. On the score that they have been short paid, the petitioners submit another representation on 2/8/2017 which is still, which is yet to meet its consideration at the hands of the respondent. The learned counsel B.S. Kamte, appearing for the respondent, submits that appropriate orders would be passed on the said representation if reasonable time is granted in strict consonance with law. In the light of the said submission, I deem it appropriate to dispose the petition without entering into the merit of the claim of these petitioners, to consider the representation and pass necessary orders with an outer limit of 3 months from the date of receipt of the copy of the order, if not earlier ordered accordingly. Yes, next.
Seal number 6, H.M. Tharigon, Sharad Magdu.
Tharigon Renendra.
Petitioner appointed as a the Hindi teacher.
Appointed as teacher.
Teacher. In the year 2007, under the the seventh respondent. Now the seventh respondent forward the list of teachers to the for approval, excluding the name of the petitioner.
Why?
Without any reason. He filed objection before the government.
Who appears for the seventh respondent?
Seventh respondent. Served
unrepresentative.
Please.
Yes. Aided institution.
Aided institution.
The petitioner is before this court.
He is seeking negative mandamus fellowship not to release anta keltare.
Not to
release the salary for.
Not to release the salary alla.
Alla avrige irli. Ivrige yak consider madilla anta kalistane. The petitioner is before this court seeking the following prayer. It transpires that the petitioner heard so and so. The petitioner is one of those persons appointed as Hindi teacher.
Hindi
as Hindi teacher in the year 2007, along with all the private respondents.
Hindi lecturer,
Hindi lecturer, along with all private respondents. The seventh respondent at the time of appointment was yet to get itself admitted to grants. It transpires on 19/8/2011, a direction was issued by the state to submit a proposal to bring the institution along with the teachers/lecturers working in the institution under the ambit of grant. While forwarding the college, seventh respondent is said to have left out the name of the petitioner, notwithstanding the petitioner being qualified and being appointed at the relevant point in time along with the private respondents. The petitioner is therefore at the doors of this court calling in question the said action of the respondent, seventh respondent, the aided institution, by seeking a direction to consider his objections dated 12/9/2018. In the light of much water being flown as on date, as 7 years ago, the subject petition had been preferred, and there is an interim order of stay. The 7 years ago. The coordinate bench of this court on 20/11/2018 had passed the following order. The direction was not to take any decision on the list sent by the seventh respondent institution till the next date of hearing. The next date of hearing has now stretched to 7 years. Therefore, as on today, what relief that can be granted to this petitioner is that consideration of his objections as he has sought for at the hands of the sixth respondent before taking a decision on the list sent by the seventh respondent. The learned counsel for the petitioner would submit that would suffice for the present. In that light, I deem it appropriate to dispose the petition with a direction to the respondent number 6, the secretary. Caution. The sixth respondent secretary before whom the objection is filed to consider the objections and pass necessary orders thereon. Once the objections are considered and necessary orders passed, the list sent by the seventh respondent shall be processed in accordance with law. All other contentions of both all the parties remain open.
Respond number 1 to 4
consider madbekare. Respond number 1 to 4 shall consider.
If they have sent your lordship
already
respondent,
stay there.
Please your lordship. But in the list which they have sent, his name is not at all there.
Adikine objection consider ಮಾಡಿ take action in accordance with law. Interim order ಇಲ್ಲ ಅಂದಿದ್ರೆ dismiss ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೆ. Yes. So Dharwad is successful in interim order. Yes.
Seal number 7, Sunil S. Desai, Jayesh Shetty.
Next week, my lord. I am filing, my lord, the application.
Submits that what is challenge, probable and final select is subsequent notified.
Yes, I am filing, my lord. Today I am filing.
After vacation. ಇಲ್ಲ ಅಂದ್ರೆ 17th. 18 matter.
15th ಗಿಟ್ರೆ notice ಆಗುತ್ತೆ. Notice ಆದ್ರೂ ಆಗುತ್ತೆ.
Final list as well as my lord, the appointment is also been done. That is, my lord, the subject matter.
That is, his appointment itself is, my lord, provisional, subject to result of writ petition. In the appointment order itself, it is reflected.
challenge.
That is what, my lord, last date.
Appointment order indicate.
Yes, yes, my lord.
And
It has been indicated. Only he has not been arraigned, my lord. That is why I am.
You have to arraign.
That I am making application, my lord.
The petitioner files an application seeking to implead the selected candidate as a party respondent to these proceedings.
Yes.
In the light of the impugned, in the light of the order of appointment itself indicating that the order of the appointment of the petitioner will be subject to the result of the subject petition, the appointed candidate become appointed candidate becomes a necessary party. For the reasons indicated in the affidavit accompanying the application, being satisfied with the same, the application stands allowed. The petitioner amended cost rate the petitioner to file
unless, my lord, it has been, they have been served.
No, I don't know why.
Shall amend the cost title. The newly added respondent be served by way of hand summons.
Gopal Patil appears in a connected matter where your lordship has reserved, I may be permitted to serve. This is transfer from Gadag to the same person.
He is the appointed candidate, and now Malad is no more in service of that
Jims and Kims.
Malad, he is in.
ಈಗ ನಾನು allow ಮಾಡಿಬಿಟ್ರೆ ವಾಪಸ್ ಜಿಮ್ಸ್ ಮತ್ತೆ ಅಲ್ಲಿ ಎಲ್ಲ ಶುರು ಆಗುತ್ತೆ. All gymming will start. ಅದ್ರಲ್ಲಿ ಯಾರು ಗೋಪಾಲ್ ಪಾಟೀಲ್. Counsel Gopal Patil is directed to accept notice for the respondent.
Yes.
All right, we'll see. But he is not qualified, is it?
No, he is against the reservation.
It is
Reserved
not.
post ಬಂದ್ರೆ.
Yes, yes. It is reserved for Hyderabad, Karnataka.
Correct. ಅದರಲ್ಲಿ ಮುಂಚೆ ಅವರು ಕೊಡಗುವಿಂದ ಬಂದಿದ್ದಲ್ವಾ?
He is more meritorious than the
Institute of Medical Science. ಅವಾಗ ಅವರು ಕೂರ್ಗ್ MLA ಆಗಿದ್ರ ಏನಾರು?
ಇಲ್ಲ ಇದ್ದಾರೆ.
He is from Pune. He was working at Bombay.
He
was
hard working at Bombay.
Yes, reserved seat for director post.
Before I leave, I'll pronounce that.
Please, your lordship, any date, my lord, next week.
We'll
15th,
take it.
15th, 16th.
Gopal Patil ಇವತ್ತೇ
Yes, I will serve today.
We'll take it on 15th.
Please.
Or 15th, yes.
Fresh matter.
Better 16th ಇರಲಿ.
16th, fresh matter, my lord.
application copy ಕೊಟ್ಟಿದ್ರೆ
ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ ಸರ್. 16th ಅವ್ರಿಗೆ
ತಿಳಿಸ್ಬೇಕು.
Yes, next.
Anand P. Saudi, Prakash S. Udkeri.
Lordship, in this matter, they are seeking for the amount of sixth pay scale, fifth and sixth pay scale, your lordship. 4, 5 and sixth pay scale. He has given representation to the respond number 5 SDM, your lordship, where he is working.
Yeah, fifth respond, Dharmasthara Manjunathesh.
Please, your lordship, SDM college. Representation at 67. ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, page number 67, your lordship.
How can I issue a writ against them? Aided institution ಅಲ್ಲ?
Please, your
Private.
lordship.
No, it's an ACT, yes, it's not aided. I don't know. Yes.
ACT is respondent number 8, my lord.
No representation, we have the petitioner, list immediately after vacation. Yes, next.
Seal number 9, TB Karigar, KL Patil.
Which time a candidate minutes?
AV.
Doesn't survive for consideration.
Yeah, why, sir?
Because the representation is of the year 2019, my lords. For seeking a guest faculty, my lords.
Guest
Next week I will.
No, sir.
Next week I will argue, my lord.
Problem, sir. Yes. The petitioner is before this court seeking the following prayer. The prayer of the petitioner is said to have been appointed as a guest faculty in
Karnataka College.
In Karnataka.
Karnataka College respond number 3, my lords.
In the third respondent, Siddhappa Kambli Law College. The term of the petitioner as a guest faculty as found was for the said academic year. The said academic year having been over, the learned counsel for the respondent submits that nothing further would survive for consideration in the case at hand. The petition is of the year 2019. We are in 2025. What has happened later, whether the petitioner has been appointed as a guest lecturer, guest faculty later or otherwise, is not on record. Even otherwise, the petition is to be disposed as having become infructuous, and reserving liberty to the petitioner to knock at the doors of this court in the event of need, and in the event that he is not taken as guest faculty contrary to law. With reserving such liberty, petition stands disposed. Please.
Number 10, TP Hegde, Mrutyunjay Tatabandi.
Petitioner, may I seek on 12th, my lord? Senior is coming physically, my lord, sir.
PP Hegde?
House.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಇದು?
My lords, it is with regard to regularization of my lords, technical assistants, agricultural technical assistant.
ಅದು senior ಬೇಕಾ?
ಇಲ್ಲ ಅವ್ರದ್ದೇ ಇದು ಮಾಡಿದ್ರು 12th anyhow is my lords here only, that is why.
Oh, those matters are.
Yes my lords, that is why.
I list on 12th at the request, madam ready?
Madam.
On 12th at the request of.
Madam.
Please, your lordship, 12th,
List
ಅಂದ್ರೆ
on-
similar matters were disposed ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಅದಕ್ಕೆ.
ಗೊತ್ತಾಯ್ತು, ಅದು ಕೇಸ್ ಮುಗಿದ್ಮೇಲೆ ಹೇಳಿ. Yes. The list the matter on 12th at the request of the council appearing for the petition. ಯಾವ್ದು similar matter? ಇದು 12th ಈ serial number?
Please, your lordship, serial number, same number, your lordship.
ಯಾರು ಚೇತನ್ ಮೊನಾಳಿದ?
Please, your lordship, serial number 10.
ಯಾವ್ದು similar matter dispose ಆಗಿರೋದು?
I will
collect
verify,
my
your
lords.
lordship.
12th. Yes.
Serial number 12 is connected with serial number 10.
Serial number?
12.
ಇನ್ ಎರಡು ನಂಬರ್ ಇದೆ, ವೇಟ್ ಮಾಡಿ.
In the fresh matter.
ಹಾ, ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಇನ್ನ ಇಲ್ಲ. ಎಸ್
Please.
Serial number 11.
ನಾಳೆಯಿಂದ ಎಲ್ಲ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ತೆಗೆದ್ಬಿಟ್ಟು
The first respondent in this case, my lord.
I am for petitioner, my lord, writ of mandamus seeking direction to the respondent number 1 to declare the probationary period of the petitioner from the date.
ಪ್ರೊಬೇಷನರಿ ಪೀರಿಯಡ್. ಎಸ್ ಪ್ರಕಾಶ್ ಸರ್.
My lord, in this case, we have already relieved and he has transferred to the respondent number 2 institute.
The petitioner is before this court seeking the
My lord,
following prayer.
respondent number.
ರಿಲೀವ್ ಆದ್ಮೇಲೆ ಪ್ರೊಬೇಷನರಿ ಪೀರಿಯಡ್ ತಗೊಂಡಿ.
My lord, communication letter na issue ಮಾಡಿದ್ದಾರೆ my lord, respondent number 1 lien sir, lien transfer ಆಗಿದೆ ಅಂತ ಹೇಳಿ 23/11/2022 I will produce.
The petitioner is before
Let
this
them
court
consider,
seeking
my
the
lord.
following prayer. The learned counsel appearing for the petitioner submits that as early as in 2022, a communication is sent to the petitioner that his lien has been transferred to the institute where he is now joined. In that light, nothing further would survive for consideration in the case at hand. Petition is disposed as having rendered infructuous. In the light of the aforesaid communication dated
23/11/2022.
23/11/2022, ordered accordingly. Yes.
Grateful, madam.
Yes.
Serial number 12, Harshavardhana M. Patil, NV Aji.
Matter will be connected with serial number 10, my lord.
10, 12th, list on 12th along with 10. Or list on 10th along with 12, 12 along with 10, yes.
Number 13, Shivraj S. Balloli.
13 kindly have to next week months. AG ಅವರು ಬರ್ತಾರೆ.
Covered matter. My lords, I am seeking refund of my lords the differential GST amount that is to be
That
paid.
is covered, sir. Refund of Krishna Kumar ಅವರು ಆಡೋದು
At least Friday, at least.
Not
Friday.
ಏನ್ covered ಇದ್ಮೇಲೆ ಮುಗಿದ್ಯಾ? AG ಬಂದ್ರೇನು, AG ಬಂದ್ರೇನು? I have passed so many orders
Yes,
following that.
Page 80, my lords, your lordship's order is.
8?
ಇದರಲ್ಲಿ ಮೆಮೊ, my lords. New memo.
ಇಲ್ಲೇ ಇದ್ಯಾವುದು?
ಇದೊಂದು ಕೊಡಿ. Latest ಇದೆ sir. Page number 80, my lords.
ಅದು ಏನಿದೆ ಹಾಟ್ಲಿ ಕಂಟೆಸ್ಟೆಡ್, ಆಮೇಲೆ ಅದಕ್ಕೆಲ್ಲ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾಯ್ತು.
Yes. Operative question, lords.
Yes.
Lords, I have filed my statement of objections.
No problems.
That contention is arbitration ಇದೆ ಅಂತ.
ಅದು ಎಲ್ಲ ಕನ್ಸಿಡರ್
Yes.
ಮಾಡಿದ್ದಾರೆ
Yes.
ಜಸ್ಟಿಸ್ ಕುಮಾರ್.
Please.
The petitioner is before this court seeking the following prayer. The prayer of the petitioner sought is akin to what is decided by the coordinate bench of this court in writ petition 9721 of 2019 disposed on April the 11th, 2023. The coordinate bench has held as follows. The coordinate bench, the judgment of the coordinate bench in the aforesaid case has subsequently been followed by two other coordinate benches in page 38. Am I around Sabranatala?
Please, my lords.
Page 38, page 45.
Please.
All of which bear consideration by an order, in the order passed by this court in WP 25439 of 2023 disposed on 16 September 2025. The contentions of the respondents are all taken note of and an order is passed. Identical contentions are projected in the case at hand, including that of subsistence of an arbitration clause between the parties. The same being already considered by the coordinate bench in writ petition 9721 of 2019 and connected cases. I deem it appropriate to follow suit and pass the same order. An order of copy. Yes.
Highly obliged.
Next.
Till number 14. Shivraj S. Balloli.
14, my lords, the
Prakasha.
proceedings, my lords, are initiated under section 69 of the Savarda Act without issuing, my lords, a show cause notice and, my lords, an article of charge, my lords, as contemplated under 69. Please, my lords.
ಸೌಹಾರ್ದ. ನೀವು ನೋಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ my lords,
ನೋಡ್ಕೊಂಡ್ ಬಂದಿಲ್ವಾ?
ನಂದು ಇದರಲ್ಲಿ ಇದೆ my lords.
ಮತ್ತೆ ಅವ್ರೇನು ಹುಡುಕ್ತಾ ಇದ್ದಾರೆ, ನೀವು ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ?
I'm used to that iPad.
I should flag it and come, sir.
Sorry, my lords.
Oh, iPad ಅಲ್ಲಿ ಇದೆಯಾ?
Yes, my lords.
Oh.
I appear for respondent number 8, my lord.
ಸೌಹಾರ್ದ ಆಕ್ಟ್ ಇಲ್ವಾ? ಎಲ್ಲರೂ ಪೇಜ್ ಫ್ಲಿಪ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಕೊಡಿ.
ಸೌಹಾರ್ದ Cooperative societies.
What petition?
Cooperative societies.
ಸೌಹಾರ್ದ ಅಂದ್ರೆ ಈಗ
ಇಲ್ಲ my lords. My sincere apologies.
Why are you short read?
No, my lords. What conflict here?
ಇದೆ ಬಿಡಿ ಇಲ್ಲಿ. Yes.
69, my lords, contemplates.
Surcharge proceedings.
Surcharge proceedings. Without, my lords, issuing, my lords, articles of charge, my lords.
ಎಲ್ಲಿದೆ contemplation?
Please, my lords.
ಇದು ಇಂಟರ್ಪ್ರೆಟ್ ಮಾಡಿ ಜಡ್ಮೆಂಟ್ ಯಾವ್ದಿಲ್ವಾ?
ಇದೆ my lords. Page number 85, my lords. Petition.
ಎಲ್ಲಿದೆ ಇದು ಆರ್ಟಿಕಲ್ ಚಾರ್ಜ್ ಕೊಡ್ಬೇಕು ಅಂತ? ಸರ್ಚಾರ್ಜ್ ಅಂದ್ರೆ ಹೌದು.
Page 85, my lords, of the petition. Identical, my lords, case.
The petitioner
Para 7, my lords,
is before this court seeking the following prayer. Heard so and so. The petitioner is said to have superannuated, is said to have retired on attaining the age of superannuation on 31/5/2015. Long thereafter, proceedings are instituted against the petitioner under section 69 of the Karnataka State Cooperative Societies Act, hereinafter referred to as the Act for short. The petition is preferred on a slender score that the petitioner, that section 69 contemplates a notice to be issued or articles of charges to be served upon the person against whom section 69 proceedings are instituted. The learned counsel for the petitioner submits that the issue whether the articles of charge is to be issued or not in a surcharge proceedings is no longer res integra, as the coordinate bench of this court considers the said issue and has passed an order in WP 28654 of 2018. The learned AGA, though would seek to refute this submission, is not in a position to dispute the fact that there are no articles of charges issued against the petitioner, and without the articles of charges being issued, no surcharge proceedings could have taken place. In the light of the aforesaid circumstance, the only issue that falls for consideration is whether section 69
para 7, page 80.
Section 69 contemplates issuance of a show cause notice or the reply to be submitted to the show cause notice by the state. The section 69 reads as follows. Section 69 ostensibly is based upon an audit report and a surcharge proceedings being instituted on the foundation of the said audit report. Therefore, the person against whom the surcharge proceedings are instituted must necessarily be notified of such charge in the least. The coordinate bench considers the very issue and declines to accept the contention of the state that proceedings could be initiated without a show cause notice being issued. The coordinate bench has held as follows. Page 89.
89 months.
88 to 90. 88 to 90. In the light of the mandate of the statute and the interpretation of the said mandate by the coordinate bench, this court need not delve deep into the matter. While it is an admitted fact that the petition, that there is no show cause notice issued or articles of charge served upon the petitioner prior to initiation of surcharge proceedings under section 69. In that light, petition deserves to succeed. The allowed cost reserving liberty to the same liberty, this is Narendra order.
Please. Obliged, Mr. Apology.
Seal number 15, Gayatri, yes, sir.
In the earlier occasion, the government was directed to take instruction with regard to the place of residence of respondent number 6.
Page number 21 itself, Your Lordship. in the page
Appointment is subject to outcome of the petition.
Page number 21 of the petition itself, Your Lordship. Lordship has asked me what you have done in the, for verification of the residential of the respondent who has appointed, Your Lordship. In the page number 21 itself, Your Lordship, the Mangaluru Gramada voters list nalli respondent number 3's name is there, Your Lordship. And we have verified,
You're
Your
not
Lordship.
verified, you're supposed
The
to verify.
documents, Your Lordship, which shows, Your
Not the
Lordship.
documents, madam, spot verification madbekala.
Page 21, she is also in the voter list of Yelburga Taluk Mulats.
Of
That is
Mangalore.
still in effect.
Page.
Mangaluru.
21.
ಯಲಬುರ್ಗಾ ತಾಲೂಕಿನ ಮಂಗಳೂರು ಊರಿನಲ್ಲಿ.
Serial number ಎಲ್ಲಿದೆ ಇದು?
Page number, last
tick
page.
mark ಹಾಕಿದೆ.
That is Lakshmi
ಲಕ್ಷ್ಮಿ
Hallikeri.
ಹಳ್ಳಿಕೇರಿ.
ನೀವು?
Now,
She is
same as
Faridaba.
Gondwa.
Petitioner is Faridaba Begum. Page number 16, Your Lordship.
ಅಂಗನವಾಡಿ ಕೇಂದ್ರ ಯಾವುದು?
Let's Gondwal.
Gondwal village.
Gondwal 2.
ಗೋಂದ್ವಾಡ್.
Gondwal village of Koppal Taluk, Your Lordship. And the present respondent who is appointed, she is a widow, Your Lordship.
They have not announced the provision list. They have directly appointed these petitioners. We have
She is a
given
widow, Your Lordship,
objections.
and widow petitioner, the respondent number 6 is a widow.
ಅಲ್ವಾ? ಮಾಡ್ಲಿ ಬಿಡಿ. ನಿಮ್ ಬೇರೆ ಕಡೆ ಸಿಗುತ್ತೆ. ನಿಮಗೆ ಬೇರೆ ಕಡೆ ಸಿಗುತ್ತೆ. ಎಷ್ಟು 2021 4 ವರ್ಷ ಆಯ್ತು. ನೀವು ಬೇರೆ ಕಡೆ ಅಪಾಯಿಂಟ್ ಆಗಿಲ್ವಾ?
Please, Mulats.
You would have been appointed somewhere else. Just check.
ಅಲ್ಲ ಎಲ್ಲಿದ್ ರೆಸಿಡೆಂಟ್ ಇರ್ತಾರಲ್ಲ ಅಷ್ಟೇ ಅಪ್ಲೈ ಮಾಡಿ.
ಅದೇ ಅದು ಕರೆಕ್ಟ್. But she is a widow preference.
ಅಲ್ಲ ಪ್ರಿಫರೆನ್ಸ್ ಇರ್ಲಿ. She is not the resident of that place is my contention.
Verify
Voter ID
ಮಾಡಿನೇ
effect.
ಕೊಟ್ಟಿರೋದು.
Widow ಇರಬಹುದು, but how did you appoint residents?
ಅಲ್ಲ, after verifying documents only, Your Lordship, we have given the appointment.
ಈ voters ಈಗ ಗೋಂದ್ಬಾಳ
page
is
number
the
9.
village. ಇವರು ರೆಸಿಡೆಂಟ್ ಆಫ್ ಗೋಂದ್ಬಾಳ ಇಲ್ಲ ತಾನೆ?
ಇಲ್ಲ.
ಏನೋ ವಿಡೋ ಅಂದ್ಬಿಟ್ಟು ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ?
But Your Lordship, as she is already working, Your Lordship, from 20.
She is not served unrepresented ಬೇರೆ. Unless you give me what verification you have done, we will set this aside.
Lordship, as per my instructions, the documents which they have
Voter
submitted.
ID ಒಂದೇ.
Please, Your Lordship, I will get Your Lordship.
Petitioner,
I will get Your Lordship.
on the strength of the document appended to the petition, submits that the appointed candidate, which respondent? Sixth respondent is not a resident of Gondbal village where the notification was issued and the Anganwadi center situate. The sixth respondent is a resident of ಎಲ್ಲಿದು?
Mangaluru village.
Mangalura.
Mangaluru village.
Mangaluru village.
Village of Koppal Taluk.
Which admittedly is not, does not come within the jurisdiction of the Anganwadi center that is notified. Therefore, the respondent state shall secure instructions as to how the sixth respondent could be appointed as she is not a resident of the said village. The learned HCGP submits that she was a widow, so preference was given. Preference can be given, but it should be of a resident of the said village and not elsewhere. The justification be submitted by the next date of hearing.
Please, Your Lordship.
17th.
Please, your lordship.
Date, my lords.
18th.
Please.
18th.
Seal number 16, Sonu Sohel, Vishwanath Bichkatti.
This is Anganwadi helper post, my lords. The petitioner is completed 8th standard, obtaining more marks than the respondent number 8. And respondent number 8 has completed her degree, though we have not produced any
What is the
documents to that.
qualification?
Qualification is 9th standard is a maximum. 10th pass are not
Helper,
allowed for that.
Helper again 9th standard pass.
Less, failed, my lords.
9th fail.
10th fail, yes.
10th fail and the 9th pass.
Till 9th, yes. And she has filed only 9th certificate.
Who?
Respondent number 8, whereas she has completed her degree.
You have
And one
produced the
more,
document, degree idu?
no.
ಮತ್ತೆ ಹೆಂಗೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಡಿಗ್ರಿ ಅಂತ?
This is the information I received. One more point is, my lords, she has filed her parental address on her parental address, whereas both are
Appears
widows.
for the 8th
And
respondent.
it is my matrimonial
Iva?
place.
ಯಾವ ಡಿಗ್ರಿ?
Annexure E may kindly be produced, my lord,
Annexure E. ವ್ಯಾಸಂಗ ಪ್ರಮಾಣ ಪತ್ರ.
pertaining to respondent number 8.
BA. Your BA?
Yes. Yes, lordship.
And it's her parental place, my lords.
ಯಾವುದು ಮೇಡಮ್ ಅದು?
This is Baichvalli place.
And what did you produce? 9th standard ಮಾತ್ರ produce
Yes,
ಮಾಡಿದ್ರಾ?
yes.
Yes, lordship.
9th pass. ಯಾಕೆ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ವಾ? ವೈ ಸರ್? ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕೆ ಹೇಳ? Playing fraud on the state? And BA ಪಾಸ್ ಮಾಡಿ ನೀವು ಅಂಗನವಾಡಿ ಕೆಲಸ ಮಾಡ್ತೀರಾ?
Helper.
ಮಾಡೋದೇ ಇಲ್ಲ ನೀವು.
Helper.
ಅದು ಅಂಗನವಾಡಿ ಹೆಲ್ಪರ್ ಬೇರೆ, ಇಂಪಾಸಿಬಲ್. ಐ ಆಮ್ ಅ ಗ್ರಾಜುಯೇಟ್ ಅಂತ ಮಾಡೋದೇ ಇಲ್ಲ ನೀವು. Yes. Anything else? The petitioner is before this court calling in question appointment of the 8th respondent as Anganwadi helper in the ಯಾವ ಅಂಗನವಾಡಿ ಇದು?
Baichvalli 2, Anganwadi Kendra.
ಎಲ್ಲಿದೆ ಮೇಡಮ್? In Baichvalli -2 village of Hangal Taluk. Heard the learned, heard so and so. The facts in brief germane are as follows. The respondent 1 to 7 notification ಯಾವತ್ತು ಮೇಡಮ್?
11/8.
A notification comes to be issued by the state seeking appointment of Anganwadi worker and helper to the aforesaid Anganwadi center. A committee comes to be constituted for the purpose of selection on 11/8/2020. The petitioner and the 8th respondent both apply pursuant to the said notification. On 13/11/2020, the committee, after assessment of the documents, notify a provisional select list and then a final select list despite the objections of the petitioner. The final select list selects the 8th respondent as Anganwadi helper in the aforesaid Anganwadi center and therefore Anganwadi center. The petitioner challenges the same before this court in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner is qualified to hold the post. The 8th respondent is overqualified to hold the post as the 8th respondent is a graduate Bachelor of Arts. The learned counsel further contend that the 8th respondent has suppressed the fact that she is a graduate but has produced only the marks card of 9th standard to secure the appointment, and would further submit that she is not even a resident, madam?
Please.
She is not a resident.
She is not her parental residence is Baichvalli.
She is not a resident of the village in which, the Anganwadi center is not situated where she resides, as she gives the address of her parents as staying there, notwithstanding the fact that she is married. With the learned AGA would, learned counsel appearing for the 8th respondent would seek to defend the action on the score that overqualification is no bar to secure appointment as Anganwadi helper and would submit that the petitioner is residing with her parents and therefore the said address has been rendered. The learned AGA would toe the lines of the learned counsel appearing for the eighth respondent in contending that the eighth respondent is appointed 4 years ago and the said appointment should not be disturbed at this juncture. I have given my anxious considerations notes. Therefore, narrated facts are not in dispute. The issue lies in a narrow compass. The qualification for appointment of Anganwadi helper notification hakidra madam?
Yes, Milords, at page number 14, notification.
The qualification in terms of the notification
Point number
for
5.
appointment of Anganwadi helper is.
Point number 5, Milords. Anganwadi ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಬಯಸುವ ವಿದ್ಯಾರ್ಥಿಗಳು
The qualification is as follows. Page 14, marked portion. An Anganwadi helper, the Anganwadi worker must have 10th standard. Helper should have passed 9th standard. This is the qualification necessary for consideration of the cases for worker or helper. As observed, the petitioner and the eighth respondent apply for the post of Anganwadi helper. The eighth respondent is selected on the score that the eighth respondent's marks in the 9th standard was over and above the marks of the petitioner. But the fact remains that the eighth respondent has played fraud upon the state by producing a 9th standard marks card and a 9th standard marks card, notwithstanding the fact that she is a graduate. The evidence of the eighth respondent being a graduate is as follows. It is a certificate issued of the petitioner passing BA in the college as on 15/3/2021. It reads as 36. In that light, whether the petitioner belongs to the said village or otherwise need not be gone into, as the petitioner suppresses the fact that she is overqualified to the post, produces a 9th standard marks card and secures the employment. If this cannot be termed as playing fraud on the state, nothing else can be. In that light, the appointment of the eighth respondent must necessarily be obliterated. The petition thus deserves to succeed on this sole score. The allowed cost, the appointment of the eighth respondent stands obliterated. The appointment shall be offered to the petitioner if the petitioner is found eligible in all other facts. Yes. Next.
Seal number 17, Srinande Pachapure.
Speaking, my lord, writ of mandamus, my lord, to consider our objections, my lord.
What objections?
Lordship, the petitioners are the, my lord, the shepherds and farmers, my lord. The deputy commissioner, my lord, intends to, my lord, allot 10 acres of land, reserved land, my lord, in favor of the one particular community, my lord. That notification, my lord, we have filed objections. Panchayat has also filed objection.
That order recalled. That order been recalled.
The petitioner is before this court seeking the following prayer. The prayer of the petitioner is to consider their case, consider the representation submitted by them. The representation was against an order that allotted 10 acres of land to a third party. The learned AGA, on instructions and verification of the records, would submit that the order has been recalled. In the light of the recalling of the order, nothing further would survive for consideration in the case at hand. Petition is disposed as having become infructuous, reserving liberty to the petitioner to avail of such remedy as available in law in the event of need. Proceed accordingly.
They are not, they are intended to, my lord, the allot, my lord. For that, we have filed objection. Thereafter, my lord.
Intended to allot.
Allotted. It is allotted, in fact, allotted. Thereafter, it is cancelled.
Please.
Anyway, it's recalled.
Yes, please.
Next.
Seal number 18, Jagadish Patil, Sadanand MK.
Week's time, my lord.
My lord.
See, I received objections yesterday.
What matter?
Yesterday I have
Birth
filed.
certificate. Lord, challenge the order in Lok Adalat.
My lord, I have filed my statement of objections, my lord. Respond numbers.
There is correction of my lord's date of birth.
You become 6 years younger, Attane.
No,
6 years, not me. He become.
Oh, he, correct.
My lord,
I am
Who
the
wants time
institution.
now? Who wants time?
I-
Why?
My lord, he produced the objections, my lord, kindly.
ಅದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಯಾರು?
ಇಲ್ಲ, ಹಾಗಿಲ್ಲ.
What's your problem, sir? He has to justify.
Please.
Why are you seeking time?
My lord, my date of birth has been rectified in the year 1995, my lord. I have produced the document.
95
Annexure-
ಆಗಿದೆಯಾ?
Yes, my lord. Respond, annexure R5,
On
my
what
lord.
basis?
My lord. Annexure R1, my lord.
ನಾವು ನೀವು ಹುಟ್ಟಿರೋದು ಯಾವಾಗ ಸರ್ ಆಕ್ಚುಲಿ?
1/6/1966, my lord.
1/6/1966.
66, my lord.
Where is 10th marks card ಇದೆಯಾ?
No, my lord.
Okay.
My lord, in the year.
10th marks card ಇಲ್ಲಿ.
SLC marks card.
No, my lord. My lord, my date of birth has been rectified in my service records in the year 1995 itself, my lord. It is the allegation of
Where
the
is the
petition.
10th marks? When did you pass out 10th, sir?
I don't have.
ಏನ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ನಿಮ್ದು?
Teacher.
Assistant teacher. Assistant teacher.
ಯಾವ್ದಾದ್ರು ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ ಇಲ್ಲಿ?
There is no certificate. The endorsement issued by the village accountant, my lord, that he has.
My lord, Gram Panchayat, my lord.
Gram
It is the
Panchayat.
allegation of the petitioner that, my lord, I have misused the date of birth issued by the civil judge JMC, my lord, produced as per annexure F1, my lord. That too issued in the year 2017, my lord. But my date of birth has been rectified in service records in the year 1995, my lord. I have used this document.
Did you want time? Actually, to the learned counsel appearing for the petitioner seeks a week's time. List on 17th in the fresh matters list. Yes.
Till number 19, Gayatri, yes, sir?
In the earlier occasion, a direction was issued to the HCGP to secure instruction with regard to the implementation of the tender work, which was already allotted for the lift irrigation in the Kuriganur village, my lords.
Pipeline is already laid down.
Yes.
Yes.
ಯಾವಾಗ ಅದನ್ನ commissioning?
Instructions on 2 days time.
The learned AG seeks time, yet again, list on Friday in the fresh matters list finally.
Great. Interim order, my kind.
Interim order subsisting will continue to the next date.
Number 20, Shivraj S. Balloli, Rashekar Gunjalli.
Yesterday's petition, my lords, yesterday's petition, insofar as, my lords, arrears of salary is concerned. My lords, my learned friend, my lords, government advocate made a submission that arrears have been paid, but I have sought instructions, my lords, it's not paid completely, my lords.
What completely?
No.
Who says?
My lords, the
Employee is
petitioner's,
not there now.
petitioner's wife,
How
wife.
does she know?
My lords, she has secured, my lords, the other employees are also, my lords, they have also secured instructions.
Petition dated, your lordship.
She's saying that, my lords, up to
2024.
the date of the petition, it is paid.
Date of the petition,
Petition till
8 January 2024.
4, please, your lordship. Till date ಅಂತ ಇದೆ. 24 ವರೆಗೂನು you have paid, your lordship.
Thereafter, my lords, she has
ಆಯ್ತು,
still.
ಆಮೇಲೆ
ಅಲ್ಲ, ಆಮೇಲೆ it will pay, your lordship.
ಆಯ್ತು, pay
ಹೋಗಿರುತ್ತೆ.
ಮಾಡ್ತಾರಷ್ಟೇ.
Let
The
there be-
petitioner is before
Bona
this
fide
court
miss,
seeking
your
the following prayer. The learned counsel appearing for the respondent submits that appropriate salary has been paid to the petitioner while, seeks the following prayer. The petitioner is no more today. The learned counsel appearing for the respondent submits that till the date of filing of the petition salary of the petitioner was paid. After the filing of the petition is not paid is what the learned counsel Shivraj Balloli submits on instructions from the
Wife of
the wife of the deceased. The learned counsel, learned AG, HCGP and the counsel for the respondent would undertake that if salary is not paid till the date he passed away, it would be paid within an outer limit of 8 weeks from the date of receipt of the copy of the order. In that light, the petition stands disposed with a direction to the respondent state, to the respondents, to pay salary to pay the arrears of salary from the date of filing of the petition till the date of death of the husband of the petitioner, till the date of death of the petitioner to the wife within an outer limit of 8 weeks.
Please.
If not already paid.
Please.
All other benefits, if the petitioners, if the wife of the petitioner is entitled to the same, it is open for the petitioner to, it's open for the wife of the petitioner to submit such representation or knock at the doors of the appropriate fora.
Please.
Ordered accordingly.
Obliged, great.
12 weeks, man.
12 weeks.
Please.
Salary. Yes.
Obliged, great.
ಅವ್ರಿಗೆ ಸ್ಯಾಲರಿ ಅಂದ್ರೆ ಭಯ ಈಗ.
Till number 21, Shivkumar S. Badwadgi.
But the matter pertains to the JOCs.
Covered against, sir.
ಇಲ್ಲ ಲಾಸ್ಟ್ Last occasion, the state has filed an objection to the effect that petitioners has not completed 5 years. I have secured the document.
5 years complete madidru, no, it is covered by what I've already written.
That's my submission to my lords is, I'm not saying my lords have passed an order. I'm on the point that the very notification, though we are eligible, though we have completed 5 years of service, our cases are not considered.
For regularization.
No.
Absorption.
Absorptions. Now, state has filed an objection to the effect that one petition is short of 15 days, another petition is short of 2 months. Whereas I'm having the attendance sheets and the salary paid to the petition, which goes to show that I have worked for 5 years.
As per my attendance, also I have also filed your lordship along with the
To look into
objections.
the attendance versus attendance and pass orders. The petitioner.
May I pass on the attendance sheets?
Petitioners are before this court seeking the following prayer. The heard so and so. The petitioners were petitioners here, Obrana.
No, there are 2 petitions are there.
Petitioners in both these petitions were appointed as lecturers in their respective subjects on consolidated pay on 21/7/2005 and are said to have been working as on the date of the notification dated 6/4/2011. The petitioners, the state took up the cause of the job-oriented course lecturers for their absorption and issued a notification on 6/4/2011, absorbing several teachers who are working job-oriented courses. On the strength that they have completed 5 years of service as teachers in those courses. In those courses who were working as part-time job-oriented course employees. The petitioners case in both these petitions were not considered for such absorption on the sole score that they had not completed 5 years of service. The learned counsel appearing for the petitioner now seeks to place on record the attendance register, which according to the petitioner depicts that the petitioners have completed more than 5 years of service as on 6/4/2011 and therefore would seek a direction to reconsider the cases of these petitioners. The learned HCGP would vehemently refute the submissions, contending that the petitioners did not possess the requisite years of service as on 6/4/2011, as they were short by 15 days, 1 week, or a month, as the case would be. 15 days and a month, as the case would be. In that light, what is now required to be discerned is attendance versus attendance, one produced by the petitioner, one of the state. Therefore, the state to look into the attendance now placed by the petitioner, compare it with the attendance with the state, and pass necessary orders in accordance with law. It is made clear, except the aforesaid circumstance, nothing else is considered by this court as what is projected by the state was only that circumstance. In the light of the aforesaid, direction, the petition deserves to succeed, albeit in part. Quashed, allowed in part. Quashed. The matter is remitted back to the hands of the state to pass necessary orders, bearing in mind the observations made in the course of the order, with an outer limit of 4 months from the date of receipt of the copy of this order.
May I make to add up one point? Along with attendance also, they have paid the salary for the entire year.
They have already relieved from service, your lordship.
The last one, Barkode. It is open to the petitioner to produce any further document with the state, or for the state to solicit any document from the hands of the petitioners to substantiate their claim for absorption as on the date others were absorbed. Relieve
Yes, that was called in question before in the earlier writ petition. Earlier writ petition came to be allowed and remanded back to the authorities. Yes.
Please.
Order recorded.
Grateful.
Disposed.
Seal number 22, SC Kadakatti, Irangoda ke Kabul.
I'll kindly seek 1 week's time. File additional rejoint.
ಏನ್ ಮ್ಯಾಟರ್?
Additional rejoint, pension matter, my lord.
ಪೆನ್ಷನ್ ಕೊಟ್ಟಿಲ್ವಾ?
Additionally, pension benefits, my lords.
ಪೆನ್ಷನ್ ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
They are ready to pay pension from 27/8 to 2019, my lord. We are seeking from 2017.
AV. Yes.
Seal number 23, Prashant S. Kardevar.
AV at the request of the council appearing for the petition.
For the petitioner, my lords. This is pertaining to, my lord, Grama Sahayaka, my lords.
Your lordship, in this matter, your
Ram
lordship,
Sahayak.
please, your lordship. I'll
Lord,
file affidavit, your lordship. Tahsildar is present, your lordship, because what they have shown is, your lordship, population is there as per the population, and one more post will be created. It is not there, your lordship. Admittedly, post is not vacated.
Create ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ, create ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ.
Lords, in fact, on the other day, my lords, my friend had filed a memo showing, my lords, 3 villages.
ಹೌದು.
In one village, my lords, this respondent, my lords, is appointed as a village assistant. In other 2 villages, my lords, one person is, my lords, managing the 2 villages. In fact, if the population is looked into, more than, my lords, double the population of this particular village.
If population is looked into, your lordship, that
Managing 2 villages.
ಇಲ್ಲ, ವಿಲೇಜ್
ಅಲ್ಲ,
ದಿಸ್ ವಿಲ್
ಕೊಡಿ
ಇದು
ಸ್ವಲ್ಪ.
ಬರೋದು ಸಾಜಾ ಅಂತ ಬರುತ್ತೆ, your lordship.
ಆ ಸಾಚಾನೆ ಅಲ್ಲ ಬಿಡಿ.
Because, your lordship, it
Lord,
comes
one,
from the not from the population, it will
Which
be
are the
count,
2
your
villages
lordship.
managed by one man.
That I have placed memo, your lordship.
That
The
will
name
be-
is not shown,
that
my lord.
will be count,
One
your
Prabhu
lordship.
Bhimappa Talwar is working as a Grama Sahayaka in these 2 villages.
Which village, sir?
Please, lord, along with my memo, my lord, I have produced. In that, my lord,
ಎಲ್ಲಿದೆ?
Hirekoppa and Govinakoppa.
ಹಾ.
For these 2 villages, one person, my lord, Prabhu Bhimappa Talwar is working
ಹಾ.
as Grama Sahayaka, and Anganwadi is concerned, my lord, the dispute is before this honorable court. When, my lord, we sought, my lord, information.
This will be fixed from the survey
Yeah,
numbers,
only
your lordship,
furnished.
not from the population wise, your lordship.
The petitioner has filed a memo with regard to 3 offices where
3 villages.
3
Three villages comes under the same
3
Grama
villages
Panchayat.
in which one Gram Sahayak could be functioning. Insofar as Arishana Gudi is concerned, the dispute is before the court as to whether the petitioner should be permitted to continue or the private respondent. Insofar as Hirekoppa and Kurugovina Koppa, the memo indicates that one person by name, ಯಾರದು?
Prabhu Bhimappa Talwar.
Prabhu Bhimappa Talwar is working at 2 places.
2 places anta baralla, your lordship. That is
ಆಯ್ತು,
one
it is-
circle, your
villages.
lordship.
is working at Hirekoppa and Kurugovinakoppa both.
Yes.
Therefore, the learned council has also placed on record the population of the villages. In terms of the population, 2 Gram Sahayak ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡೋದು ಇವರು?
ಇದು ಅರಿಶಿಣಗುಡಿಯಲ್ಲಿ
Arishinagudi.
ಆಗಿದೆ.
ಅಲ್ಲ, what is that office? The village office in which the Gram Sahayak works cannot be handled by 2 persons, notwithstanding the population being as is appended to the memo. Therefore, ಯಾರು ತಹಸೀಲ್ದಾರ್ ಯಾರಿದು?
Tahsildar is present, your
Who is the
lordship.
competent authority, appointing authority ಯಾರು?
Tahsildar.
The Tahsildar, who is present, is it?
Please, your lordship, I'll file
Tahsildar who
today
is
affidavit
present before
ಹಾಕಂತ
the court
ಹೇಳಿತ್ತು, so I will file.
shall file an affidavit
Please, your lordship.
before this court as to how the said person is permitted to work at 2 places when the fight is between the 2 for a place. Therefore, the affidavit shall be filed by the next date of hearing, list on Monday in the fresh
Please, your
matters.
lordship. Please.
ಈಗ ಕೊಡ್ತಾರೆ. Yes.
Seal number 24, Srinande Pachapure, BS Kamte.
This is with respect to, my lord, the salary of 34 days. They have considered the diazonon period, my lord, during COVID-19.
Anything else? The petitioner
ತಾವು
is before this court.
only thing is, my lord, lordship, my lord, comply the directions issued by my lord. Lord, statutory period, my lord, minus ಮಾಡಿದ ಮೇಲೆ, lord, they are asking, my lord, another, my lord, 34 days, my lord, waiting period, my lord. Apart from 10 days, my lord.
ಈಗ ನೀವು ಯಾವ್ದಕ್ಕೆ ಡೈಸ್ನಾನ್ ಟ್ರೀಟ್ ಮಾಡಿದ್ದೀರಾ ಅದನ್ನ ಕ್ವಾಶ್ ಮಾಡ್ತೀವಿ. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಏನಿಲ್ಲ.
Please.
The petitioner is before this court seeking the following prior heard so and so. The petitioner is an employee of the Hubli, another
KPTCL.
KPTCL. On 5/6/5/2021, one B. Manjunath, Additional Director Commercial, is transferred to the place of the petitioner as Chief Financial Advisor and Director Finance, HESCOM Hubli until further orders. On 7/5/2021, owing to the said transfer, the petitioner hands over charge to the said incumbent Manjunath. On 10/5/2021, the petitioner submits a representation that is unable to report to the place assigned immediately due to the lockdown imposed on owing to owing to the state engulfed with COVID-19 with effect from 10/5/2021. Another representation of the same kind is submitted on 14/6/2021. The corporation on 24/11/2021 gives posting to the petitioner at Bangalore. The petitioner reports to duties on 25/11/2021. The representation of the petitioner is placed before the authorities directing treatment of the said period as compulsory waiting period. An endorsement comes about treating 35 days of the petitioner's absence as dice non, which would be not treating the service for any purpose. The petitioner then submits another representation seeking to consider the 35 days as compulsory waiting period. It is non-consideration of this that has led the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would reiterate the grounds that are urged in the petition seeking quashment of the order of treating 35 days as dice non. The learned counsel would also take this court through a notification issued by the government of Karnataka imposing a lockdown on account of COVID-19 and his disability to travel during the said period. The learned counsel B.S. Kamte, representing the respondent, submits that the act of the petitioner is subversive of discipline. He did not report to the duties of the transferred place immediately, and therefore the order should not be interfered with. He would further submit that the petitioner is seeking the entire period to be a compulsory waiting period apart from the 35 days that is imposed, which should not be granted. I have given, therefore narrated, I have given notification.
Annexure G and G1.
The petitioner is transferred to Bangalore from where?
From Hubli to the head office Bangalore.
Hubli to Bangalore by the notification, which reads as follows. The petitioner hands over charge to the incumbent, but submits 3 representations seeking time to report to duties on account of the lockdown. The lockdown is it is not in dispute that there was a lockdown imposed on 7/5 in terms of an order dated 7/5/2021. It reads as follows. Owing to the inability of the petitioner to report to duties at Bangalore or due to the lockdown, can by no stretch of imagination be imposed upon the petitioner to become a dice non. The order that is passed is
Annexure H, my lord. Page number 41.
The order passed reads as follows. The period of dice non is between 17/5/21 to 20th June 2021. In the light of the notification imposing lockdown and the inability of the petitioner to report to duties, the owing to said lockdown would inure to the benefit of the petitioner, which leads to the obliteration of the impugned order. In the light of the said, for the aforesaid reasons, petition allowed, impugned order stands quashed. The 35 days of dice non.
34 days.
34 days of treatment of dice non be treated as service. As service, the petitioner would be entitled to all consequential benefits that would flow from treating 34 days as service. Yes.
Please.
Ordered accordingly.
Please.
For 25 MS Harvey, Manoj and Disciplinary.
Petitioner.
The connected matter of the petitioner, Your Lordship.
Maintainability of the malad appeal before the competent authority.
Oh, idu.
The respondent have taken the contention malad.
Yes.
It's a case of malad compulsory retirement.
Retirement.
Compulsory retirement is not.
Retirement. As a major punishment, I have imposed him as a punishment for his misconduct, Your Lordship. Entire annexure A series of the complaint received for entire 1 year. He started sending students to market to hold his bag, sleeping in the college classes and not completing the syllabus. For 1 year, I have received the complaint. He put the students' career at the peril. Moreover, my institutions, it was put into peril, Lordship.
ಈಗೇನ್ ಇದು dismiss ಆಗಿದೆಯಾ?
ಇಲ್ಲ, my appeal has been allowed malad. Set
My
aside the
inquiry,
order of compulsory.
I passed an order under
Whose
inquiry.
appeal is allowed?
But I have filed appeal before the malad competent authority challenging the compulsory retirement. That appeal has been allowed malad. Being agreed by the said appeal, they have filed revision before the government. That is also dismissed malad. Now malad,
ಏನಾಗಿದೆ?
now the malad from the date of malad compulsory retirement till the date of my superannuation. But I am entitled for the salary malad. You know of the setting aside of that punishment order.
He is seeking arrears back wages of the entire.
ಅಷ್ಟೇನಾ ನಿಮ್ದು?
ಅಷ್ಟೇ ನಮ್ಮ
ನಿಮ್ದೇನು?
Your Lordship, my contention is the very inquiry, the jurisdiction itself has preferred wrong appeal before the jurisdiction, that is 94(5). He ought to have preferred before the EAT tribunal, Your Lordship.
All right, have you taken this contention there?
Yes, Your Lordship, I have taken the contention.
Initially, my lord,
Initially in 90, before the competent authority, I have taken the contention with regard to jurisdiction. Moreover, there he challenged that order after 4 years, lapse of 4 years. And he has not filed an IA for limitation, condonation of delay also, Lordship.
My grievance is malad. Initially, they have taken contention
Back
before.
wages ಮಾತ್ರ ಬೇಕಾ?
Salary malad. From the date of malad compulsory retirement till the date of 1.5 years, malad, in view of the setting aside of the compulsory retirement.
No work, no pay.
They have malad prevented me from working malad by issuing the penalty order malad.
I will reason it out, no problem. No work, no pay.
In fact, when
That service at best, we will direct them to take it as.
But it is aided institution malad.
They aided. We will direct it to be taken as for the purpose of terminal benefits.
But they have
No salary at all.
But up to the date of malad
Will
compulsory.
not give you any bonanzas.
Up to the date of compulsory retirement, my pensionary benefits have been settled malad.
Settled?
That from the till the malad from the from the date of malad compulsory retirement, my thereafter malad is in view of the dismissal of that.
Not going to the jurisdictional aspect. I will only say.
So far jurisdiction is concerned malad.
I am not going to enter into that. We will say that you are not entitled to arrears of salary on the principle of no work, no pay. The said service shall be considered for terminal benefits. That's all.
We have provided, Your Lordship. In fact, he had initiated contempt to initiate.
Compulsory retirement ಕೊಟ್ಟಿದ್ದೀರಾ?
In fact, he had initiated contempt, Your Lordship. That was also dropped.
1 minute. Compulsory retirement orders are set aside.
Set aside.
That you have challenged.
Yes.
Now that in view of the retirement, we will not grant any order.
Yes.
Will not pass any order with regard to arrears of salary. But that period you treat it as
Your Lordship,
the purpose of terminal benefits.
It is aided institution. Let them pay and reimburse from the government malad. It is aided institution.
Public money, sir.
Malad, by virtue of the malad punishment order, I am successfully prevented from working malad. That order has been set aside malad. Therefore, malad, I am entitled for salary.
Your Lordship, with regard to terminal benefits, he already received, Your Lordship, from the date of his retirement, compulsory retirement.
Only 1.5 years salary malad.
Have you challenged it only on jurisdiction or merit?
On merit also, Your Lordship. With regard to delay also, 4 years latches is there, Your Lordship.
Yes, sir. ಏನು allegation ಇವ್ರ ಮೇಲೆ?
Only allegation is malad.
First
The
allegation
petitioner has not completed the syllabus of the 8th and 9th standard for the academic year 2014 and 15.
Annexure.
For in that year malad, the 100% result in the malad 8th and 9th standard malad. That is only the allegation malad.
I will call it. Will give a quietus to the issue.
Please.
By directing terminal benefits ಮಾತ್ರ calculate ಮಾಡಿ.
So for counting of malad.
ಅಂದ್ರೆ ಮತ್ತೆ arrears of salary ಅಂದ್ರೆ then you will have to pay.
Yes, Your Lordship. That's the rule that has been.
ಅದಕ್ಕೆ terminal benefits.
Government.
But
We'll send a proposal to government. We'll send that proposal to government.
The petitioner in both these cases arise out of a solitary order passed by orders of the government under section 130 and 131 of the Karnataka Education Act 1983, hereinafter referred to as the Act for short. The petitioner in writ petition 104174 of 2024 is the employee/teacher who is seeking arrears of salary from the date on which his compulsory retirement till the date of his retirement on attaining the age of superannuation, which would be between 3/11/2016 to 31/5/2018, which is close to 18 months. The companion petition challenges the very order passed by the government under section 130 and 131 of the Education Act, contending that the petitioner was imposed a penalty of compulsory retirement. The appeal could not have been filed before the government, but it had to be preferred under section 94 before the Education Appellate Tribunal in terms of appellate tribunal. He would also seek to place reliance upon several judgments. The issue now is the petitioner has retired from service. He is armed with two orders passed by the government on invoking the government under section 130 and 131 of the Act. The respondents, the petitioner in the companion petition had projected the ground that the appeal before the government was not entertainable in the light of the remedy being available under section 94 of the Act. Notwithstanding the same, the government under section 130 entertains the appeal and passes the order. The management again challenges the said order before the revisional authority under section 131 and fails. Therefore, both the petitioner and the management are before the court, one seeking arrears of salary, the other seeking quashment of the orders passed by the concerned authorities. As observed herein above, the petitioner has attained the age of superannuation in the year 2018, and the allegations against the petitioner relate to the year 2015 and 16, which is now 10 years ago. Therefore, now sending the matter back to the tribunal for adjudication altogether, for a fresh adjudication, would neither be in the interest of the management nor the employee. Therefore, in the light of the retirement of the petitioner and 10 years being passed by, without entering into the merit of the jurisdictional issue as projected by the respondent, I deem it appropriate to give a quietus to the issue. The claim of the petitioner employee is that he should get arrears of salary from the date on which he was compulsorily retired on 3/11/2016, and the date on which he would superannuate on 31/5/2018. The salary to the said period cannot be granted on the score that the petitioner has not worked. On the principle of no work, no pay, the salary of the petitioner would not be available. Notwithstanding the fact that the orders of compulsory retirement have now been set aside, and those orders did not grant back wages to the petitioner. However, the petitioner, having attained the age of superannuation on 31/5/2018, the terminal benefits of the petitioner have all been settled up to the date of compulsory retirement, i.e. 3/11/2016. What remains to be settled is for 18 months. Those 18 months, the petitioner would not be entitled to any salary, but the set period is to be calculated for the purpose of grant of terminal benefits of any kind. Therefore, the respondent institution shall now submit a proposal to the state for recalculation of the terminal benefits, including the period up to 31/5/2018, the date on which he attains the age of superannuation, and pay the petitioner accordingly within an outer limit of 4 months from the date of receipt of the copy of the order. It is again made clear that the petitioner is not entitled to any arrears of salary between 3/11/2016 to 31/5/2018. Ordered accordingly.
Obliged.
Number 26, Charana Basavaraj CM.
26, my lords, I beg to appear for my lords petitioners counsel in serial number 26, my lords.
Yes, sir.
Am I audible to your lords now?
Yes, sir. Government.
Yes. Lords, the petitioners are all, my lord, working in the agricultural department as my lord.
Have been engaged.
You have been engaged. By senior. All right. So, yes, sir.
But may make a
Lords,
submission.
we are
Notification,
seeking,
KPSC,
Lord, we are working in the agriculture department, Lord, for various periods, starting from Lord 2011 and Lord up to 2022 also. And we are working in a scheme called Atma scheme, Lord, and are fully qualified for appointment as assistant agricultural officers or agricultural officers in the agriculture department, in which they are presently working. And Lords, the state has been Lord regularizing the services or Lord providing some age relaxation or absorption. All these processes Lord have been extended from time to time in respect of Lord the post of assistant agricultural officer and agricultural officer, Lord, agriculture officer. And we are also seeking same Lord treatment since we are working for Lord up to 15 years period by now. And we have approached this honorable court on several occasions. And Lord, this honorable court has issued directions Lord, in 2023, 24, and so on. And there is a direction to consider our case for regularization or Lord absorption or for relaxation or reservation. Nothing is being done by the state, and Lord, the agricultural commissioner for agriculture issues an endorsement with the annexure W stating that it cannot be considered. Before that, can I request my lords to kindly take annexure yes, my lords. Annexure
189.
yes. My lords, page number 189 it starts. Can I request my lords to kindly come to page number 218? Para number 14, my lords. The only right that the petitioners can claim is for regularization of their services on account of long service rendered by them from the year 2012.
Which is the endorsement?
Page
Page
275,
Annexure W, Your Lordship.
annexure W. So during,
What is the endorsement? ಅವ್ರು ಇರ್ತಾರೆ ಅಂತ ನೀವು ಓದಿಲ್ವಾ?
In your lordship, according to the procedure, notification is called for, wherein your lordship contact, appointment has been given. With due procedure law has been followed, and also your lordship subsequently, the contact has been taken place between the contract employees and the your lordship government, wherein same clause has been followed, as well as we were sent for the election, your lordship. All the same duties, your lordship, done by the other government employees.
Are you project employees?
project.
Project employees.
Interim dated note 31/8/2024, interim order. Interim order.
31/8?
31/8/24, in the, not
In
interim order.
IA4 direction, we have filed your
In the
lordship.
meanwhile, the respondent initiated any recruitment process, the petitioner would be liberty to participate
The
in the,
interim order, leave it.
not they have participate, the keep.
This is Suraj or order ತೋರಿಸಿದ್ರಲ್ಲ ಏನದು? This is Ranjita.
Wherein your lordship,
Suraj or order ಏನು?
we have made a representation, your lordship.
ಅಲ್ಲ,
That
ಅದು
has been-
same petitioners ಆ?
Same petitioners, your lordship. This second round of
ಯಾವ
litigation.
interim order?
Not interim.
My lords,
Subsequently.
am I audible now?
Pendants of the-
Second petition ಇದು.
But
Am I
here,
audible?
notification was issued by the KPSC, that they have made a statement that they are took a part in the recruitment process. But according to their application filed with the interim application, they have stated that they have took a part in, they have submitted the application, took a part in the selection process. Selection process is dated 29/2024, after interim order.
ಈ
KPSC has
selection ಅಲ್ಲ, how were they appointed?
not a scheme, particular scheme not introduced by the central government.
Scheme is still in subsistence?
Scheme government.
Yes,
Yes,
yes, it is on, my lord. Scheme is on.
State
Central
government.
government scheme, sir.
ಇಲ್ಲ, state government. State government. Recruitment process is.
If you are Ranjita, if you have been appointed to a particular project and the project is over and your service is coterminous with the project. Kashta.
They are still working, your lordship. Subsequently, they are issued one more notification in 2024. By virtue of this petition, your lordship, with the permission, we have participated and we are
They have
continued.
They have
They
participated.
have been selected under the new
That is,
notification
that is
also.
what the interim order is.
Am I audible to your
Result not
lordship's lord? Am I audible to your lordship's lord?
Ah,
If I am audible to your lordship's lord, what we are
you were
claiming
not
is,
till now, sir. Yes.
beg your lordship's pardon, my lord.
Yes, yes, sir. Tell me.
My lords, the scheme apart, our request is, my lord, that we are qualified for appointment as agricultural officers or, my lord, assistant agricultural officers. Whenever recruitment process takes place, our cases should be considered for appointment in the post of, my lord, the agricultural officers or AAOs. And, my lord, in that direction, my lord, we have been, my lord, approaching this honorable court. My lord, scheme is different and, my lord, we are continuing in the scheme, but the benefits that we are getting in the scheme are only very limited, in the sense there are no promotional avenues and, my lord, there is no pay scale, time scale is not being paid to us. And, my lord, we are also qualified, being, my lord, agricultural graduates and agricultural, my lord, postgraduates. That is how, my lord, this honorable court has, my lord, directed the authorities to consider our case for regularization. We are also requesting that we must be given a certain quota in the selection process. In fact, my lord, the central government had appointed a committee to study, my lord, this scheme itself, and it has given a report, video annexure L. Can I for a minute request, my lord, to kindly take page number 132? It is, my lord, the committee which says that our services should be regularized, or we must be given, my lord, the preference in the selection process on whenever, my lord, regular selections take place. This is the report, page number, your lordship may kindly take page number 143.
Objections hakidira?
Objections hakilla. In the meanwhile, what has happened is, my lord, this honorable court permitted us to participate in the selection process. We have applied. They say that you will not consider your application because some of us are age bodies, what they are saying. My lord, when there is a direction of this honorable court, my lord, allowing us to participate in the process, they cannot, my lord, refuse to, my lord, consider our applications. Our request in the IA is to reserve certain posts in favor of, my lord, the petitioners, my lord. That's all. The process of selection is, my lord, put on hold as of now.
Objections hakidira?
Please.
Hakilwa?
Hakil.
Hakbekala.
Please.
Heard the learned senior counsel Basaraj Shabrad appearing for the petitioner along with Ranjita and so on. The issue is with regard to regularization of these petitioners. The petitioners are said to have participated in the selection process which took place during the subsistence of the subject petition and are continued in service. Therefore, the claim is that the petitioner's services ought to be regularized by the respondents as they are fully qualified to hold the post, and their entry is in accordance with the judgment of the apex court in the case of Uma Devi, 2006, 4 SCC, page 1. The learned counsel appearing for the respondent state and Shuraj Mudol, but KPSC, appearing for the KPSC would in unison contend that these petitioners are appointed, these petitioners though come through the KPSC, these petitioners are appointed under a scheme of the Government of India which is to be implemented and executed by the Government of Karnataka. The scheme, therefore appointment of these petitioners were coterminous with the scheme. The learned counsel for the petitioner submits a scheme is still in subsistence and the petitioners are therefore continued under the scheme. The objections in the peculiar facts of this case would be necessary by the respondents. In that light, objections, if any, by the 9th of January 2026.
My lord, I have a request, my lord. They have initiated this process of, my lord, recruitment. We have applied. Let them, my lord, not fill up, my lord, the post, my lord, equivalent to the number of petitioners before your lordship, my lord. Let them not fill up.
In the event the respondents seek to fill up the post that the petitioners are working, the petitioners are at liberty to move the matter Yes, next.
Please.
Number 27, Madan Gowda and party.
Next to appear for petition in this case, Your Lordship. A matter pertaining to pension, Your Lordship, last from 1.5 years, more the pension has not been settled, Your Lordship.
Your Lordship, in this matter, cost has been
Your Lordship,
imposed. Your
order, my
Lordship.
Lord, dated 19
Recalling
February
that
2020.
order, Your Lordship.
1,000
As Your
rupees per
Lordship,
day.
please, Your Lordship.
ಕೊಟ್ಟಿಲ್ವಾ
that-
ಇನ್ನು?
ಇಲ್ಲ.
ಇನ್ನು
Actually, Your Lordship, in this petition, the prayer itself is infructuous. Already they have moved the application and we have also sent the.
What application, madam?
For arrears, Your Lordship, salary, Your Lordship.
ಹಾ.
ಅದನ್ನ ಕಳ್ಸಿದ್ದೀವಿ.
Salary ನಾ
We have-
pension ಇದು?
Pension, sir.
Pension.
ನಾನು order ನೋಡಿದ್ದೀರಾ madam?
Please, Your Lordship. Pension.
He retired 8 months ago.
Please, Your Lordship.
ಅದೇ
And
ಯಾವಾಗ
it is
pension
sent,
ಕೊಡ್ತಾರೆ?
Your Lordship.
Huh?
But what is my contention, Your Lordship, if order is passed by saying that if within a time frame, Your Lordship, it is not paid, then it may be imposed.
ಇಲ್ಲ ಈಗಾಗಲೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಅದಕ್ಕೆ recalling.
50,000 ಅವ್ರಿಗೆ ಅದನ್ನ recall ಮಾಡಲ್ಲ. ಇವ್ರು ಕಳ್ಸಿದೀನಿ ಅಂದ್ರಲ್ಲ ನೀವು?
ಹೌದು ಸ್ವಾಮಿ.
ಅವ್ರು
ಯಾವತ್ತು
ಕಳ್ಸಿದ್ದಾರೆ.
ಕಳ್ಸಿದ್ದೀರಾ?
My lord, I was, my lord, he has signed the papers on 4/12/2000.
This court on 17/1/2025 had passed the following order. A direction was issued to the respondent educational institution to forthwith furnish the papers to process the pension of the petitioner. The learned counsel appearing for the institution submits that the papers were processed and after the signature of the petitioner on 4/12/2025, immediately thereafter.
24, my lord. 4/12/20.
4/12/2024 and immediately thereafter. Therefore, the papers were at the hands of the state. The state has not yet processed pension and not paid to the petitioner. Therefore, this court on 19/2/2025 had passed the following order.
Your Lordship, one
The order
submission.
was on 19/2/2025. Even today,
And
pension has not been paid to the petitioner. The,
Your Lordship, it is paid, Your Lordship.
when,
ಆಗಿದೆ. I will
ಯಾವಾಗ?
file, Your Lordship. The document ಬಂದಿದೆ. But file is not there, Your Lordship. ನಾನು ಹಾಕ್ತೀನಿ. ಮೆಮೊ ಹಾಕ್ತೀನಿ. Password, Your Lordship. It is already paid.
the learned counsel, ಕೊಟ್ಟಿದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ,
And it
ಕೊಟ್ಟಿಲ್ಲ
was
ಸ್ವಾಮಿ.
not submitted. ಕೊಟ್ಟಿದ್ದಾರೆ.
The
I have
learned
information.
counsel, learned HCGP submits that the pension has been paid to the
Paid,
petitioner and would seek to
I have-
place those documents on record. In the same breath, the learned HCGP seeks recall of the order imposing costs. The said order would be considered to be recalled after the document is placed of payment of pension.
Actually, same cost is to be imposed them, Your Lordship, petitioner, Your Lordship, because we have already paid, which is not submitted by the petitioner.
ಆಯ್ತು ಕೊಡಿ, ರಿವರ್ಸ್ ಕಾಸ್ಟ್ ಹಾಕೋಣ ಕೊಡಿ.
Please, Your Lordship.
Yes.
ಇದರಲ್ಲಿ I have filed application for recalling that.
ನಿಮ್ದು 50,000
ಹೌದು sir.
ಅವತ್ತು ಮಾಡುವ. ಎಲ್ಲ ಪೆನ್ಷನ್ ಬಂದ್ಬಿಡ್ಲಿ.
ಬಂದಿದೆ.
We'll take off all these words later.
Please.
Yes.
Day.
List on, ಯಾವತ್ತು ಬೇಕು? Monday?
Please, Your Lordship.
15th fresh matters.
Please.
Seal number
We
28.
have paid, Your Lordship. Cost is to be paid to the petitioner.
ಅದು ಸುಳ್ಳು ಹೇಳಿದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ಕಾಸ್ಟ್.
Please, Your Lordship.
Petitioner ಮೇಲೆ
It is
impose
paid,
ಮಾಡಿ.
Your Lordship. I have.
All
on
right.
it.
Seal number 28, party,
My
Manoj.
lord, for
and
the
Vikram.
petitioner, my lord. My lord, two issues in this writ petition, my lord. One is with respect to, my lord, the seniority, my lord, for the post of headmaster.
Headmaster?
ಹೌದು.
Yes.
And the second issue is, my lord, now the petitioner has retired, my lord. In July 2024, her pension has not been fixed.
In fact, we have sent the proposal. In fact, we had sent a letter.
Proposal ಯಾರಿಗೆ sir?
ಅಲ್ಲ, we have sent a letter to submit her document. She is not coming forth to ಮಾಡಿಲ್ಲ, ಮಾಡಾಕ್ತಿಲ್ಲ.
ಯಾಕೆ ಎಲ್ಲರೂ ಮಾಡಲ್ಲ ನೀವು?
ಅಲ್ಲ,
ಈಗೂ ಅಷ್ಟೊಂದ ಅಥವಾ ಬೇರೆ ದುಡ್ಡು ಇದೆಯಾ ಆರಾಮಾಗಿ?
ಅಲ್ಲ, she is seeking the pension as per the seniority list.
Lord, insofar as seniority, may I just show page 40, my lord. Page 40, my lord. That is,
You take this without prejudice to your rights, sir.
my lord, we are agreeable, but
ಅದನ್ನ we
because
are
of
ready to give her
The
pension.
petitioner is before this court on twin projections. One, that the senior petitioner is entitled to a particular seniority. And now that the petitioner has attained the age of superannuation, is claiming pension. The learned counsel appearing for the institution submits that the documents are not being signed by the petitioner on the score that she wants the seniority pension in accordance with the seniority, which is yet to be determined by this court. In that light, without prejudice to her rights in the subject petition and determination of seniority, the petitioner shall sign the documents and receive the pension that is to be, that would be paid, which shall however remain subject to the result of the petition.
Yes.
Ordered according, list after vacation.
Obliged.
Yes, next.
Seal number 29, Shashank S. Hegde.
Appearing for the petitioner in this matter, my lord.
This is regarding appointment of
Appointment of
sole
arbitrator.
arbitrator, my lords.
Ah.
Requires some more time, my lords.
Yeah,
Kindly
yeah,
next.
My lord, they
Some
had
more
to
time,
suggest the name for appointment. That's all.
List tomorrow, finally, in the event,
Time.
in the event no answer would come about by the state, this court would appoint an arbitrator. Yes, next.
Kindly
Much
weeks,
obliged.
at least weeks time,
Tomorrow,
because of the ongoing session. my lords.
nothing,
Kindly
nothing. ಏನಿದು? ಒಂದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಷ್ಟೊತ್ತು. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Seal number 30,
ನಿಮ್ಗೆ ಯಾರು ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ? ಯಾರು ಬೇಕು ಅಂತ?
Approval has to be come from the government, my lords.
No problem. I will pass an order. Yes.
30. So regarding the recurring, Shashank S.
Petition, my lords. Challenging, my lord, the interdivision transfer in KSRTC, my lord, petitioner is a class 4 employee.
Influences because he has in the
Reported
month,
ಅಲ್ಲ?
he reported in the month of May itself.
Two submissions. My lord, on previous occasion, I submitted, my lord, that his subsequent, my lord, joining, my lord, to the transfer post is been made subject to the result of this writ petition. My lord, now I'm challenging the very validity of the transfer order. The lordship may kindly come to Inquiry 61, my lord, wherein, my lord, C&R rules give some protection, my lord, to the class 4 employees, my lord, in case of the, if he's
Class 4 employee. Yeah.
class 4 employee, my lords.
For the last 15 years, my lords, he has worked at one
My
particular
lord, the
place. Now, my lords, we have transferred him.
number of years
ಅದು
is
ಬಹಳ
sort of-
ದೂರ ಅಲ್ಲ, from my lords ಬೆಳಗಾಂ division to my lords ಖಾನಾಪುರ division, ಖಾನಾಪುರ ಡಿಪೋ. ಚಿಕ್ಕೋಡಿಯಿಂದ ಬೆಳಗಾಂ, my lords. After my lords.
40 ಕಿಲೋಮೀಟರ್.
Illa. My lord, the distance is like this. Now currently he's working, my lord, prior to the order of transfer, he was, my lord, working in Athani depot, which was at a distance of 45, my lord, 50 kilometers.
ಆಯ್ತು, ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದೆ ಅತನಿಲಿ?
My lord,
ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದೆ?
from 2012, my lord, I'm working in Athani depot.
Ah.
My lord, now, my lord, I've been now transferred to Khanapur depot, which is at a distance of 240 kilometers. That will seriously cost, my lord, the financial, my lord, my lord, my.
ಏನು ಮನೆ ಪಕ್ಕ ಇರ್ಬೇಕು ಡಿಪೋ?
My lord, if your lordship may kindly peruse his judgment.
ಕೊಡಿ
My lord, the object, my lord, the word used is sparingly, my lord, in administrative agencies. They have not stated what are the reasons, my lord, for which I have been transferred, my lord, to the Khanapur depot. My lords, ink page 703, my lords, the middle portion, second page.
ನಿಮ್ ಗೈಡ್ಲೈನ್ಸ್ ಏನಿದೆ ಸರ್? ನೀವು ಗೈಡ್ಲೈನ್ಸ್ ಪ್ರಕಾರ
Guidelines illa, my lords.
Lords, as far as this is an administrative transfer.
ಎಲ್ಲಾನು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರಾನ್ಸ್ಫರ್. Don't term it as administrative. Now, what is the guideline that governs this kind of employees?
There are no guidelines. Only the thing is, my lord, the C&R rules, my lord, rule 13, my lords. Wherein, my lord, they have stated that generally they cannot be transferred on administrative grounds, only on exceptional circumstance.
That is arbitrary, sir. That you will use that as and when, as and how you want. What guidelines have you framed?
But that, my lords, tomorrow, my lords,
Guidelines ಇರ್ಬೇಕು ನೋಡಿ.
Ink page 61, my lords, your lordship may
No,
kindly.
there are some guidelines with the case. KSRTC guidelines ಇಲ್ವಾ?
my lords, as far as my lords, my instructions, my lords, that
You operate only under regulation 13, is it?
ಇಲ್ಲ, there are, my lords.
Oh, no, guidelines.
I have it tomorrow, my lords.
Your officer is not here.
Yeah.
Guidelines ಮಾಡಿಲ್ವಾ?
Transfer guidelines.
ಗೈಡ್ಲೈನ್ಸ್ ಮಾಡಿದಿರಲ್ವಾ? ಈ ಗ್ರೂಪ್ ಡಿ ಏನ್ ಮಾಡಿದೀರಾ?
Group D office ಎಲ್ಲ same guidelines.
ಎಲ್ಲ ಸೇಮ್ ಅಲ್ವಾ? ಎಷ್ಟು ವರ್ಷ ಮಿನಿಮಮ್ ಟೆನ್ಯೂರ್?
Minimum 3 years. 3 years.
ಆಯ್ತು, ನಿಮ್ ಪ್ರಶಾಂತ್ ಉಸ್ಮಾನಿಗೆ ಹೇಳಿ. I'll take
Same
it on
lords, he has been
Friday.
working for the last
That will
instructions 15
consider,
years, please.
but I need to see some guidelines,
Please.
because
I'll furnish.
obviously under the statute you can't operate. You
Okay.
should have some guidelines to execute the statute.
Please, I'll furnish tomorrow.
Obligation.
ನಾಳೆ ಆಗುತ್ತಾ? ನಾಡಿದ್ದು ತಗೊಳ್ಳ?
Tomorrow, I'll produce.
Yes, tomorrow.
Obligation.
Number 31, PG Chikkanargun, Chetana Beeraj.
Recruitment endorsement attacks at zero lordships. Where not the second respondent declined to consider the application for appointment on compensate ground, your lordships.
Compassionate.
Please, your lordships.
In the last occasion, Lordship, the government had filed objections.
File objections. Your
Complete
Lordship.
service particulars.
Yeah, 2001 itself, Your Lordship, D group employees appointment was closed, Your Lordship. Crash ಆಗಿದೆ.
8 ಇಂದ.
ಅಲ್ಲ,
One ಅಲ್ಲ.
please, Your Lordship.
In fact, the appointment of them, not the husband of the person, was added post, your lordships.
So what?
ಅವ್ರದ್ದೇನ್ ಹೇಳ್ತಾರೆ, 2001 ಇಂದ those are vacant, treated as permanently added post ಅಂತ ಹೇಳ್ತಾರೆ. But not the husband of the petitioner post is not added post, your lordships.
Our SDC and he was joined as earlier he was joined in the JOC, Your Lordship. Subsequently SDC in SDC ಅಂತ
ಈಗ
ತಗೊಂಡು,
date of
now
death-
she is
Date of
seeking,
death
your
ಏನು
lordship,
madam?
2015, your lordship.
2/3/2000.
Application ಯಾವತ್ತು? Compassion appointment.
Application madam lord the 30/10/2019.
ಒಂದ್ ವರ್ಷದೊಳಗೆ ಕೊಟ್ಟಿದಾರಲ್ಲ?
ಒಂದು ವರ್ಷ ಕೊಟ್ಟಿದ್ದೇವೆ, ಹೌದು.
ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಈಗ?
ಹೌದು, ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಓ, ಆಗ್ಲೇ ಒಂದ್ಸರಿ ಬಂದಿದ್ರ ಇಲ್ಲಿ?
Last date my learned friend has passed down the government order. In the government order, not the husband of the petitioner post is not one time has been not the aided not. May I read on your-
ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಯಾವುದು?
Last date not the.
ಮೇಡಮ್?
In that not the.
Right, passed.
May I read your lordships?
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್. ಯಾವ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್?
May I
ಓದಿ.
Please.
ಯಾರು ಕೊಟ್ಟು? ನೀವು ಕೊಟ್ಟು?
Please, your lordship.
ಇದಾ?
Please, your lordship. The same.
In that not the preamble ಅಲ್ಲಿ ದಿನಾಂಕ 1/3/2001 ಖಾಲಿ ಇದ್ದ ಹಾಗೂ ನಂತರ ಖಾಲಿಯಾಗುವ ಎಲ್ಲಾ ಬೋಧಕೇತರ ಹುದ್ದೆಗಳು ಶಾಶ್ವತವಾಗಿ ಅನುದಾನ ರಹಿತವೆಂದು ಪರಿಗಣಿಸಿರುವುದರಿಂದ 366 ಬೋಧಕೇತರ ಹುದ್ದೆಗಳನ್ನು ಒಂದು ಬಾರಿಗೆ ಅನುದಾನ ಸಹಿತವೆಂದು ಪರಿಗಣಿಸಿ.
ಅದು ನೋಡಿದೆ, that is there. So
Oh,
they
last
have
time
been
ತಾವು-
treated as aided post as a one-time measure.
One time.
So he dies in an aided post. Entitlement.
No, your lordship, they are not, she is not entitled for group D, your lordship. Now she was appointed for the group D.
SDA na group D na?
SDA, your lordship.
SDA group D na?
ಇಲ್ಲ.
Group C.
But now, as per the qualification and
ಇಲ್ಲ,
the.
qualification ಬಿಡಿ, SDA group D na?
ಇಲ್ಲ.
Appointed as SDA ತಾನೆ?
No, first he was in JOC, your lordship. Subsequently he was.
ಅವರು ಹೋದಾಗ ಯಾವ ಕೇಡ್ರಲ್ಲಿ ಇದ್ರು ಮೇಡಮ್?
SDA.
SDA. Please, your lordship.
Anything else?
But your lordship, as I have filed my objections also, your lordship, where in para 19 of the objections, your lordship, as per rule 8(2) of the vacancies, non-teaching staff ಗೆ close ಆಗ್ಬಿಟ್ಟಿದೆ in the year 2001 itself, your lordship.
Non-teaching staff compassionate appointment
ಇಲ್ಲ.
ಇಲ್ಲ. ಯಾವಾಗ? 2001 ಅಲ್ಲ?
Please, your lordship.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್. ಎಂಡೋರ್ಸ್ಮೆಂಟ್
ಎಲ್ಲಿ?
R4, your lordship.
ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇದೆ.
R4, your lordship.
(2003).
Please.
ಎಲ್ಲಿದೆ ಮೇಡಮ್? Which clause?
Uh, 8(2), page number 37, your lordship. Vacant and unapproved posts of non-teaching staff as on
Page
137, your lordship.
Hmm.
Grant in aid 8, your lordship.
Ah.
Next, clause 2.
Vacant and unapproved posts of non-teaching staff
non-teaching
as on
staff
1/3/2001.
shall be permanently unaided.
Hmm.
If at all there are any vacancies in the non-teaching post which is arises after 2001 on account of retirement, resignation, removal, dismissal and death are to remain permanently unaided. Such vacancies will be, which are unaided shall be filled by the management and the salary and other allowances
One
shall be
moment,
paid.
madam. ಅದು ಒನ್ ಟೈಮ್ ಮೆಷರ್ ಅಂತ ಮಾಡಿದ್ ಯಾವ ಆರ್ಡರ್ಲಿ?
2015 your lordships. 2015 your lordships. 31/8/2015 ಅಲ್ಲಿ ಮಾಡಿದ್ರು.
Special measure that was, it's a special measure that was made to, in order to occupy them.
Why did you make? ನಿಮ್ದೇ ರೂಲ್ ತಾನೆ?
Please, your lordship.
Why did you make?
But as it is already,
As
it
it
is
is
the
in where?
management, your lordship, who is,
Forget
who
it.
has to.
There was a rule that said permanently unaided ಆಗಿರ್ಬೇಕು ಅಂತ. ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿದೀರಾ ಇಲ್ಲಿ? 1/3/2001 ಇಂದ ಖಾಲಿ ಇರೋ ಹುದ್ದೆ so and so ಅವ್ರಿಗೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದೀವಿ. ಹೌದಾ?
Please, your lordship.
As simple as that. The petitioner is before this court seeking the following prayer. heard so and so. The petitioner is the widow of one Sanjay Halagekar, who at the relevant point in time was appointed as a part-time teacher.
ಇಲ್ಲ ನಾನ್ ಟೀಚಿಂಗ್
ಅಲ್ಲೇ JOC ವರ್ಕ್ ಟೀಚರ್ ಮಾಡಿದ್ರು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ವಾಸ್ ಮಾಡಿ
Part-time teacher as
In JOC.
a part-time teacher in a job-oriented course on 36/1995. Subsequently, the petitioner was asked to work as second division assistant. The petitioner continued to work as second division assistant in the which institution?
third respondent
In the third respondent institution, and dies in harness on 15/3/2019. Immediately thereafter, the petitioner submits a representation seeking appointment on compassionate grounds on 30/10/2019. The said representation did not merit consideration. Therefore, the petitioner was before this court in writ petition 105-198 of 2021. The said writ petition comes to be disposed directing consideration of the representation, which leads to the impugned endorsement. The impugned endorsement is on, impugned endorsement of rejection of the claim of the petitioner is on two counts. One, the post that the petitioner held was a Group D post, and for a Group D post, it is to remain permanently unaided in terms of a government order notified in the year 2003. In terms of a notification dated 2003, the learned counsel, 2003, the learned counsel for the petitioner would submit that notwithstanding the said notification upon which the impugned order relies on, the petitioners as a one-time measure, the husband of the petitioner as a one-time measure has been considered to be bought under the ambit of aid. At the time of death of the husband of the petitioner, he was working in an aided post as a second division assistant. The learned counsel submits that he is not a Group D employee. The learned HCGP would, however, refute the submission, again placing reliance upon the notification of the year 2003, which bars all appointments, which bars considering the Group D employees from 1/3/2001 to be to come under the aid. Therefore, would submit, if the petitioner is not an aided employee, the husband of the petitioner, if is not an aided employee, the petitioner cannot claim appointment on compassionate grounds.
Your Lordship, the same order, Your Lordship, at page number 9, wherein it was stated, Your Lordship, ಮೇಲೆ ತಿಳಿಸಿರುವ ಅಭ್ಯರ್ಥಿಗಳು ವಯೋನಿವೃತ್ತಿ ಹೊಂದುವುದರಿಂದ ಅಥವಾ ಇನ್ನಾವುದೇ ಕಾರಣದಿಂದ ಸದರಿ ಹುದ್ದೆಗಳು ಖಾಲಿಯಾದಲ್ಲಿ ಅಂತ ಹುದ್ದೆಗಳನ್ನು ಶಾಶ್ವತ ಅನುದಾನ ರಹಿತವೆಂದು ಪರಿಗಣಿಸತಕ್ಕದ್ದು ಅಂತ.
ಅದು Group D.
Please, for non-teaching staff.
SDA also.
For all non-teaching staff.
Please.
That was the condition imposed.
Not, he was not the after retirement, it has been.
The aided aided post.
Aided post.
Aided post.
Difficult.
As a one-time measure, in order to close the JOC, they were given this post with the condition imposing that it shall not be treated as.
The petitioner.
Next post after retirement, no, it has to be treated as a permanent unaided post. No, it is not he is doing the service, he died, Your Lordship. Next post after the retirement, it has to be treated.
Retirement or death anta irado. Very retirement adre I would have granted you so. The learned counsel, learned HCGP would further take this court through the order that gives the right to this to the husband of the petitioner to be treated as a permanent employee, to contend to submit that after the retirement or death of the incumbent who has been treated as a permanent as an aided post as a one-time measure, the post would revert back to become unaided permanently. I have given my anxious consideration submissions made by source. The afore narrated facts are not in dispute. The petitioner, husband of the petitioner, was appointed as a job-oriented course teacher on 36/1995 and is later working as a second division assistant in the institution. the petitioner dies, the husband of the petitioner dies in harness on 30/10/2019, sorry, on 15/3/2019. Immediately thereafter, a representation is submitted to seeking appointment on compassionate grounds. This is turned down after an order passed by this court by the following endorsement. Page 31. The endorsement is on twin score that the appointment of the husband of the petitioner was as a Group D employee, and the post would revert back to Group D employee. As a Group D employee, and the petitioner is not entitled to appointment on compassionate grounds in view of the rule.
Rule 8, Your Lordship.
In view of the rules of 2003. The institution in which the petitioner was working was admitted to grant in aid. And while so admitting to grant in aid, the husband of the petitioner, who was also an employee, is brought within the ambit of grant for a limited purpose of closure of the issue of job-oriented course by the following order. Flag ಹಾಕಿದ್ದೇನೆ madam.
For all the categories, it was made applicable. For FDA, STA and group, for all the categories, it was made.
The government order was bringing several cadres of job-oriented course teachers within the ambit of grant as a one-time measure, with a clear indication that on the retirement or death, on the retirement or otherwise, death and the
Otherwise.
on the retirement
Now
or
the-
otherwise, the post getting vacant would, or the post would revert back to becoming permanently unaided. It is on this condition the husband of the petitioner is also brought under the ambit of grant. The state, as could be gathered from the order, has granted the said benefit of bringing the husband of the petitioner and the like under the ambit of grant for the sole reason of giving a quietus to the issue of job-oriented course teaching. The issue now is whether the petitioner would be entitled to appointment on compassionate grounds in the teeth of the aforesaid government order, in which the post held by the petitioner's husband would revert back to an unaided post. It is the government order did not spring in thin air, but it was in terms of a rule that comes about in the year 2003, i.e. on 7th August 2003. The relevant rule reads as follows. The rule was in place that the moment the vacancy of non-teaching staff as on 1/3/2001 would be permanently unaided. Any vacancies arising after 1/3/2001 on account of retirement, resignation, removal, dismissal and death are to remain permanently unaided. Such vacancies which are unaided is to be filled up by the management, and the state would have no role to play. If the rule and the government order are read in juxtaposition, what would unmistakably emerge is that the disentitlement of the petitioner to seek appointment on compassionate grounds. Though compassionate appointment is to be granted to tide over the crises or that befalls upon a family due to the death of the sole breadwinner, the appointment cannot be granted, dehorse the rules. The rules are as quoted herein above. A post of the petitioner, husband of the petitioner, was brought under the ambit of grant as a one-time measure. The one-time measure having gone after the death of the husband cannot mean that the wife would be brought in by the management with the approval of the state, contrary to the aforequoted rules. Therefore, finding no merit in these petitions for claim of compassionate appointment, the petition stands disposed.
Right.
Seal number 32, Ramchandra Mali, BS Campus.
appear, my lord, for the petitioner. This is a matter, my lord, wherein a retired employee, my lord, in 2013 was deprived of, my lord, terminal and pensionary benefits for a
ನಾನ್
period over.
ಮಾಡಿದ್ನಲ್ಲ My order.
My lord,
Oh,
my lord,
annexure
order.
F1, oh, sorry, F, my lord.
On 17/11, my lord, I took
Hey,
time.
what
my
are you
lord.
claiming now?
Now, my lord, they, in the contempt, my lord, they paid page number.
ಆಯ್ತು, ಈಗ ಎಷ್ಟು ಬಾಕಿ ಇದೆ?
My lord, Baki, my lord, we have paid it, my lord. I have filed, my lord,
ಯಾವ್ದು ಕೊಟ್ಟು?
memo along with, my lord. I have given.
Till that is,
Lord,
my lord,
memo is-
incomplete is what my.
Lord, we have calculated, we have paid, my lord, 34 lakh and, my lord,
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿ.
ಈಗ ಈ ಪೆಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದೇ 34 lakh, my lord, I have filed memo, my lord, actually.
34 lakhs ಅಲ್ಲ, ಅವ್ರ ಮೆಮೋ ಪ್ರಕಾರ 26 lakhs ಅಂತ ಹೇಳ್ತಾರೆ. My lord, your lordship may kindly take.
Tax deduction 8 lakhs ಆದ್ಮೇಲೆ 26
ಅದು
ಆಗಿದೆ.
how, my lord, that has been done, your lordship may kindly see. They have granted, my lord, this Vetan Vyathyas 5,04,52, out of which, my lord, they have credited only 452 rupees and deducted 5 lakhs towards, my lord, the tax.
This is done, my lord, strictly in accordance with your lordship's order, my lord. 12% interest ಹೇಳಿದ್ದು ಅದ ಪ್ರಕಾರ. Lord, your lordship said, my lord, if the amount is not paid within the, my lord, certain time, 6% initially, if not paid, my lord, 12% till the payment. My lord, shortage of was there, my lord. Actually, last time I took time to, my lord, pay the arrears. Now, my lord, the entire arrears, my
ಎಷ್ಟು
lord, remaining
ಕೊಟ್ಟಿದ್ದೀರಾ?
arrears.
5/12/25 ಗೆ
Yes, my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಈಗ, my lord,
26 ಲಕ್ಷ 30.
ಅದು
ಮುಂಚೆ ಎಷ್ಟು
30
ಕೊಟ್ಟಿದ್ರಿ?
ಮುಂಚೆ, my lord, 1 crore, my lord,
That
53
is
lakh
1
37,000.
crores of 22 lakhs.
1 crore 53 lakhs.
Enough of windfall.
Total 1 crore 88 lakh.
Only, submission is this towards, my lord, this.
Enough of windfalls. ಆಯ್ತು, 1.5 ಕೋಟಿ ಬಂದಾಗಿದೆ. ಇನ್ನೆಷ್ಟು ಬೇಕು ನಿಮ್ಗೆ?
ಅಲ್ಲಿ ಬೇಕಂತ ಬಿಟ್ಟು ಅನ್ನೋದು ಅಲ್ಲ. What they have done is only, I'll submit, my lord, at two aspects, my lord, page number 83, your lordship, may kindly take.
ಸಾಕು.
I'll leave.
ಎಷ್ಟು? Enough. The petitioner is before this court seeking the following prayer. The petition is an offshoot of an order passed by this court, which directed, offshoot passed by this court, which allowed the petition by the following order. Page 66, 67. A writ appeal preferred against the said order comes to be rejected. After rejection, payment of 1 crore?
22 lakhs 670.
1 crore 22 lakhs 670 as arrears of salary and terminal benefits is paid by the respondent corporation. Alleging that he has been short paid, the subject petition is preferred. During the pendency of the subject petition, again 26 lakhs 35,528 is paid. Therefore, in all, the petitioner has today received close to 1.5 crores as arrears of salary and terminal benefits. The learned counsel though the learned counsel Ramchandra Mali vehemently contends that he is still to be paid amounts in the light of the said amount being paid by a corporation which is undoubtedly public money, nothing further would survive for consideration in the case at hand. The petition stands disposed.
Great.
Pleasure.
Number 33, Shivani Shetty.
My lords, I appear for the petitioner's counsel, my lords. My lords, this is the matter regarding that Group A post, my lords. My lords, on the last occasion, my lord, a submission was made about my bona fides. Kindly see page 261 for a minute, my lords. 261. I am a witness as against that Deepak. Kindly see page 261 for a minute, my lords, of the writ petition.
Who is that Deepak?
My lords, Deepak is the kingpin who misappropriated the money. Entire money was found in his account. FIR is filed against him. After FIR is filed against
problem ಆಗಿದೆ ಹೇಳಿ ಸರ್?
My lords, I'm a Group A officer. Rule 36 requires them to obtain the sanction of the Chief Minister. They have not obtained the sanction of the Chief Minister. Therefore, the disciplinary proceedings
For
as against me
departmental
has to go.
inquiry.
Departmental
Departmental
inquiry.
inquiry.
Yes, my lord. Department inquiry. Rule 36. My lord's judgment is there, my lord. Shiv Shankar and Dr. Chandrasekhar. Yes.
First of all, my lord, he was, my lord, in charge of my lord, accounts department, but he signed the checks, but submitted, my lord, here the signature is his around without there being any work, my lord, or there was not even a contract at all.
Allegations irbodu,
I-
but
But he's fortunate, my lord, that criminal proceedings are not initiated against him. But for that, my lord, he cannot say that, my lord, discipline
My lords,
proceedings
I am
should
saying
not
I am
be
a
initiated.
witness. I am a witness in the case against Deepak. Kindly see page 261. I am a witness
He's
in the case
fortunate,
against
my
Deepak.
lord.
Based on my statement.
Allegations are there.
No, my lords, no
He
allegation
himself-
against me. Page
no,
261.
now
Appear
the
and
issue
say the
is
same.
only whether sanction is required or not.
Not,
Or has been taken or not.
Not been taken.
Not-
They have said so, my lords, they have said so before this honorable court. They made a statement before this
Your
honorable court.
submission is not required.
Yes.
Your Lordship.
Are you saying it is not required?
Please, Your Lordship.
Why?
Because, Your Lordship, Rule 15(3), Your Lordship, shall have power, the appointing authority for
Entry
place.
of KCSCCA.
Please, Your Lordship.
Hmm.
Placing such government servant under suspension
Suspension, department inquiry.
and of the disciplinary authority
Hmm.
for the purpose of taking a disciplinary proceedings against him and to impose any of the penalties specified in clause 1 4A of Rule 8 on such government servant, it shall not be necessary for the government in water resource department or managing department to get approval or to consult the lending authority of the appointing authority as the case may be before placing such government servant under suspension or imposing on him any of the said penalties, but it is necessary to intimate to such penalty to the
Group A applicable alla.
group A. No, it is. The government servant, Your Lordship, in clause 1, Your Lordship, the government servant in water source department in respect of the government servant holding group A and group B posts whose services are lent on Kaveri.
Lent on.
Please, Your Lordship.
Mig lent alvala. See, group A, group B,
Please, Your Lordship.
the disciplinary authority continues to be the lending department, even if he is on deputation. Group C and D, the lending department can initiate disciplinary proceedings, anything they can do for a misconduct committed in the lending department. Now, group A, only a recommendation can be sent to the lending department by the borrowing department.
Please, Your Lordship.
That's what the purport of that is. A and B lending department power illa. Is lending borrowing alla illiradu. Whether it is placed before the chief minister in terms of the transaction of business rules is his submission. Whether it's required or not, the answer should be there.
Lord, may I submit? But the order is.
Misconduct may be grave. I am not on
I-
that. We will not go into that. But misconduct may be grave. We will not get into that issue. The legal issue with regard to this we will solve.
My Lord, the order is issued in the name of governor himself. The Lordship sees annexure A.
No, does it mean that it is placed before the chief minister?
That's under Article 166. Lordship may kindly say, the rules are framed under Article 166. Here it says, my lord, all executive actions of the government of a state shall be expressed to be taken in the name of.
What is the loss cost?
Around 7 crores, my lord, is the. But even the transaction rule is not clear that prior approval is required. It only says all the cases of nature.
It can't be post facto approvals.
May I read this? It says all the cases of the nature specified in the second schedule to this rule shall, before the issue of orders therein, be submitted to the chief minister by secretary and the department. But cases which shall be submitted in the schedule, it says cases relating to disciplinary matters against an officer of Group A. Prior sanction is not mentioned. As
Prior
like it, in section 19, my lord, of the IPC, the prior sanction has to be taken.
PC Act, IPC.
Sorry.
Yes.
I'm not so acquainted with it.
That's all right.
Like that, my lord, there is no such express provision that prior sanction has to be taken. It has to be placed. And moreover, my lord, under the 163, Article 166, my lord, these rules are framed. it's passed, my lord, the order under Annex A is passed, my lord.
It requires consideration.
Please.
Not.
And those
It has-
judgments which your lordship had
It has
referred.
far-reaching consequences. It's not, cannot be just like that rendered. What are the judgments, sir?
My lords, three judgments, my lord, I've produced. One is, my lord, Karnataka Lokayukta produced, but that's, my lord, Peshway's judgment, my lords, which remanded the matter back. My lords may kindly take page 30.
1 minute. Transaction of business rules ಅಲ್ಲಿ ಯಾವ್ದು ರಿಲೇ ಆಗಿದ್ದು ನೀವು?
ಹೌದು ಅಲ್ಲ, ಇದು
My lords,
ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ.
just 1 minute, my lords.
Sanction.
Kindly see.
Those are IPC offenses.
My
Transaction
learned
of
friend
business
may permit
rules.
me. My learned friend may
Wait,
just permit me to kindly read, my
Now
lords,
you
page.
tell me, transaction of business rules, ಯಾವ rules, sir?
Rule 36, my lords. Rule 36.
One moment.
My lords may just take. My lords, I filed a note. My lords may just take the note for a minute. I filed a small
One moment,
note.
sir.
Sorry.
36. Where is the schedule?
My lords, second schedule, my lords. My lord, note I'll extract ಮಾಡಿ. The
One
note
minute.
ತಗೊಂಡ್ರೆ 4-page note.
Second schedule.
Yes, ma'am.
36, 19.
So disciplinary matters admittedly has to be referred.
Before issue of orders. Before issue of orders. My lords may kindly see rule
Wait.
36. All cases of the nature space.
These rules shall, before the issue of orders thereon, be submitted to the chief minister by the secretary of the department.
My lords may see schedule 8, schedule 2 only 8 and 9 may kindly be seen, my lords. 8 and 9. Second schedule only 8 and 9.
Page number 35.
Yes, sir.
Moreover, your lordship, this is
Next level. Yes, Ajay.
My lords, just one submission. My lords, I have seen the second schedule, my lords.
I have seen.
Yes, my lords, just one aspect I want to point out on the minutes. Kindly see page 261 for 1 minute. Just two for my page 261. My lords, I have page 261, my lords. This is, my lords, the charge sheet filed against Deepak, my lords.
Yes.
Yes. My lords, it's a second paragraph, my lords. ನಂತರ ಅಧಿಕಾರಿಗಳು ಕೆಲಸದ ಒತ್ತಡದಲ್ಲಿರುವಾಗ ಸಂದರ್ಭವನ್ನು ಬಳಸಿಕೊಂಡು ತಾನು ಸೃಷ್ಟಿಸಿರುವ ಕೋಟಿ
ಅದು ಫ್ಯಾಕ್ಟ್ಸ್ ಅಜಯ್, ಅದು ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಆಯ್ತು.
No, my lords, because my lords. Yes, my lords, on the aspect of law, my lords, I have pointed out, my lords, saw rule 36, my lords. My lords saw rule 36.
I have seen rule 36, schedule 2.
Yes, my lords.
Disciplinary matters is covered.
Yes, my lords. Now, my lords, the judgment of my lords. Kindly now, my lord, look at the judgments, my lord, I have produced, my lords. Kindly take the judgment.
B. Shivashankar, sir. B. Shivashankar was 13(1)D and 13(E), 13(2). It is not departmental inquiry. Peshway is again 7A. It is not departmental inquiry. Both were criminal cases where sanction was required or not was what is.
My lords, I see. I get. My lords, I understood, my lord. May just one submission can I make, my lords? My lords may just have the matter next week, my lords. I will produce a judgment on this. I understood the. Next week, is it possible, my lords? I'll produce a judgment on this one point. I understood the question that, my lords, there is a judgment, my lord, not of our High Court. I'll find it and produce. I read it, my lords. I thought, my lords, covered by my lord's point. I understood the question.
No, no. Both are criminal cases.
No, my lords, these are criminal cases. These are.
No, this is departmental inquiry, sir. Shivashankar was criminal case. Peshway was criminal case.
My lords, that's what I'm saying. My lords, yes, my lords. What I'm saying. My lords, yes. My lords, just 2 points I just want to make, my lords.
Your submission should be under second schedule of 36. One of the clauses is lokayukta's initiation.
Yes, yes,
If,
yes.
if transaction of business rules is, sanction is required, prior approval of the chief minister is required for that. Another clause of the same schedule cannot mean that it cannot be there.
Yes, my lords, that would be my submission, my lords. That would be my submission. That would be my just one other aspect, if my lords just permit, my lords.
Really?
Yes, my lords. In my lords' judgment itself, my lords have analyzed insofar as how and why transaction of business rules is important. And my lords have held that therefore it is, my lords, it is like a super, it is because it is arising directly under the constitution, it, my lords, supersedes everything else. That is what my lords have held on. My lords, on the if my lords says that if there is a requirement, my lords, I'll find and produce a judgment exactly on the point relating to disciplinary inquiry. But my lords, the point that my lords have said, my lord, that answers my question. Point number 8 is relating to disciplinary. Point number 9 is relating to lokayukta. My lords, that would it completely covers the issue. I can't put it better, my lords. I'm sorry. I was thinking on some other lines. My lords have just crystallized the issue on that one point.
We'll see. Yes. Get a judgment. Let's Monday, fresh matters.
My lords, I have some difficulty on Monday. Can it be on Friday, my lords?
Next Friday?
My lords,
19 is half day, sir.
Yes, my lords, I have some.
All right, 19.
19. Yes, great. Interim order may kindly be continued.
Interim order subsisting will continue till the next date of hearing.
Obliged.
19th in the fresh matters list.
Yes.
Yes.
Seal number 34, Anne Saheb Shalgar, B. Mohammad Ali.
Please, your lordships. This matter pertains to the Waqf institution, my lords, district Vijayanagara. The impugned order is at page 52, marked as annexure M. This is an order passed by the board, my lords, constituting a managing committee of 11 members for the period of 3 years, dated 25/2/25.
So what? Who are you?
I am the person interested in Waqf, my lord, as per the...
Person interested?
Yes. As the Waqf institution is a mosque.
Appeal 83, section 83.
83.
My lords, since, my lord, there is an interim order granted by this honorable court.
Last occasion or please.
Where is the interim order?
2011-25.
Oh, either 4 people.
Yes.
No, 1 minute. Where they were?
Vijayanagara district dispute.
Oh,
Last,
yes,
last
sir.
occasion it was pointed out by
There
your
are
lordships.
the bunch of contradictions, my
Yes,
lord.
sir.
Lord, my submission.
Where are the objections?
Lord, I appear for the respondent number 5, pleading applicant, my lord. Wherein, my lord, the petitioner who is having no locus as per section 3.
You forget his locus, sir. You forget his locus.
That, my lord, the order impugned is, my lord, subsequent to this particular development.
Waqf board circular is 29/6/19.
Yes, indeed.
Public notice is issued on 14.
To that same effect, my lord, the correction was forwarded by the Waqf board in the month of March itself.
When, sir?
My lord, may I please to, my lord, in the month
Other
of...
objections.
My lord, please.
All of you file a
And, my lords, one more submission, my lords, as per annexure P.
list the matter on 18th. Objections, if any, by the respondents by then. Interim order subsisting would continue till the next date of hearing.
Please.
In the fresh matters, my lords.
In the fresh matters. Yes.
Great.
Much okay.
Seal number 35, GN Narsamnavar.
Petitioner has filed application for appointment of Anganwadi helper, my lord. My lord, she has obtained more marks than the respondent number 6, my lord. Without considering, my lord, the
Yes, sir.
annexure H has been passed, my lord.
Madam.
She has not uploaded the documents, your lordship.
Which document?
Residential documents, your lordship. Residential proof.
Objections ಅಲ್ಲಿ ಕೊಡ್ಲಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೇನೆ. ಕೊಟ್ಟಿದ್ದೇನೆ.
ಇವ್ರಿಗೆ ಮಾರ್ಕ್ಸ್ ಎಷ್ಟಿದೆ?
386, my lord.
386. ಯಾರಿಗೆ?
ನಮಗೆ 481, my lord.
So lot of difference. 100 marks difference. ನೀವು ಬಿಡೋಣ? ಅಲ್ವಾ? ಬಿಡಿ. Then give way. Merit. Petition judgment ಅಲ್ಲಿದೆ ಕೊಡಿ. ಗೊತ್ತಿಲ್ವಾ? Dismissed. The petitioner is before this court seeking the following prayer. ಏನು ನೀವು ಓದ್ದೆ ಬರ್ದೆ ಹೋದ್ರೆ ಬಂದ್ರೆ ಹೆಂಗೆ?
Judgment ನೋಡಿ.
ಹೋಮ್ವರ್ಕ್ ಅನ್ನಲ್ಲ ನಾನು, ಯಾಕಂದ್ರೆ ಹೋಮ್ವರ್ಕ್ ಅಂದ್ರೆ ಬೇಜಾರಾಗುತ್ತೆ. ಅದಕ್ಕೆ ಓದ್ದೆ ಬಂದ್ರೆ ಹೆಂಗೆ?
Sorry.
The petitioner is before this court seeking the following prayer. The petitioner, heard once, the petitioner and the respondent, private respondent, participate in a selection process initiated by the respondent for appointment as Anganwadi helper. Which Anganwadi center?
Ward number 4, my lord. Ward number 4, Akshay
ಹಾಸ್ಪಿಟಲ್ ವಾರ್ಡ್ ಅಲ್ಲ ಕೇಳಿದ್ದು, ಯಾವ ಅಂಗನವಾಡಿ ಸೆಂಟರ್ ಅಂತ?
Asray plot 1, my lord. Shiggaon, Asray plot Shiggaon, my lord.
ಅದೇ ಬರ್ಕೊಳ್ಳಿ ಸರ್. ನೀವೇನು ಹೇಳಿದ್ರೆ ವಾರ್ಡ್ ನಂಬರ್ 4 ಅಂದ್ರೆ ನಂಗೆ ಗೊತ್ತಾಗ್ತದೆ. ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ವಾರ್ಡ್ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಎಸ್. So the petitioner and the respondent participate in the said selection process. The third respondent, third ಏನಿದೆ? Seventh respondent, ಅಯ್ಯೋ ಇನ್ಯಾರಿಲ್ವಾ?
Ninth respondent.
Ninth respondent.
ಇನ್ನೊಂದು 4 ಜನ ಮಾಡ್ಬಿಡ್ಬೇಕಾಯ್ತು. The ninth respondent is appointed as Anganwadi helper in the Anganwadi center. The petitioner is before the court calling the said appointment in question on the score that the petitioner is more meritorious than the appointed candidate. The learned counsel appearing for the petitioner would project the solitary circumstance of merit as is averred in the petition as a submission. The learned counsel learned HCGP appearing for the state would submit that the petitioner did not upload the document.
Domicile certificate.
Upload the domicile certificate, and therefore a less meritorious person was chosen in the absence of a domicile certificate. The certificates of the appointed candidate were in order, therefore the appointment was made in favor of the appointed candidate. The learned counsel for the petitioner submits would join issue in submission that the petitioner, while filing the objections, had filed the domicile certificate along with the objections. Therefore, prior to the selection, when it was in place, the respondent competent authority ought to have considered the same. I have given my source. Therefore, narrated facts are not in dispute. The issue lies in a narrow compass. It is an admitted fact that the petitioner in the qualifying examination secures 481 marks, which amounts to 76.96%. While the selected candidate, the ninth respondent, has secured 381 marks.
86.
386. Any difference? 386 marks, which is close to 90 marks less than the marks secured by the petitioner. The only issue is whether merit can be given a go-by on the score that the cyber center did not upload the document of domicile certificate of the petitioner. The petitioner, on looking at the provisional select list, files the objections. The objections reads as follows. Annexure G, page 24. To the objections, the document of i.e. the domicile certificate is appended. This is an admitted fact. If the domicile certificate was available and not uploaded at the outset, it was brought to the notice of the authority before the final list could be out. The issue whether the non-filing of the domicile certificate is would take away the merit of a candidate is no longer res integra. The apex court in Rajkumar Gijoria has held as follows. In the light of the petitioner being more meritorious, close to 90 marks than that of the selected candidate, the ninth respondent, the selection of the ninth respondent on the sole score that the domicile certificate was not uploaded, notwithstanding the fact that it was appended to the objections, is erroneous and contrary to law. For the aforesaid following out allowed, quashed. The appointment of the ninth respondent stands quashed. The petitioner shall be offered appointment as Anganwadi helper in the said Anganwadi center if the petitioner qualifies on all other counts. Ordered accordingly.
Number 36, Venkatagiri Ramchandra Hegde.
Warrant executed.
Huh?
Warrant executed and they appear before the lordship, before AC.
ಲಾರ್ಡ್ ಅವರು ಇದೇ ತರ ಡಿಲೇ ಟ್ಯಾಕ್ಟಿಕ್ಸ್ ಅನ್ನೇ ಯೂಸ್ ಮಾಡ್ತಾರೆ.
ಇಷ್ಟ ದಿನ ಈಗಿಲ್ವಲ್ಲ. The petitioner is before this court seeking the following prayer. The learned AG on instructions should submit that warrant has been executed and the respondent children of the petitioner have now appeared before the assistant commissioner. In that light, the assistant commissioner is directed to take the issue to its logical conclusion, reserving liberty to the petitioner to avail of such remedy as available in law. The petition stands disposed. Next.
Seal number 37, CS Party.
The petitioner has been acquired by the KIDB, your lordship, that. So that deputy commissioner called the price fixation committee. So the price suggested by the deputy commissioner is not accepted by the landowners.
All right, again, objection second.
I'll take note.
The
For
first
respond
time-
number one,
This is,
Your Lordship.
first time, your lordship.
The learned HCGP is
Respond number one, Your Lordship.
is directed to accept notice for the first respondent.
2 and 3.
And
ಯಾರು ಹೇಳಿ?
Your-
KIDB.
Shashank or
ಶಶಾಂಕ್ ಹೆಗಡೆ KIDB. ಇನ್ಯಾರಿದ್ದಾರೆ?
ಇಲ್ಲ, ಪವನ್ ದೊಡ್ಡಟ್ಟಿ ಅಲ್ಲ.
ಅದಲ್ಲ, ಇನ್ನು ಬೇರೆಯವ್ರು ಯಾರಿದ್ದಾರೆ?
There are,
Respond number 4 is there.
4 ಯಾರು?
so that company, your lordship.
ಇದಾರಾ? ಒಂಟಿ ಬೋರ್ಡ್ಗೆ, ಎಸ್, ನೆಕ್ಸ್ಟ್. ಇನ್ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದಾರೆ ಹೇಳಿ ಸರ್?
So fourth respondent, that company, Mittal India Private Limited.
ಎಮರ್ಜೆಂಟ್, SLR ಮಿತ್ತಲ್ಲ, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್, ಎಸ್, ನೆಕ್ಸ್ಟ್.
Seal number 38, Anandar Koldi, Bhushan B Kulkarni.
Lordship, kindly pass over, Your Lordship, in this matter.
ಏನಿದು?
Senior counsel has argued last time, Your Lordship. I have took time to verify the judgments, Your Lordship.
ವಿಲಾಸ್ ಕುಮಾರ್ appear
ವಿಲಾಸ್
ಆಗಿದ್ರಾ?
ಕುಮಾರ್.
ಹಾ. Verify the
Kindly,
judgments.
kindly pass over, Your Lordship. I will.
Heard the learned senior counsel P. Vilas Kumar appearing for the petitioner. The learned HCGP, yet again seeks time to secure instructions and make submissions. List on Friday?
Please, Your Lordship.
Friday, fresh matters.
On Monday. May I seek on Monday?
ಆಯ್ತು, Monday, fresh matters. ವಿಲಾಸ್ ಕುಮಾರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ. ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Seal number 39, K. Raghavendra Rao, PV Gunja.
The matter was with regard to restoration of.
List on 17th for dictating orders. Commutation.
Yes, Venkatesh.
Supreme Court will see. Yes.
Alla, they have not placed any material on the last occasion, Lord.
We'll see. Take it on 17th. Yes.
Seal number 40, RK Kulkarni, Bhushan Kulkarni.
Regularization.
Lords, he claims that he's been working since 15 years and no representations are made.
Give a representation.
Please.
The petitioner is before this court seeking the following prayer. The heard so and so. The petitioner is said to have been appointed by the third respondent to work in the office of the fifth respondent as a nodal engineer. The claim of the petitioner is that the petitioner is working since 2009 till today and claims that he should be regularized. There is no representation submitted by the petitioner to the respondents seeking projecting the claim of regularization as is projected in the case at hand. The petition is preferred without submitting a representation. A petition cannot be submitted, seeking mandamus cannot be entertained without at the outset submitting a representation is by now too well settled a principle of law. That light, the petitioner is reserved the liberty to submit a representation in accordance with law. Ordered accordingly. Yes.
Seal number 41, Srinivas Nair, SS Party.
I've challenged the order of disqualification. May I just pass on some dates or events?
ಇಲ್ಲೇನೋ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
Same.
ಹಾ.
Lord, 2018, the earlier board was not elected.
Answering respond ಇವ್ರೊಬ್ರೇನಾ?
SS Patil for respond number 3.
He is a
Complaint,
complainant. In fact, everything is done what not supposed to be done.
Pass over.
Please.
Yes. Next.
Seal number 42, Anand Kumar A. Magdu.
42, 43, same. ಎರಡು same,
The
madam.
case, please no. This is the case wherein the petitioner land has been acquired for the purpose of state highway, Milo, wherein there was acquisition to the extent of 16 guntas, Milo. Out of that, initially they have paid only 10 guntas, Milo. Subsequently, we have filed a writ petition for claiming for the rest of 6 guntas, 8 annas, Milo.
Delayed interest on delayed
Delayed
payment.
interest, Milo. Wherein petitioner has entered into an agreement on 18/11/2014, Milo, which I have produced it
Who
along
has
with the
to
memo.
answer, madam?
Sorry,
Yaar?
only the state
State
government.
hai na?
Only
Ready?
Please.
Yes.
Here, petitioner has entered into an agreement on 18/11/2014, Milord. And initially, first payment was made on 30/8/2019, Milord, wherein agreement was entered into in the year 2014. So here, petitioner is seeking for the delayed payment, Milord. And subsequently, another 6 kuntas 8 annas, Milord, by way of writ petition, we have sought for. That was to be calculated from date of agreement to the second payment, Milord.
Second payment yavaga?
17/12/2024.
So now delayed payment, interest on delayed payment.
Yes, ma'am.
So from 18/11/2014 to 30/8/2019 insofar as the first chunk.
First.
The second chunk is up to 17/12/2024.
Please.
Judgment Silva?
Judgments. One is under section 142 of the Supreme Court. And the another is, I would like to pass on, is under section 34. Two copies I have served, one copy for the government. Sorry, ma'am. Here, my lord, sorry.
Same petitioner.
Same petitioner, this is the different one. There also there was an agreement between the parties. It's a acquisition is under the airport acquisition, but there, my lord, there also the Honorable Apex Court in case of Suresh Pankapur, that is civil appeal number 2380 of 2017. Your lordship may kindly peruse paragraph 5, my lord. This court in the case of revenue divisional officer so and so.
Damage award.
Damage equivalent to damage is what they say. It is has laid down that though interest was not payable, but damages can be measured as an award in such cases, wherein thus in the instant case we deem it appropriate to exercise our inherent power under Article 142 of the Constitution of India, grant damages of 15%. Similar to that only, Milo. Yes, Milo. But here, Milord, even in this case, in case of Commissioner Rehabilitation and Resettlement Upper Krishna Project, Bagalkot and another versus Jayashree Koti and others. Here they say at the first head note, Milord, acquired land interest payable on amount of compensation not paid or deposited before taking possession. Here, when the agreement was entered, the possession has already been taken immediately on the date of agreement, Milord. So interest payable from the date of taking possession till payment or deposited of amount of compensation. So however, in the absence of any record to show on what the date of possession was taken, interest payable from the date of here the possession has been taken on the date of agreement. So from there till the date of payment, the interest is to be carried out.
Page number 28, Your Lordship.
Of the petition?
But they say that, yes, no. When we have filed a writ petition, there we have not claimed. And according to the writ petition, the amount has been paid is what the endorsement has been issued when I have made a representation.
ನೀಡಲು ಕೋರಿರುತ್ತೀರಿ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಹೊರಡಿಸಿರುವ ಆದೇಶದಂತೆ ಕ್ರಮ ವಹಿಸಿ ಪರಿಹಾರ ಹಣವನ್ನು ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಬೇರೆ ಪ್ರಕರಣದಲ್ಲಿ ಉಲ್ಲೇಖದಂತೆ ಶೇಕಡ 15% ನಕಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. The acquisition was challenged.
Acquisition was not challenged because acquisition in the writ petition I have challenged it because to the extent of 6 kuntas 8 annas they have stated that there is a road existing and for that compensation was not paid to me.
Second chunk ಆಯ್ತು. First chunk again dispute ilva?
Dispute illa. ಅಲ್ಲಿ ಏನಾಗಿದೆ, there was a dispute insofar as market value is concerned, my lord. Initially it was subsequently 1093 was awarded and as per the agreement entered, my lord, it was 1093, my lord, but they paid only to the extent of 410, my lord. For that, I have challenged in the writ petition also.
ಇದು ಯಾವ್ದದು?
ಅದರಲ್ಲಿ ನಾನು ಕೇಳಿದ್ದೆ.
Which writ petition?
Writ petition 14760.
Writ petition 147,609. ಅದು endorsement ಅಲ್ಲಿ ಅವ್ರ
ಉಲ್ಲೇಖ.
That is pending.
that is disposed of.
Disposed of. ಅದೇ ಇಲ್ಲಿರೋದು ಅದೇನೆ ಅಲ್ವಾ?
ಅದೇ
ಅದರಲ್ಲೇನೆ
ಉಲ್ಲೇಖ
147,609 ದಿನಾಂಕ 11/1/24 ಹೊರಡ ಆದೇಶದಂತೆ ಪರಿಹಾರ ಲೆಕ್ಕಾಚಾರ ಮಾಡಿ ಉಲ್ಲೇಖ 2ರಂತೆ ಪರಿಹಾರ
ಅದರ ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದಾರೆ. But wherein for interest, my lord, it is their duty to pay interest, because when there is a delayed payment, so interest is to be awarded to me.
Your Lordship, as per the order of this honorable court, we have paid, Your Lordship. Subsequently, this is the new ground they have raised, Your Lordship, and damages and interest they are seeking.
We'll consider many matters of this kind.
Please, Your Lordship.
Heard reserved. ಎರಡೂನಾ ಸೇಮಾ?
Same.
ಎರಡು ಅದರಲ್ಲಿ ಏನಿಲ್ಲ. Fact same is it?
Same extent, everything is same.
Same
Amount is also
6
same.
acres,
Agreement,
8 annas,
same.
In twins ah?
Adjoining lands. Same relatives, family. Grateful.
Till number 44, Vishwanath S. Bichkatti, ML1T.
The second respondent.
My lord, kindly pass on, my lord. I am for respondent number 4.
ಯಾವ್ದು still number?
44.
ಏమంటే ಇದು?
Already one petition was filed seeking direction to the respondent number 3rd authority, Lordship. Wherein Lordship, it is their allegation that Lordship, the authority, airport authority, they have illegally encroached the land. But as per our contention, Lordship, we have not acquired the petitioner's land, Lordship.
ಸರ್ವೆ ಮಾಡಿಸ್ತಲ್ಲ ಅದ ಇದು?
ಅವ್ರಿಗೆ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಇದು ರೆಮಿಡಿ
Placed immediately after vacation. Yes.
Till number 45, Kulkarni Arvind.
That's IPF for the petitioner. There are two writ petitions. One is the earlier suspension order was challenged in 105255 of 24.
105255 suspension order.
105255. Please, Lords. My lords may kindly see, the order was based on some newspaper clippings. Exclusively based on that newspaper clippings, suspension order has been passed. Challenging that, I'm before this honorable court. This honorable court had granted interim order. He has continued with this service. During the pendency, the very same complainant has filed one more complaint. Initially, that complaint was closed, saying that the allegations are far from truth. Based on the second complaint, the petitioner was taken into custody. As he was in custody for more than now, exclusively based on the report submitted by the police officers, the second order has been passed. Page number 232.
No, this is not exclusively based on the police.
ಓ ಇನ್ನೇನು ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಲೋಕಾಯುಕ್ತನ ಇದು?
Police report.
ಲೋಕಾಯುಕ್ತನ
ಅಲ್ಲಲ್ಲ,
ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್.
Because he is involved in a criminal case, they sent me the intimation to university.
Intimation ಕಳಿಸಿದ್ದಾರೆ.
Page 232, their order may kindly be seen. Before the operative portion, before previous paragraph, whereas Sub Inspector Police so and so has submitted the report to the Karnataka University on 2/6/2025, cited reference 16, stating that the following contents of the following the contents of the Supreme Court.
ಈಗ ಎರಡು ಸಸ್ಪೆನ್ಷನ್.
ಎರಡು suspension.
ಈಗ first suspension we will close it. Second suspension is in operation. So first suspension we will close it. This will continue.
This there is no interim order insofar as the second the order is concerned, and it's already 6 months have already lapsed insofar as
that they will consider review of it, but it is not an interim orderable case.
Interim order, we are seeking for the disposal itself, the very purpose.
Direct the university to review it in accordance with law, in accordance with Ajay Kumar Chaudhary.
My lord's judgment.
Nandu idea.
Sunil Desai's judgment, where
review
independent application of mind is also not there. The prima facie case is also not. Even otherwise, rule 10, I did not mention. Even the circular of the state government, which specifically says that they have to find out the prima facie case and independent application of mine.
Prima facie case ಇದ್ರಲ್ಲಿದೆ.
ಇಲ್ಲ, ಒಂದು ವರ್ಡ್ ಇಲ್ಲ ಅದು.
The whole problem is, and he has confessed to his mistakes.
ಅಂತ that is their, that is the report given by the police. Based on that, they have passed this order. And added to this, he has served for 27 long years. There are no allegations of whatsoever nature. And initially, when the interim order was granted in 105255, plus subsequent to that, there were several lots. The works were assigned to the petitioner. He has completed those works, and some of the PhD students are also working under him. They have been put to prejudice.
Oh, Papa.
Otherwise also. Plus, what is the allegation against the petitioner is that there was a cooperative society which requested for conducting the examination. Plus, the unsuccessful candidate initiates a criminal proceedings against the cooperative society. One second.
Will dictate at 2:30. Please. ಒಂದಂತೂ close ಮಾಡ್ತೀನಿ.
That is totally based on the newspaper clippings.
This will consider. Yes.
Please.
2:30 pass forward ಮಾಡಿ.
Seal number 46, RM Javed, B Muhammad Ali.
Based on 16th or 17th. Last week they have given some documents. I have to take it.
List on 17th.
Fresh matters.
Oh, fresh, in the fresh matters.
Please. Much over.
17th ಬೇಕಾ 18th ಬೇಕಾ?
As per his current, I am ready.
ಯಾವತ್ತು ಸರ್? 18th.
Please.
Seal number 47, Nayak Gurunath.
Your Lordship, this is regarding the forced death certificate. On the previous day,
I said I'll dismiss it.
No, Your Lordship, this was any notice to the other side.
Notice.
Also, there is an interim order, interim.
ಬರ್ಲಿ. Yes. Learned AG, state ಇದೆಯಾ?
State is.
State and one.
Learned AG is directed to accept notice for the respondent. ಇನ್ಯಾರಿದ್ದಾರೆ?
Respondent number 1, Chidanand Jinnappa Desai.
ಹೆಸರಲ್ಲ, ಯಾರು? Private respondent, complainant. Emergent notice to the complainant. Yes, next.
Seal number 48, Adit Chandan Gowda, MA Hulyar.
My lord, senior counsel Harnali sir has been engaged. He is held up in court hall to kindly pass over the matter.
He is here.
He is appearing through VC, my lord. He is held up in court hall.
All right.
Great.
Today or another day?
As your lordship's convenience.
Passed over to 17th. Yes. Next.
Seal number 49,
In this case, my lord, filing statement of objection.
Jigani.
The copy is also served.
My lord,
Ready?
please.
ಏನು objection ಏನಿಲ್ವಾ?
No, portion of my land have been sought to be acquired under preliminary notification in 2023, my lords. Now, my lords, without JMC notice, my lords proceeded to survey the land and have produced the map in Annexure C, my lords. That is the portion of my.
Conduct a joint survey.
No,
It's already
my
conducted.
grievance is in twofold, my
It
lords.
is already conducted, my lord. What they say is, they have to shift, they saying, shift the entire drainage, that area to the left side, my lord. That is a natural flow from since the more than 4 decades, my lord. I will, they have, and they are not growing anything in that area, my lord.
Agreed, we are not
Wherein
going.
land,
Oh, you're not doing anything.
No, we are not growing, but we have purchased the property to do the farming, my lords. Because
When did you
if your
purchase the
lordship may kindly see, no,
When did you purchase the property?
before 2 years, my lords, 1.5 years also.
ಅಲ್ಲಿಂದ ಏನ್ ಮಾಡ್ತೀವಿ? ಸುಮ್ಮನೆ ಇದ್ದೀರಾ?
No, the construction have been already started in 2024
Why
itself.
did you purchase that property which construction?
No, in a neighboring lands, my lords, not in my land. They have not touched my land yet. That's why I sought for the stay, not to dispose this
Not to
without
touch your
final.
lands.
No final notification have been done. No compensation have been awarded till today, my lords.
they will get a compensation, my lord.
If
Level
you
one
have
notification
not
is issued.
notified their land for acquisition,
Yes,
you
my lord.
can't straight away do it.
No, my lord, it is notified. 11 on notice issue ಮಾಡಿದೆ. My lord, in between landowners, they are not objecting it.
They are objecting.
not objecting.
Now you are also objecting. Wait, madam.
They are not objecting this project, my lord. Only petitioners, the beginning and the end, they have lands, my lord. So they are objecting it.
As far as 16 persons are the landowners, my lords, in that particular survey number, all 16 owners are objecting this acquisition, my lords. Not acquisition. If your lordship may kindly see the annexure C, that is the portion that are acquiring only 3 to 4 guntas will be left in this side, western side of the land, my lords.
This side,
Western side of the land, one portion, my lords. And if I want to grow or if I want to develop in the future, I can't do anything in that 3 to 4 guntas,
on that side.
that side. And there is no path and passage to
On which side?
western side. If your lordship may kindly see the map.
Produce the
I can-
photographs also, no?
Huh?
Photographs also there, my lord.
All right. ಈಗ compensation, you want to acquire the land in accordance with law by payment of
We
compensation.
will pay the compensation, law.
Without doing anything, you can't
No,
acquire.
we will pay the compensation.
JMC notice kuda agila that.
JMC is already done, Joint Measurement Committee is already done. They said that they have not issued they have not
Notice
received,
ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ ಅಂದ್ರೆ ಮತ್ತೆ?
they have not
Which
received the,
Who have you
Not
conducted?
even a single owner have received the notice.
ಮತ್ತೆ?
No, my
What
lord.
is that? KDB na ಇದು?
No, my lord. They have
BTD.
Which respondent ಯಾರು?
BTD.
BTDM.
ನೀವು
That is
ಹಂಗೆ
the
ಮಾಡ್ತೀರಾ? ಎಲ್ಲ KDB ನೂ ಅಷ್ಟೇ ಇವ್ನು ಅಷ್ಟೇ ಯಾವ್ದು ಲಾನು ಫಾಲೋ ಮಾಡಲ್ಲ.
my lord, they have received you have conducted the JMC.
20 ವರ್ಷ ಆದ್ಮೇಲೆ ನಾನು ಅವತ್ ಮರ್ತೋಗ್ಬಿಟ್ಟಿದ್ದೆ ಅಕ್ವೈರ್ ಮಾಡೋದು ಅಂತ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ 20 ವರ್ಷ ಆದ್ಮೇಲೆ.
No, we have conducted the JMC, but they said that they have not received the notice.
Where have they said notice they have received? Where have they said? Where have they said they have received notice?
In the objection. Oral,
Or where is the notice issued to them? ಎಲ್ಲಿದೆ document? Issue ಮಾಡಿದ್ರಲ್ವ ಇರೋದು? Private lands you take away as though it is your own land. ಸುಮ್ನೆ measure ಮಾಡೋದು ಇದು ನಮ್ದು.
I will that document I will produce it now.
Produce tomorrow.
Day after tomorrow.
Day after tomorrow. Fresh matters list.
Please.
Seal number 50, Sadiq Kanvi, Jay Shetty.
Notes, the petitioners are the office bearers of Managing Committee Anjuman Islam Mudol, and they have been terminated during their existing term without issuing notice as required under section 67 of the Act, my lords, which is prescribed under Rule 58 of the Rules 2017. And there is a form.
Committee had already taken charge. You have approached the tribunal under 83.
My lords,
whatever you
without
want.
issuing notice, my lords, the writ is maintainable, my lords. And
Ah,
your
no.
lordship has earlier in the earlier day, my lords, interim order was
No, the
granted.
other case, ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
No,
In other case,
not
fine.
in this case only, my lords. In this case only, my lords. There is no notice and the order is passed without jurisdiction. And the writ is maintainable, my lords.
No, no. Sir.
And the similar writ has been entertained by
No,
this
no,
honorable
sir.
court, my lords.
On the
And they have not
new
taken a charge.
committee had not taken charge.
no,
which-
no, my lord.
Whereas it had already taken, therefore earlier committee had no right to function in said place, though the constitution new committee held the petition. Yes, sir.
Correspond 4 to 7, my lord.
Section 83, my lord, specifically provides for the
The
remedy
petitioner.
before the.
First, they have not taken charge, my lords. That
No,
can be-
alle- alle
from
ಮಾಡಿ.
since last 2 days, my lords, I am making a submission that they have not taken a charge. That is the fact, my lords. Moreover, I have filed the detailed objection, my lords. I have, my lords, along with the photos and video, I have produced, my lords. That is there on record, my lords.
The petitioner is before this court seeking the following prayer. On 21/11/20 on first, on 30/10/2025, this court had passed the following order. The new committee, the learned counsel for the respondent further submitted. Girish ಯಾರಿಗೆ? Girish Edward ಯಾರಿಗೆ? ನಿಮ್ದಾ? This court on 30/10/2025 had passed the following order. Owing to the submission of the counsel for the respondent on 21/11/2025, the said modified order. ಇದ್ಯಾವುದು judgment? WP 107360.
Sanjay Guru sir.
Based on that judgment only, your lordship has arrived, my lords. That is not covered and that is contrary and it is applicable to my case, my lords.
ಅದು 83.
Poem pata
No,
hai
that is not covered in that 83 is not there. That covers.
Passing of a no confidence motion, my lord.
The petitioner ಎಲ್ಲಿ ತಾಳಿ ನೋಡ 83 ಅಲ್ಲಿ ರೆಮಿಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ.
Lords, when they issue notice, my lords, I am obliged to go under 83. When they have not issued a notice, then it is barred by jurisdiction and it is a writ is.
Objections ಹಾಕಿದಿರಲ್ಲ. Anyway, I modified the interim order.
We have produced documents regarding we have taken the charge already, my lord.
AVIO. Yes, next.
Seal number 51, Tarikal Praveen.
Please, my lord. Dispute of differential amount, my lord, where I made an application before the concerned court to implead me as a party, my lord. it came to be rejected, my lord.
Who are you?
I am one of the line losers, my lord. Earlier I had received a compensation, my lord, from the concerned
madam.
department.
R1, I'll take notice, Your Lordship. R2
Learned
notice has-
HCGP is directed to accept notice for R1, emergent notice to the second respondent.
Not to disperse the amount, my lord, in deposit.
Which amount? How much
Differential
is your
amount.
share?
Well, 1/3 of my share, my lord.
How?
Lord, now, as per my lord, I
How
have.
1/3?
Lord, as per my lord, the land which has been gone, my lord, earlier I had received the amount, my lord.
How 1/3, on what basis are you saying?
My lord, as per the annexure G, my lord, where it says 38 lakhs has been deposited, my lord.
38 lakh?
38 lakhs, 2,573 has been deposited.
Out
Now
of that, how
should be
much is
divided
yours?
between mine and the respondent number 2 here in, Lord.
The respondent shall not disburse an amount of rupees 13 lakhs out of the deposit of 38 lakh 23,000 without the leave of the court. Yes.
38 lakhs, 2 lakhs, 2,005.
38 lakh 2,000. Anyway, 13 lakhs ಅಷ್ಟೇ
Yes.
ನಿಮಗೆ.
Number 52, Yaji Narayan, AP Hegde Jamane.
For petition. But a petitioner is a
21
cooperative.
years da.
Yeah. But the amendment carried to the bylaw of the petitioner society came to be challenged in the year 2025.
Yes, sir. We'll allow it.
Senior counsel is appearing.
No problem. Yes. 2:30 count. 2:30, we'll continue this matter. Yes.
Please.
Well, madam. Sir.
Lordship's kind permission. Lordships are pleased to dispose of serial number 13, my lords, in terms of Justice Krishna Kumar's order. One clarification, my lords, may I seek for. My lords, in that order, the lordships, my lords, had directed the petitioners to submit a detailed representation. My lords, sorting out, my lords, what are the factual aspects of my lords' payment.
Same thing.
My lords, in the operative portion, my lords, ordered to follow your lordship's previous order, my lords, wherein, my lords, the operative portion reads, my lords, respondents.
Whatever just Krishna Kumar has passed, same order will pass.
Please.
Please.
Obliged.
Obliged.
Okay. You're hungry? You're hungry? Mic togoli.
ಜೋರ್ ಜಾಸ್ತಿ ಆಗತ್ತೆ. Some court halls, they have asked me not to use the mic.
ಹೌದಾ?
So, Lord, 194 is listed at 2:30 today.
You're so vociferous, huh? Yes.
Lord, it's a 2012 matter.
100 days, ada. 10 years delay.
This is 2012. Lord, because that KIDB. Beg your pardon. If your lordships could take it up.
Serial number ಏನು?
194. It's serial number 1 at 2:30 today. Serial number 1 at 2:30. 2:30 list ಅಲ್ಲಿ ತಾವು ಕೊಟ್ಟಿದ್ರಿ ಡೇಟ್.
2:30 list ಅಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು. Today at 2:30.
See, we'll take it.
164, your lordship, I have filed NOC for petitioner.
Judgment ಬೇಕಲ್ಲ ತಗೊಂಬಿಡಿ.
They have entered into compromise. If it is taken.
Whoever.
List to serial
My
number
name is
12.
not shown.
List 2 ಏನಿದೆ ಮೇಡಮ್?
List to serial number 12, big. I am for ESCOM. I have to file sections are done. Still, statement of objection.
ಆಯ್ತು, ಯಾವ್ದು ಟೈಮ್ ಬೇಕು ತಗೊಂಡಿರಿ?
After vacation.
Serial number 153.
150, what do you want? Time?
No, no, it may be taken at 2.
Urgency.
2:30 ಅಂದ್ರೆ it's
2:30
a covered
ಅಂತಿದೆಯಾ?
decision that is.
ಇದೆಯಾ 2:30 ಅಂತ? 153 is FE Patil ಅವರು.
FE Patil. It's a covered matter. Lord, in the last occasion we made a mention.
We'll see. Before I rise, we'll take it.
Please, grateful.
If it's covered, in ಯಾವ್ದಾರು covered matter ಇದ್ರೆ ಹೇಳಿ. We'll finish all that. Yes.
Serial number 111 and 138.
Who are you?
I am from the bank.
Party in person?
Yeah, bank.
Bank in the party in person. Where is your advocate?
Advocate is not well. That is why
No problem.
so
We'll adjourn.
we want adjournment. Thank you, sir.
Mr. Silamba. 12. sir, head.
After vacation.
Sir?
Court officer. Court officer.
Sir, ಹೇಳಿ sir.
Madam, first list serial number 123, madam.
First list ಒಂದೇ ನಿಮಿಷ sir. Sir, 123 ಹೇಳಿ sir.
After vacation, madam.
Okay sir.
Adjourn, madam. After vacation, la.
Next week, right? ಹಾ, ಒಂದೇ ನಿಮಿಷ sir.
ನಮ್ ಕ್ಲರ್ಕ್ ಬರೀ ಎಫ್ ನಂಬರ್ ಹಾಕ್ಯಾನ
103.
ಲಾಸ್ಟ್ ವೀಕ್ ಮಾಡಿದ್ವಿ ಅದನ್ನ.
Okay, after vacation. Entry mode extend ಆಗಬೇಕು. ಹಾ sir.
Madam, 123 after vacation ಆಯ್ತಲ್ಲ madam?
ಮ್ಯಾಚ್ ಮಾಡಂತ
Entry mode extension. Monday entry mode extension. ರೀಚ್ ಆತಂದ್ರೆ ಸಾಹೇಬ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. ರೀಚ್ ಆಗದೆ ಇದ್ರೆ ಕಳಿಸ್ಕೊಡ್ತೇವೆ. ಆಗಿದೆ ಬರ್ಕೊಡಿ. ಹಾ ಎಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್. ಮೇಡಮ್
ಸರ್ ಮೇ ಬಿ ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟರ್ ತಗೋಬಹುದ್ರಿ. 230 ಮ್ಯಾಟರ್ಸು ಇದೆ ಸರ್. ಫಸ್ಟ್ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಮ್ಯಾಟರ್, ಆಮೇಲೆ 230 ಮ್ಯಾಟ್ರು, ಆಮೇಲೆ ಪಾಸ್ವರ್ಡ್ ಕೇಳ್ತೀನಿ ನಾನು. ಪಾಸ್ವರ್ಡ್ ಇಲ್ಲ ಕಂಟಿನ್ಯೂ. ಹೌದು ಸರ್, ಹೌದು ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಮೇ ಬಿ
ಮೇಡಮ್
ಬೆಂಗಳೂರು ಹಾ ಸರ್.
ಮೇಡಮ್
ಹಾ ಸರ್, ಹೌದು ಸರ್, ಹೌದು ಸರ್. ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 123 ಆಫ್ಟರ್ ವೇಕೇಶನ್ ಮೇಡಮ್.
125 ಸರ್.
ಅಲ್ಲ 123 ಮೇಡಮ್. 123
ಆಗಿದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್
ಮೇಡಮ್ ಸೀರಿಯಲ್ ಲಿಸ್ಟ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಲಿಸ್ಟ್ ನಾಗ ಅವ್ರು ಹೇಳಿದ್ರು ಅವತ್ತು ಆಗಿಲ್ಲ ಅದು.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಯಾವ ಲಿಸ್ಟ್? ಅಲ್ಲ ರೀಚ್ ಆಗಿದೆ ಮೇಡಮ್. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಯ್ತು. 165. ಹಾ ಹೇಳಿ. 165 ರೀ. ಹಾ ಎಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆನ್ಷನ್. ಡೇಟ್ ಎಂಟ್ರಿ ಬೇಕ್ರಿ? ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಆಯ್ತು. ಹಾ ಹೇಳಿ.
ಇದರಲ್ಲಿ ವಿಸಿನಲ್ ಅಪೀಲ್ ಆಗ್ತಾರೆ.
ಹಾ ಆಯ್ತು.
ಪಾಸ್ವರ್ಡ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್?
3 ಇದೆ ಸರ್. ಹೇಳಿ. ಕೇಳ್ತೀನಿ ಮೇಡಮ್, ಯಾಕಂದ್ರೆ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಇದೆ. ಅದು ಮುಗಿದ ಮೇಲೆ ಸಾಹೇಬ್ರಿಗೆ ಕೇಳ್ತೀನಿ. ಲಿಸ್ಟ್ 2 ನಾ ಅಥವಾ ಪಾಸ್ವರ್ಡ್ ಅಥವಾ ಕಂಟಿನ್ಯೂ ಅಂತ ಕೇಳ್ತೀನಿ. ಒಂದೇ ನಿಮಿಷ. 164 17 ಎಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆ ರೀ? ಇಲ್ಲಲ್ಲ. ಆಯ್ತು. ಹಾ
ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ ಅಂತಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಬೆಟರ್ ಇದನ್ನೇ
ಇದು ಎಫ್ಆರ್ ನಂಬರ್ ಕೊಟ್ಟಿರಲ್ಲ ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ. ಎಫ್ಆರ್ ನಂಬರ್ ಇದೆ. ಹಾ ನಂಬರ್ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ನಂಬರ್ ಕೊಡ್ರಿ ಮೇಡಮ್. ಇಲ್ಲ ಬೋರ್ಡ್ ನೋಡ್ ಕೇಳ್ತಾರೆ ಮೇಡಮ್, ಅದಕ್ಕೆ. ಎಲ್ಲಿ ಬೋರ್ಡ್ಗ? ಆಯ್ತು. ನಿಮ್ಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಡವಾ? ಓಕೆ ಓಕೆ ಆಯ್ತು.
ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಅಥವಾ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ?
ಕೇಳ್ತೀನಿ ಸರ್. ಬೆಂಗಳೂರು ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಇದೆ, ಅದ್ ಮುಗಿದ್ಮೇಲೆ ಸಾಹೇಬ್ರಿಗೆ ಕೇಳ್ತೀನಿ. ಅವ್ರು ಯಾವ್ದು ತಗೊಂತಾರ ಅದೇ.
ಓಕೆ, ಬೆಂಗಳೂರು ಫಸ್ಟ್ ಬೆಂಗಳೂರು ಬೆಂಚ್. ಪರಮೇಶ್ ಇವು ಫೈಲ್ ಸಿಕ್ಕಿ ಇಟ್ಬಿಡ್ಬಾರ್ರಿ ಮೇಡಮ್. 132 ಅರ್ಜನ್ ಆಗೋದು ಬೇಡ ಮೇಡಮ್. 132
ಅನ್ಕೊಂಡ ಮೇಡಮ್ ಸೈನ್ ಆಗಿರೋದು ಫೈಲ್. 132
ಅರ್ಜನ್ ಆಗೋದು ಬೇಡ ಮೇಡಮ್.
ಅರ್ಜನ್ ಆಗೋದು ಬೇಡ. ಆಯ್ತು. 120 ತಗೊಂಡಿದ್ದಾರೆ ಸರ್. 1812.
Court officer.
ಮೇಬಿ ರಾಮಚಂದ್ರ ಮಲ್ಲಿ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
Court officer?
ಮೇಡಮ್ ಹೇಳಿ ಮೇಡಮ್.
Ma'am, serial number 55 Arjun Agad Bada, ma'am.
55.
55, first list.
ಓಕೆ ಮೇಡಮ್ ಆಯ್ತು.
Thank you.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ರೀ ಎಂಟ್ರಿ ಮಾಡಿದ್ರಿ ಇಲ್ಲಲ್ಲ ಟೂ ತರ್ಟಿಗೆ ಇದೆಯಲ್ಲ ಬೆಂಗಳೂರು ಬೆಂಚ್. ಹಾಂ 111 ಎಷ್ಟ್ರಿ ಡೇಟ್? ಓಕೆ.
ಅಂದ್ರೆ ಇದೊಂದು ಪ್ರಶ್ನೆ. this entire e-file, man, copy of the entire e-file has been.
But the serial number 148, the reputed financier of correct Lord has branded as a rowdy. Lordships on the last date, my lord, had said this matter should be posted in the fresh list of the Helidri.
148.
Yes, my lord, by mistake it is coming. Can be taken up tomorrow or day after. My lord,
PM police, ಏನ್ problem?
he has been put in the rowdy sheeters list, my lord, that financer who, because of the stale deeds and ಹೇಳಿ.
ನಾಡಿದ್ದೆಲ್ಲ fresh matter ಗೆ ಹಾಕೋಣ. All the matters that are listed today and would not reach 5 o'clock this full court meeting.
Lord, serial number 136, my lord, in the first list. Lord, sorry. Lord, covered by addition, my lord, acquisition, my lord, only
Covered by what
representation. Lord, it's
Covered
only
by what
representation is made to consider, my lord, that is not done. Acquisition of the year 1992, my lord, so far they have not done the payment.
ವಾಪಸ್ ಸೀಲ್ ಮಾಡಿ ರಿಸರ್ವ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಇದು ಇವತ್ತಿಂದಲ್ಲ ಅದನ್ನ ನಾನು ಚೇಂಬರ್ ಕಳಿಸಿ ಸೀಲ್ ಮಾಡಿ. We'll just finish the second list and take it. Half an hour's time. Second list will dispose ಮಾಡುವಂತ ಇದು ಅದಕ್ಕೆ. Call the second list.
List number 2, preliminary hearing B group, seal number 1, K. Raghavendra Rao, DM Bandi.
Yes, madam. ಏನಿದು?
Yes. Plus petitioners, family in-laws was owning plus certain extent of land in Narayan Devankere village of Hospet Taluk.
ಪ್ರದೀಪ್
Please,
ನಿಮ್ಮ ಮೊಬೈಲ್ ಆಫ್ ಮಾಡಿ ತುಂಬಾ ಗಲಾಟೆಯಲ್ಲಿ. Yes.
Plus was acquired for the purpose of Tungabhadra Dam project in the year 1949, Mulas.
1949.
Yes.
Yes,
Thereafter,
Hmm.
Mulas, the village got submerged. All of them, they left the place.
Certified copy ಬೇಕಾ?
35, a copy of the title deed ಬೇಕು ನಮ್ಗೆ.
ಓ ಯಾಕೆ?
ಬೇರೆ ಇದೆ. They admit that Mulas plot number 12B has been allotted to. I have placed all those materials before your lordship. They admit that Mulas our lands have been acquired.
ಎಲ್ಲಿದೆ ಟೈಟಲ್ ಡೀಡ್?
Title deed you respondents ಹತ್ರ ಇದೆ.
ಇದೆಯಾ?
In fact, Mulas
ಇದ್ರೆ ಕೊಡ್ತಾರೆ. ನೀವು 75-year-old ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಕೇಳಿದ್ರೆ ಇದ್ರೆ ಕೊಡ್ತಾರೆ.
53 documents there are.
53 ಇರ್ಬೋದು.
53 ಡಾಕ್ಯುಮೆಂಟ್.
ಅಲ್ಲ 53 ಇಲ್ಲ 53ನೇ ಇಸ್ವಿದು ಅಂತ ಅವರು
ಇಸ್ವಿದ?
ಇಸ್ವಿದು ಅಂತ ಹೇಳ್ತಾರೆ.
The
Now, Mulas, for us, Mulas, that site is lying vacant. But Mulas, to protect that site.
ಆಯ್ತು, if it is available, they will give you.
They only say, Mulas, it's not available.
What about
That is the
80
endorsement
ವರ್ಷ ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಅದೇ ಸಿಗುತ್ತೆ.
ಅಲ್ಲ, based on the materials available, all the
Whatever
documents I have placed before your
you want,
lordship.
ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನ ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ ಹೇಳಿ?
ಅಲ್ಲ, title deed copy ಆದ್ರೂ at
ಆಯ್ತು,
least what they have, because
ಅವ್ರದ್ ಬಿಡಿ, ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಇಷ್ಟು ವರ್ಷ?
if you're Mulas,
ಏನ್ ಎಲ್ಲ ಗವರ್ಮೆಂಟ್ ಮೇಲೆ ಹಾಕದ? You have no responsibility of keeping the documents?
Mulas, your lordship may kindly
Then
see what happened. Mulas,
everything government has to provide?
No.
Then
Mulas, it was not furnished to us. Mulas, what has happened is this.
ಆಯ್ತು, if it was not furnished to you, why did you wait for 75 years?
ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ, ಅವರೆಲ್ಲ
ಈಗೇನ್
Plus,
ಮಾಡಕ್ಕಾಗಲ್ಲ.
they left the village, they stayed in
Can't help,
Mulas.
madam, you can't wake up from deepest slumber, get up and ask the government to give everything to you. You have, your citizen has his own responsibility to keep the documents.
Yes, Mulas, I do
Then
admit. Mulas, they have, Mulas,
ಏನು
provided these copies, certain copies.
ಏನಿದೆ ಅದು
Admittedly-
ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ಇಟ್ಕೊಳ್ಳಿ ಸಂತೋಷವಾಗಿ.
ಅಲ್ಲ, ಅದೇನು ಪ್ರಯತ್ನ ಆಗಲ್ಲ.
ಏನು ಆಗಲ್ಲ ಅಂದ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Plus, admittedly,
No,
Mulas,
madam.
Mulas, plot number 12B has been allotted. They don't dispute it. The lands, Mulas, belonging to
Allotted
our
when,
family has
madam?
been acquired.
Allotted when, madam?
53 minutes. 1910-53.
Well, Mulas, the mistake is here. Mulas,
Mistake is
lordships
whose?
Mulas, the government mistake. You
Seriously?
don't tell.
Anything
Your
else?
lordships could kindly see, Mulas,
Anything
page
else, madam?
53. Page 53.
The petitioner is before this court seeking the following prayer. The prayer heard so and so. The prayer of the petitioner is seeking a direction to furnish the certified copy of the assignment of the house site within bracket a title deed in respect of allotment of site number 12B. Conspicuously, in the prayer, the date of allotment is absent. The petitioner, the ancestors of the petitioner is said to have been allotted site 12B When is the question? In the year 1953, after about 68 years, the legal heirs of the allottee, who by themselves themselves are 71 years or otherwise now, submit a representation to the respondent and seeking the documents that are seeking the documents concerning this allotment of site 12B. Whatever documents were available with the state is all furnished. The petitioner is now before the court asking for a title deed that was stood handed over at the time of allotment. If the title deed had not been allotted, had not been handed over to the petitioner, the allotment would not have been complete. The person to whom allotment had been made 75 years ago would have undoubtedly questioned it. The family of the petitioner wakes up from deep slumber after about 75 years. After about 69 years, submits a representation and files as the subject petition in the year 2021, and in 2025, the submission is being made for a mandamus. It is not only the responsibility of the state to keep the documents, whatever is there in their possession. The citizen also has a responsibility to keep the documents that are handed over to him. Merely because the documents are not with the possession of the petitioner, the state cannot be blamed for it, and a direction being sought at 75 years after the allotment for a document to be provided, which the state has replied to, contending that it is not available. Ostensibly so, as 75 years have passed by. Finding no merit in the petition stands rejected. Next.
Number 2, GS Hulmani, CV Angadi.
For seeking and mandamus to consider the representation what annexure.
Idu ade tarana?
Please, my lords.
Yen representation?
Lords, to lords, wherein the respondent number 3 corporation have undertaken, my lords, before the consumer forum and also before the high court to make a road, my lords.
Elli?
In the
Mane olga?
In the layout.
Layout.
Please, my lords.
Private layout.
Private layout. Thereafter, my lords, in compliance to that, my lords, they had various representations has been submitted.
Road madi anta.
Please, my lords, to act upon on the basis of the undertaking given before the commissioner.
Yes, sir.
In fact, this writ petition is in the nature of public interest litigation.
Because
we'll consider the representation and pass.
And the petitioner is before this court seeking the following prayer. The petitioner is said to be the resident of a private layout. The respondent corporation is said to have undertaken before the consumer forum that they would form the road in the said layout. The undertaking is sought to be executed by way of submission of representations, plethora in number. The respondent having not considered the same, the petitioner is before this court in the subject petition. The learned counsel appearing for the respondent submits that the subject petition is in the nature of a public interest petition and no relief should be granted. In the light of the prayer being innocuous, that is, i.e. to consider the representation with regard to formation of the road, I deem it appropriate to direct the respondents to consider the same in accordance with law and pass necessary orders thereon. It is made clear that this court has not considered the right of these petitioners to get a road laid in a private layout, ordered accordingly. Yes.
Much obliged.
Number 3, BB Ballari, Chandrasekhar Hiremat.
As on today, my lord, the representation, the claim of the petitioner has been, my lord, forwarded to the state. I got
forward madidira, sir.
It is to the state concern. I place it on record, my lord. May I
The
seek on
petitioner
Monday?
is before this court seeking the following prayer.
One second.
The petitioner is said to have been appointed on daily wages in the 4th respondent university. The 4th respondent university, owing to the service rendered by the petitioner, is said to have recommended the case of the petitioner to the state as early as on 11/4/2014. They said recommendation of the university in University of Agricultural Science to the state has been with the state is what the learned counsel for the petitioner.
One submission.
University submits.
In addition, yes. There are, my lords, earlier occasion whereas my lord, the applications were sent to the state, it has been rejected. That is what, my lords, Monday, my lords, I will place it on record in detail, because, my lords, if that is the case, that has to be, my lords, ended some logical end, my lords. Only to that extent, Monday, my lords, I will place it on record.
List immediately after vacation. Anybody?
Monday, my lords, I will.
Yes, next.
May I?
Next.
R.K. Kulkarni, Hanuman Reddy Saukar.
Lord, the petitioners are seeking mandamus against the respondents number 2 to 4 to consider their representation at annexure F and H for the appointment of Paura Karmikas as they were working on 4/12/2017.
The petitioner is before this court seeking the following prayer. The heard so and so. The genesis of the claim of these petitioners is from a special rules for appointment of Paura Karmikas in local bodies being notified by the state on 4/12/2017. It transpires that the petitioners have submitted plethora of representations seeking their appointment on in regular basis.
Regular basis.
Appointment on regular basis as Paura Karmikas in terms of the special rules so framed by the state. The representation having not met its consideration, the petitioners are at the doors of this court in the subject petition. The learned counsel appearing for the petitioner would, learned counsel appearing for the learned HCGP appearing for the state would submit that if reasonable time is granted, the representation of the petitioners would be considered on its merit and appropriate orders would be passed thereon. In the light of the said submission, I deem it appropriate to dispose the petition, directing consideration of the representation submitted by the petitioners, dated
At annexure F and H dated.
Dated annexure A, F and H, nodi adu dates nodbittu. A, F and H, within an outer limit of 4 months from the date of receipt of the copy of the order, if not earlier. Service lidira terminate ಏನು ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
Illa, now they have been removed. Now they have been removed by sending another's name by respondent number 4. Now they are not working. Some of the persons are working, not other.
4 months, yes.
Please.
Number 5, M. Madhusudan, Gurudev Gachinman.
There is a departmental inquiry is pending, Your Lordship.
Leave encashment.
Please, Your Lordship, ಹೌದು.
Departmental
300
pending ಇದೆಯಾ?
ಹೌದು. Departmental pending, inquiry is pending, Your Lordship.
Heard the learned counsel appearing for the petitioner and respond. Petitioner is before this court seeking the following prayer. The petitioner is the erstwhile employee of the Hubli-Dharwad City Municipal Corporation. He retires on attaining the age of superannuation on 8/12/2020. The petitioner then registers a claim for release of his leave encashment. The said leave encashment is not granted on the score that on the score that a charge sheet against the petitioner is pending for it having been issued on 31/2021. Charge sheet issued against him, consequent to which a departmental inquiry is pending. The petitioner then submits a representation on the score that the inquiry is not progressing and therefore leave encashment and other terminal benefits be released. In the light of the inquiry pending, the employee cannot seek entire terminal benefits. However, if the inquiry has commenced on 31/2021, it is rather surprising as to how the inquiry is still pending for the last 4 years. Therefore, who is the inquiry? Therefore, the disciplinary authority who has sought to initiate the inquiry by issuance of a charge sheet, by a charge sheet shall direct the inquiry officer so appointed to conclude the inquiry within an outer limit of 4 months from the date of receipt of the copy of this order. In the event the inquiry would not get completed within 4 months against the petitioner, the leave encashment that is sought for by the petitioner shall be released on account of the folly of non-completion of the inquiry by the next date, ordered accordingly. Yes.
Number 6, G.I. Gachinman.
Clarify whether salary is paid or not, my lords. Kindly have it on next week, my lords.
Salary?
Please, my lords.
Kotilva?
I'll verify, my lords.
2023, sir. 2 ವರ್ಷದಿಂದ salary ಕೊಟ್ಟಿಲ್ಲ. ಇದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹಾಕಿರೋದೇ ಅದಕ್ಕೆ ಎಲ್ಲ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ.
Please tomorrow, my lord.
The learned counsel for the petitioner submits that he would require time to secure instructions with regard to the release of salary, otherwise Friday, fresh matters.
Please.
Next.
Seal number 7, Nagesh M. Badige, MM Khannur.
They sought for a direction, your lordship, the. They sought for mandamus.
247A, qualifying
240,
service.
yes.
Entitled.
I have filed objections, it may be considered.
List Friday, fresh matters. Yes. Next.
8, Suraj S. Mutnar, Vishwanath D.
For the petitioner, my lord. My lord, I am seeking for a mandamus, my lord, directing respondent number 3 and 4 to consider my application for interview, my lord. That is at for interview, my lord.
Interview.
Please, my lord. My lord, the paper publication for the vacant post of Hindi
teacher.
Yes, my lord. For which I had applied and I had also given all the documents.
Interview ಕರೀಲಿಲ್ವಾ ನಿಮ್ಮನ್ನ?
No, my lord. I don't know the results.
ರಿಸಲ್ಟ್ ಆರು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಬೇಕಲ್ವಾ ಎಲಿಜಿಬಲ್ ಇಲ್ಲ ಅಂತ.
Please, my lord.
The petitioner is before this. ನೀವ್ ಯಾರು ಸರ್?
I am for respondent number 5, my lords.
ಇಂಟರ್ವ್ಯೂ ಯಾರು ಕರಿಬೇಕಾಗಿರೋದು?
3 and 4 ಇಂಟರ್ವ್ಯೂ ಈಗಾಗಲೇ ಆಗ್ಬಿಟ್ಟಿದೆ, my lords. Interview ಆಗ್ಬಿಟ್ಟು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗ್ಬಿಟ್ಟು it's been 2 years.
Obviously.
My lord, they should have at least communicated to me whether.
Now you got to know, madam. The petitioner is before this court seeking the following prayer. The petitioner is said to have submitted her application pursuant to a notification issued seeking appointment to the post of Hindi teacher. The appointment was, the application was submitted on 11/10/2022. The petitioner is not aware as to what has become of the representation for the last 3 years. Therefore, the petition is
I have been made to run from poll to post, my lord, without telling anything, without giving any information.
Poll to post. Don't worry. Yes. The petitioner submits that the petitioner is not aware of what has become of her application. The state should have communicated to her as to what has become of the application or called for interview. Impose costs on you. Called for interview. The learned counsel appearing for respondents 3 and 4 submits the applications are processed. The petitioner is found ineligible. The appointments are already made and others are working. It is the petitioner should have known that her appointment has not come through if all others are appointed. Finding no merit in the petition stands rejected.
My lord, I was the.
ಇನ್ಮೇಲೆ ಹೇಳ್ತೀವಿ ಮೇಡಮ್, ಮನೆಗೆ ಬಂದು ಕೊಟ್ಟೋಗಕ್ಕೆ ಏನಾಗಿದೆ ಅಂತ. It is public employment, everything is in public domain. Yes, next.
Seal number 9, Prithvi KS.
Petitioners here, my lords, has submitted representation, my lords.
For what, sir?
My lords, acquisition, my lords, originally, my lords, in the name of father of the petitioners. The compensation has been granted, my lords.
Father has received, your lordship.
Now separate compensation.
Illa, that I have to verify, my lords, whether compensation has been
Received, your lordship.
Illare father would have fought in his lifetime. Why worries?
They have not filed a statement, my lords, pursuant to my.
ಈಗ ನೀವು ಫಾದರ್ ಯಾವಾಗ ಹೋಗಿದ್ದು?
My lords, that is, my lords, father has been died, my lords, in the year 1982. Thereafter, my lords, we have submitted representation. Additional.
1990?
Father has been died in the 1982, my lords.
82? Oh, ಆಮೇಲೆ acquisition ಯಾವಾಗಿಂದು?
My lords, acquisition of the year, my lords, 66, my lords. No, that's why, my lords, we have additional.
ಇಂಥ ಕೇಸ್ಗಳೇ ಪೆಂಡೆನ್ಸಿ ತೋರಿಸ್ತಾ ಇರೋದಿಲ್ಲ.
ಇಲ್ಲ, I have, my lords, only in application also have.
ಏನಾದ್ರೂ ಕೇಸ್ ಇದೆ. If father had not received compensation, would he have not fought 66 to 82? ನೀವು ಮಕ್ಕಳು ಆಮೇಲೆ ಬಂದು ಗೊತ್ತಾಗಿ 2023 ಅಲ್ಲಿ ಫೈಟ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇತ್ತಾ?
As per, if they produce, my lords.
Sir, why should they produce? ಎಲ್ಲ ಗವರ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾ? Everything government has to do.
ಅಲ್ಲ, ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು ನಾನು ವಿಡ್ರಾ ನೋಡ್ತೀನಿ, my lords. ನಾಳೆಗೆ ಇಟ್ರೆ ನೋಡಿ.
ಕರೆಕ್ಟ್. ಮೊನ್ನೆ ಯಾವ್ದು ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು, ಏನಂದ್ರೆ ಮನೇಲಿ 2 kilograms ಗೋಲ್ಡ್ ಕಳುವಾಗಿದೆ, CBI ರೆಫರ್ ಮಾಡಿ ಅಂತ. ಅದಕ್ಕೆ ಕೇಳಿದೆ FBI ಬೇಡವಾ ಅಂತ. ಹಿಂಗೆ ಎಲ್ಲ ಗೌರ್ಮೆಂಟೇ ಮಾಡ್ಬೇಕು.
ವೆರಿಫೈ ಮಾಡಿ ನೋಡಿ ನಾನು.
ಏನ್ ನೋಡ್ತೀರಾ? ಏನು ನೋಡ್ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ, ಅದು
Petitioner
ಅವ್ರ್ದೇ.
is before this, petitioners are before this court seeking the following prayer. It transpires that during the lifetime of the father of the petitioner, the lands belonging to the family had been acquired pursuant to the acquisition process initiated in the year 1966. The father of the petitioner did not choose to question any of the proceedings, did not choose to question either grant of compensation, inadequate compensation, or otherwise by knocking at the doors of any fora. After about 50 years of acquisition, the petitioner's legal representatives of the deceased father is before the court seeking a direction by issuance of a writ in the nature of mandamus to grant compensation, as according to them, the compensation was inadequate when the father had received it. ನೀವೇ ಬರ್ದಿದ್ದೀರಾ ಸರ್ ಇಲ್ಲಿ. Learned HCGP on instructions and verification of the records would submit that the father of the petitioner had received all compensation pursuant to the acquisition of the land in the year 1966. There is no warrant to award any further enhanced compensation to the petitioners, the legal representatives, for the same land that stood acquired in the year 1966. Finding no merit in the petition stands disposed.
I have produced, my lords, additional compensation, my lords, which has been granted. Original compensation na produce ಮಾಡಿ.
ಅಲ್ಲೇ ಇದೆ.
ಇಲ್ಲ
ಮೇಡಮ್, ಅವ್ರಿಗೂ ಕೊಟ್ಬಿಡಿ.
Please, Your Worship.
ಆಮೇಲೆ
Seal number 11, MB Reddy, GM Anil Kumar.
ಏನೇನಾಯ್ತು?
Kindly, my lord. I am for the petitioners, my lord. Petitioners for the daily wages laborers, my lord.
Statement of objection, parliament, institute matter.
Institute matter. ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
25 years, my lord, working there. Day group employee, my lord.
25 years.
Since 2000.
ಅನಿಲ್ ಕುಮಾರ್
2 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ಅಂತಿಲ್ವಾ?
At least 1 week's time.
At least ಇಲ್ಲ, not a day's time I will grant. These are regularization matters, I am not granting any time. 30 ವರ್ಷ ಆದ್ಮೇಲೆ ಇದು ಆಟಾಡಿಸ್ತೀರಾ ನೀವು ಎಂಪ್ಲಾಯೀಸ್ಗೆ?
Monday.
Not even one day. What Monday? ಹೇಳಿ.
ನಾಳೆ ಅನಿಲ್ ಕುಮಾರ್ ಅವ್ರು ಮಾಡ್ತಾರೆ. ಟುಮಾರೋ.
ನಾಳೆ
ಅನಿಲ್ ಕುಮಾರ್ ಅವರು ಮಾಡ್ತಾರೆ. JM ಅನಿಲ್ ಕುಮಾರ್.
JM ಅನಿಲ್ ಕುಮಾರ್ ಇದು?
Yes.
Where is he?
ಥ್ರೋಟ್ ಇನ್ಫೆಕ್ಷನ್ ಐತಿ.
ಥ್ರೋಟ್
ಇನ್ಫೆಕ್ಷನ್.
ನಾಳೆ ಸರಿ ಹೋಗುತ್ತಾ?
ಆಗ್ಬಹುದಾ?
ಅವ್ರು ಕಿಮ್ಸ್ಗೆ ಅಪಿಯರ್ ಆಗ್ತಾರಲ್ಲ, ಮೋಸ್ಟ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಅಲ್ಲೇ ತಗೊಂತಾ ಇರ್ತಾರೆ. ನಾಳೆ ಸರಿ ಹೋಗುತ್ತೆ. ಲಿಸ್ಟ್ ಟುಮಾರೋ ಅಂಡ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. Yes.
Seal number 12, HM Dharigon, BS Kamte.
Regularization, alwa?
But after retirement, he made a representation to the department.
For what, sir?
For correction of age.
Back end of service ಅಲ್ಲೇ ಮಾಡೋ ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಬೇಕಾ?
5 years ಮೊದಲು ರಿನ್ಯೂ
ನಿಮ್ಗೂ ಗೊತ್ತು, ಅದಕ್ಕೆ ನಕ್ಕೊಂಡೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Petitioners ಇಂತ ಹೇಳನಲ್ಲ, ಇಂಥವೇ ಪೆಂಡೆನ್ಸಿ ತೋರಿಸ್ತಾ ಇರೋದು ಸರ್. Yes, the petitioner is before this court seeking the following prayer. The petitioner, now 65 years old, is at the doors of this court seeking correction of his date of birth that was entered at the time when he entered service in the year 1975. The petitioner was appointed as a mechanic grade 2 in the year 1975, at which point in time his date of birth was recorded as 1/6/1960. 1955. He retired on attaining the age of superannuation on 31/5/2015. Realizes that he was born late, wanted to grow young, but chose not to initiate any proceeding during his during his service. After retirement, realizes that he wants to go back to service by growing younger. But alas, the law does not permit, as it is right that the That even at the fag end of service, an employee cannot seek change of date of birth, let alone after retirement. The petition lacking in merit stands rejected. Yes.
Seal number 30, Dinesh M. Kulkarni, Vishwanath Hegde.
Regularization?
Yes, my lords. I'm
Ah,
filing
yes, ready.
synopsis, my lords.
Synopsis, good, pretty.
Bill collector, Your Lordship.
Bill collector.
Bill, yes, my lords.
Ah.
Attender come bill collector, my
Yes,
lords.
yes.
Plus, he joined in the respondent number 4 authority
Hmm.
on 10/1/1994.
Hmm.
During the services, the respondent number 4 has never disputed the appointment nor the employment, my lords.
Hmm.
And 2006 to 2008, they have increased my salary by issuing the resolutions, my lords. And then in 2009, my lords, I make a representation to increase my salary according to the government notification, which later on they increase, my lords. This is second round of litigation, my lords. Earlier, there was a writ petition, my lords, filed to consideration of my representation, which was allowed, my lords. Later on, contempt was filed, wherein certain amount towards the arrears of the salaries was given, and the contempt court considered it as a due compliance and closes the contempt. But regularization was unanswered by the respondent number 4. So I prefer this petition, my
This
lords.
petition.
Yes, my lords.
Since how long are you working now?
Well, lords, I've retired in the year 2015, my lords.
No, your claim has been prior to retirement?
Yes, my lords.
2011.
I had made a representation
And
in
Gram
2000.
Panchayat has passed a resolution recommending your case?
Yes, my lords.
That's Vishwanath Hegde.
Yes,
Now the government has to consider.
government has to consider. But my lords, the contention of the respondent number 4 is that in the contempt proceedings, I have received a amount towards the arrears of the salary. So the claim of the petitioner is duly complied, is what they say. But my
Regularization also.
regularization also. But my prayer was in the petition for consideration of the representation. Contempt is only disobedience of the order of the court. It is not the appeal. So it
You
cannot
have
be.
recommended, Allah?
Well, we have recommended, we have paid the arrears in the contempt. My lord, only government has to take a call, my lord.
Correct. When do you take a call?
Once it is entirely answered by plethora of the judgments, I may be permitted to list of authorities, my lords.
Dharm Singh is there?
Yes, everything is there, my lords. And this is one more Supreme
What is
Court.
Vinod Kumar?
That is regarding even if appointment is, and one case of division bench, my lords. Krishna Dikshit or order, my lords.
Justice.
Yes, Justice Krishna. Apologies, my lords.
Madam.
Please, Your Lordship. Because even earlier also, the state government has asked the panchayat to recommend and.
94 adre, even before Uma Devi 10 years ago.
Yes,
Please, Your Lordship.
Entitled to all benefits and.
Yes, my lords.
Wait, we'll pass the orders before I rise, or will reserve and
Yes.
pass the orders.
My lord, direct the state. Navill.
Well, it's injustice anywhere is threat to justice everywhere. I just suggest.
Yes.
But we have complied our part, so my lord, that is not applied to. Please,
I'm not opposing, Your Lordship, but the only thing is 10/5/2013 itself only we have asked to send the proposals.
ಮಾಡಿದೆ.
Okay, so
That is between.
ಮಾಡಿದೆ ಸ್ವಾಮಿ ಅದೆಲ್ಲ.
I have
If it case for,
also, we have
fit case
also-
for a positive mandamus,
Please, Your Lordship.
will pass.
Please.
Obliged.
Seal number 14, Madan Mohan M. Kannur, Pramod Mallur.
Yes, I appear for the petition, my lord. Earlier, lord, the husband of the petitioner was appointed, your lordship, on temporary basis. He approached this honorable court, widening stay, your lordship. And as per the order of this honorable court, your lordship, here the appointment of the petitioner, husband of the petitioner was made permanent. Unfortunately, he died, your lordship. And your lordship, the petitioner as a wife, your lordship, was given the appointment on temporary basis. And she made the application, your lordship, to consider her case for on permanent basis. That is only a sort for.
R3, Your Lordship.
R3 yaru?
Somesha Sahakari Sakkare Karkan.
Represented?
Represented, Your Lordship.
Pramod Mallur.
Pramod Mallur.
ಅವ್ರಿಗೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ವಾ? ನಾಳೆ ಹಾಕೊಂತೀನಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಲ್ಲಿ.
But I think he is not appearing. But
Not appearing.
that time.
Is before this court seeking the following prayer. ಅವರೆಲ್ಲರೂ ಅಪಿಯರ್ ಆದ್ರೆ ಹೇಳಿ.
ಹೇಳ್ತೀನಿ. Because of the, I think he shifted to Delhi or like that.
Petitioner is before this court seeking the following prayer. Heard so and so. The facts in brief germane are as follows. The petitioner is the wife of
Shivaya.
Wife of one Shivaya who was an employee
Third respondent.
of the third respondent who died in harness. Pursuant to the death of the husband, the petitioner submits an application seeking compulsion appointment ಕೇಳಿಲ್ವಾ? ಕೇಳಿದ್ರಿ?
Not that, but an excessive lordship on temporary basis.
Pursuant to the death of the husband of the petitioner was appointed on temporary basis on 22/6/2015. The petitioner is said to be working on temporary basis since then and therefore submits a representation that she has worked for 8 years as on the date of submission of the representation and seeks continuance of her service on permanent basis. The said representation has not merited consideration and therefore the petitioner is before this court in the subject petition. The learned counsel appearing for the petitioner submits that if the direction is issued to the third respondent to consider her case on its merit, it would suffice for the present. In the light of the said submission, without entering into the merit of the claim of the petitioner for continuance on permanent basis, I deem it appropriate to dispose the subject petition with a direction to the respondents to consider the representation, respondent number 3, to consider the representation stroke application and in accordance with law and pass necessary orders thereon within an outer limit of 4 months from the date of receipt of the copy of the order, ordered accordingly.
Number 15, ST Kadakatti, SR Hegade.
The petitioner has given representation to pay the salary arrears, my lord.
ಯಾವ ವರ್ಷದ್ದು ಸರ್? ಯಾವ ವರ್ಷದ್ದು?
He was retired in 2016, my lord.
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯಾವಾಗ?
2020.
4 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ?
He has given several representation, my lord. But
ನೀವು ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನಿಜವಾಗ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿರ್ತಾ ಇದ್ರಿ. ಸ್ಯಾಲರಿ ಇಲ್ಲದೆ ಯಾರು ಇರ್ತಾರೆ?
Arrears, my lord, not the salary, but.
Arrears ಯಾಕೆ?
Why? Because the institute is affiliated to AICT and according to the rules of AICT, he should be given salary, my lord.
Let the representation be considered, your lordship, because as of now, representation date.
ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು?
1 to 4 ಅಂತ ಹೇಳ್ತಾರೆ.
1 to 4.
5 and 6 has to forward.
The petitioner is before this court seeking the following prayer. The petitioner is an employee of the VTU and retires on attaining the age of superannuation. The claim of the petitioner is for arrears of salary. The arrears of salary having sprung from the difference of payment that he was getting qua the entitlement under the AICTE pay scales. Therefore, the petitioner submits a representation seeking the said claim. That has not been considered on the score that there is no recommendation made by the VTU to the state to consider any such representation. In the light of the said circumstance, I deem it appropriate to direct the respondents 5 and 6 to consider the representation and pass necessary orders in accordance, representation and make a recommendation in accordance with law if the entitlement of the petitioner would be in real time to the state, and in the event such representation comes about to the state shall pass necessary orders thereon in accordance with law, answering the grievance stroke prayer of the petitioner, ordered accordingly. Yes.
ST Kadakatti, SR Hegade.
My lord, the new encashment has been not given, my lord. The amount is given, but the interest is not being given, my lord.
Interest?
Please, my lord.
ಯಾವಾಗ ಕೊಟ್ರು, ಯಾವಾಗ ರಿಟೈರ್ ಆದ್ರಿ?
Annexure J, my lord, page number 19.
Dates.
6/4/2018.
Retired.
Retired in 2016, my lord.
Why interest late ಆಗಿದ್ದು ಯಾಕೆ?
They were paid, my lord, but the interest is not paid. Earlier there was a writ petition, my lord, on compliance. They had paid the encashment, but the interest is not paid, my lord.
Yes, madam.
3 and 4, your lordship, as per prayer, your lordship.
17th fresh matters. Next.
Number 17, Vishwanath V. Badige, VR Bhagwan.
Lakshman appearing for petitioner. Petitioner seeking to direct writ of mandamus directing to respondent number 2 and 3. Consider my representation, Lordship.
For what?
On the ground of inconvenient ground.
Ground, Lordship.
Compassionate appointment.
Yes, Lordship.
Yes, Lord.
ಯಾವಾಗ ಡೇಟ್ ಡೆತ್?
Expired date is 19/12/2020, Lordship.
PDS transfer. Compassionate, covered.
Covered, Lordship.
ಎಲ್ಲಿದೆ ಪೇಜ್?
ಅಲ್ಲ, compulsion appointment, Lordship, please.
Appointment.
Appointment,
Yes, Lordship. On the ground of the petitioner father expired on
2020.
Yes, Lordship.
Yes, Lordship.
Yes, sir.
And for the respondent 2 and 3.
ಯಾರು ನೀವೇ ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ರೆಪ್ರೆಸೆಂಟೇಷನ್?
The respondent number 2 and 3 is under the Companies Act, governed by the Companies Act. And also owned by law and article of association. That's why the petition is not maintainable.
Maintainable. ಅಯ್ಯೋ, Karnataka Food and Civil Supplies Corporation, not maintainable. Anything else? The petitioner is before this court seeking the following prayer. The petitioner is the son of a Group D employee who was appointed in the First Respondent Corporation on 18/5/1990 and dies in harness after about 30 years of service. On the death of the father of the petitioner, within 1 year, the petitioner has submitted a representation seeking appointment on compassionate ground. The said representation is lying with the second respondents 2 and 3 without it being considered. Therefore, the petitioner is before the court seeking a direction for consideration of the representation. The respondent number 2 and 3 would project that the first respondent is respondents 2 and 3 is a corporation registered under the Companies Act. Therefore, it is not entertainable. The said submission is noted only to be rejected. It answers the definition of other authorities under the state under Article 12 of the Constitution of India. Therefore, the petition is entertainable, maintainable and entertainable. And that like there is the corresponding duty of consideration of a representation submitted by the petitioner lies with the second respondents 2 and 3, which they have not done till date. In that light, I deem it appropriate to dispose the petition, directing the respondent 2 and 3 to consider the representation and pass necessary orders in accordance with law at any rate within 4 months from the date of receipt of the copy of the order. The representation shall merit consideration for the purpose for which it is submitted and not, yes, next.
18, Shetty B.
Total ಎಷ್ಟಿದೆ ಮೇಡಮ್ ಇಲ್ಲಿ? 34 20ಕ್ಕೆ ನಿಲ್ಲಿಸಿ ಹೋಗ್ಬಿಡಿದೆ. ಇದನ್ನ ನಾಳೆ ರಿಪೀಟ್ ಮಾಡೋಣ.
On behalf of the respondent, next week, my lord.
ಯಾವ್ದು ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್
18.
ಏನ್?
Counsel for the petition also, respondent also informed.
ಏನಿದೆ?
Yes, my lord.
Only for consideration of my lord.
ಎಲ್ಲ ಕನ್ಸಿಡರೇಷನ್ ಹಾಕ್ಸಿರೋದು.
Representation, my lord, we can.
24
years of my lord service.
Friday.
List the matter on Monday, fresh matters.
Number 19, K. Anand Kumar, Ravi S. Balikar.
I am for the petitioner.
For the respondent, read petition,
My lord,
lords.
the petitioner is a PE teacher, my lord.
Yes,
He was
petitioner.
retired on 30/11.
Earlier, a read petition was filed by the various gentlemen.
Gentleman. All right.
6 months, just 3-4 months before. This
ಏನಾಗಿದೆ ಅದು?
petition has been dismissed, holding that a writ of mandamus could not be issued against a person and a society. Again, a writ petition is filed. It is identical prayer.
ಅಲ್ಲ, ಇನ್ನೊಂದು representation ಕೊಟ್ಟು ಮಾಡಿದೀನಿ, ಅದು
Question is, that's
representation
one thing.
ಕೊಟ್ಟು ಮಾಡಿ.
On merit,
DDPI ಹೆಡ್ ಮಾಸ್ಟರ್ ಇದು ಏಡೆಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್.
Aided institution.
ಮತ್ತೆ ಏಡೆಡ್ ಯಾರು ರಿಟ್ ಬರಲ್ಲ ಅಂದವ್ರು ಕೊಡಿ ಇಲ್ಲಿ.
that's one thing. Second is not.
ಅಲ್ಲ, ಒಂದ್
already
ಥಿಂಗ್
it is-
ಫಸ್ಟ್ ನೋಡ್ಬೇಡ, ನೆಕ್ಸ್ಟ್ ಥಿಂಗ್ ಆಮೇಲೆ.
Already it is considered and we have submitted the
ಒಂದೇ
papers.
ನಿಮಿಷ ಸರ್. It's an educational institution, aided. ಯಾಕೆ ರಿಟ್ ಬರಲ್ಲ?
Papers were to be submitted to, my lords, pension papers were to be submitted after superannuation. The problem for this,
ಸೂಪರ್ಯಾನಿಟ್ ಆಗಿದ್ದೀರಾ?
yes.
Please, my lord.
ರಿಟೈರ್ ಆಗಿದ್ದೀರಾ?
Retired 2021 ದಲ್ಲಿ ಆಗಿದೆ.
ಪೆನ್ಷನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಇನ್ನ pension ಇದೆ.
Papers submit ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಯಾರು ಪೇಪರ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ಬೇಕು?
My school, my lords.
ಯಾವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ?
ಮಾಡಿದಿರಿ.
ಯಾವಾಗ ಮಾಡಿದ್ದೀರಾ?
Lord, it has been done in 23 itself. immediately after.
Government ಮಾಡಿದೀರಾ?
Sir, government.
Madam,
The problem is, he has got
pension
two wives.
ಕೊಡ್ತೀರಾ?
Problem is, he has got two wives. He is not able to answer
My lord.
who should be his successor. There is a order passed by the
ನೀವು ಜಲ್ದಿ
jurisdictional
pensions
court.
ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ third wife will come.
My lord, kindly see.
Sir,
my lord,
ಅವರು
I filed a
explanation ಕೊಡ್ತಾ ಇಲ್ಲ.
maintenance petition before this honorable court, my lord. In that that criminal petition, this honorable court direct to the.
ನೀವೇನ್ ಬ್ಲಾಕ್ ಎಜುಕೇಶನ್ ಆಫೀಸರ್?
ಅವ್ರಿಗೆ ಈಗ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆ
ಅವರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಿ. ಶಿ ಇಸ್ ಆಲ್ಸೋ ಕಂಪನಿ.
ಮುಂಚೆ ಇದಕ್ಕೆ BDO ಅಂತ ಇದ್ರು.
ಈಗ BEO.
ಮುಂಚೆ ಬ್ಲಾಕ್ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫೀಸರ್. ಎಲ್ಲ ಕಡೆ ಡೆವಲಪ್ಮೆಂಟ್.
ಪ್ಲೀಸ್. ಅದರಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಸಹ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಮೌಂಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಪೆನ್ಷನ್ ಕೊಡ್ರಿ ಅಂತಂದು.
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್. ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್.
ಯಾರಿಗೆ ಕೊಡಕ್ಕೆ? ಫಸ್ಟ್ ವೈಫ್, ಸೆಕೆಂಡ್ ವೈಫ್, ಥರ್ಡ್ ವೈಫ್?
ಇಲ್ಲ, ಫಸ್ಟ್ ವೈಫ್, ಫಸ್ಟ್ ವೈಫಿಗೆ 2,65,000 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು. ಪೆನ್ಷನ್ ಕೊಡ್ಬೇಕಾದ ಅದು ಡಿಡಕ್ಷನ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಕೊಡ್ರಿ ಅಂತಂದು BO ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವು ಮಾಡೋ ಕೆಲಸಕ್ಕೆ ಎಷ್ಟು ಹಿಂಸೆ ಗವರ್ಮೆಂಟ್ಗೆ, ಕೋರ್ಟ್ಗೆ.
There is a order by the jurisdictional magistrate ordering 5,000 maintenance to the first wife permanently. That was arrears. The money my friend was submitting is, he did not pay anything. That is a maintenance, arrears.
ರಿಟೈರ್ ಆಗಿದ್ದೀರಾ?
Retired
ಯು ಆರ್ ಹೆಲ್ದಿ.
ನಮ್ಮೆಲ್ಲ ಯು ಆರ್ ಸಫರಿಂಗ್ ಶುಗರ್ ಮೇಲೆ, ಹಾರ್ಟ್ ಪೇಷಂಟ್ ಮೇಲೆ.
ಸ್ಟ್ರೆಸ್ ಹಾರ್ಟ್ ಪೇಷಂಟ್.
ಹೌದು.
ಆಬ್ವಿಯಸ್ಲಿ ಈ ಸಿನಾರಿಯೋ ಅಲ್ಲಿ ಮತ್ತೆ ಅದೇ ಆಗದು.
ಫಸ್ಟ್ ವೈಫ್ ಆಲ್ಸೋ ಗಿವ್ ಎವಿಡೆನ್ಸ್.
ಫಸ್ಟ್ ವೈಫ್
ಹೌದು.
ಇಲ್ಲ, ಅವ್ರು ಯಾರಿಗಾರು ಇಟ್ಸ್ ಹಿಸ್ ಲೈಫ್.
ಅದೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. ಮತ್ತೆ ಫಸ್ಟ್ ವೈಫ್ ಹೆಸರೇ ಸೇರ್ಸ್ರಿ ಅಂತ ಹೇಳಿದ್ ಕೊಟ್ಟಿದೀವಿ ನಾವು.
ಆಸ್ ಪರ್ as
ಡಿಸ್ಪ್ಯೂಟ್ ಏನಿಲ್ಲ.
ನೀವು ಹೇಳಿದ ಸರಿಯಾಗಿ
ಡೆತ್ ಆದ ತಕ್ಷಣ
ಹೆಲ್ದಿ ಅಂದ್ರೆ ಅಯ್ಯೋ ಶುಗರ್ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಹೌದು. ಆಪರೇಷನ್, ಮೇಜರ್ ಆಪರೇಷನ್ ವಾಸ್ ಆಲ್ಸೋ ಇದು.
ಹೌದಾ?
ಹೌದು.
ಎಸ್.
Papers are already submitted. My department has.
Madam, ಇವ್ರಿಗೆ ಪೆನ್ಷನ್ ಕೊಡೋದು ಯಾರು ಕೊಡ್ತೀರಾ ನೀವು? ಈ ಸಫರಿಂಗ್ ಏನು ಎರಡು ಇಬ್ಬರಿದಾರ ಇಲ್ವಾ ಅಂತ ಕ್ಲಿಯರಾ?
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವರು
ನಿಮಗೆ ಯಾವ ತರ ಕ್ಲಾರಿಟಿ ಬೇಕಾಗಿ ಕೊಡ್ತಾರೆ ಮೇಡಮ್ ಅವರು? ನೀವು ಒಂದು ಕ್ಲಿಯರ್ ಆಗಿ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಡಿ, ಯಾವ ವೈಫ್ಗೆ ಏನ್ ಹೋಗ್ಬೇಕು ಅಂತ.
ಇಲ್ಲ, ನಮ್ದೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಅವರು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟಿದ್ರು ಫಸ್ಟ್ ವೈಫ್ ಪೆನ್ಷನ್ ಇದರಲ್ಲಿ ನನಗೆ ಹೆಸರು ಸೇರ್ಸ್ರಿ ಅಂತ. ನಾವೇನು ತೊಂದ್ರೆ ಇಲ್ಲ, ಸೇರ್ಸಿ.
ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ಅಲ್ವಾ?
ಗವರ್ಮೆಂಟ್ ಸರ್.
ಮತ್ತೆ 2 ಸರಿ ಮದುವೆ ಹೆಂಗಾದ್ರಿ?
ಮೊದಲೇ ಆಗಿದೆ. ವಿತ್ ಕನ್ಸೆಂಟ್ ಅಂತ.
ಕನ್ಸೆಂಟ್ ಕಾಂಟ್ರಿ ಟು ಲಾ ಇಸ್ ನೋ ಕನ್ಸೆಂಟ್ ಸರ್. ಹಂಗಂದ್ರೆ 10 ಆಗ್ಬಿಡ್ತಾರೆ. ಹೌ ಡಿಡ್ ಯು ಮ್ಯಾರಿ ಟ್ವೈಸ್?
ಲಾಂಗ್ ಬ್ಯಾಕ್ ಮೇಲಾಡಿ.
ಮಿಸ್ ಅಡ್ವೆಂಚರ್.
ಹೌದು.
ಲಾಂಗ್ ಬ್ಯಾಕ್.
ಹೌದು.
ಇಟ್ಸ್ ಎ ಮಿಸ್ ಅಡ್ವೆಂಚರ್.
ನಿಮಗೆ ಹೆಂಗ್ ಗೊತ್ತದು?
ಮೇ ಬಿ the way he is put in a predicament.
ಅಡ್ವೆಂಚರ್ ಓಕೆ, ಮಿಸ್ ಅಡ್ವೆಂಚರ್ ಹೆಂಗ್ ಗೊತ್ತು?
ಇಲ್ಲ, he is in all sorts of trouble.
ಕರೆಕ್ಟ್. ಮಿಸ್ ಅಡ್ವೆಂಚರ್, ಆಲ್ ಸಾರ್ಟ್ಸ್ ಆಫ್ ಟ್ರಬಲ್.
ನಮ್ದೇನು ತೊಂದರೆ ಇಲ್ಲ. ಫಸ್ಟ್ ವೈಫ್ ಇದರಲ್ಲಿ ಡೆತ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಲಕ್ಕೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ.
ಫಸ್ಟ್ ವೈಫ್ ಇದಾರಾ ಇಲ್ವಾ?
ಇದಾರೆ.
ಇಬ್ರು ಇದಾರಲ್ವಾ?
ಹೌದು. ಅದರಲ್ಲಿ ಅದು 2 lakhs.
ಮತ್ತೆ ಕೇಳಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಾರು ನೀವು ಫಸ್ಟ್ ವೈಫ್ ಡೆತ್ ಆದ್ಮೇಲೆ ಅಂತ.
2,65,000 rupees ಕೊಡ್ಬೇಕಾಗಿತ್ತು. ಪೆನ್ಷನ್ ಆದ್ಮೇಲೆ ಡಿಡಕ್ಟ್ ಮಾಡ್ಕೋರಂತಂದೇ ಆರ್ಡರ್ ಇದೆ. ನಾವು ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕಿದೀವಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಇಬ್ರು ಸೇರಿ.
No, as far as my school and management is concerned, we have submitted the papers to the department.
Madam.
Now the ball is with the department.
What? All right.
They have to consider.
We'll consider your lordship if all the objections raised by the department. Objections, if any, let him answer, your lordship will consider.
Please, ma'am.
Representation ಕೊಡಿ.
Please.
ಏನಾರು ಆನ್ಸರ್ ಕೇಳಿದ್ರೆ ಕೊಡಿ.
Please.
The petitioner is before this court seeking the following prayer. The petitioner, a retired employee now, a retired physical education teacher.
Please.
ಮತ್ತೆ BEO ಅಂದ್ರೆ
BE.
Physical education teacher.
Please.
Is before the court seeking grant of pension on account of the fact that he is not granted pension at the hands of the respondents. The issue is that there are 2 wives claiming to the pension of the retired physical education teacher. The learned counsel for the petitioner submits that both the wives have together filed a joint memo with regard to what?
First wife.
Joint memo andre?
Ayo, petitioner first wife.
petitioner has placed a memo before the court in the earlier proceedings that with regard to distribution of the terminal benefits between the wives. The learned counsel for the respondent institution submits.
4 and 5.
4 and 5 submits Mahakali Education Society, submits that the papers of pension have been already furnished to the state in the same has not yet been processed. The learned HCGP submits that if reasonable time is granted, the papers of the petitioner would be processed and adequate remedy and appropriate orders would be passed and granting pension if not already granted. It is open to the respondent state to solicit any kind of documents necessary from the hands of the petitioner. The action shall be taken with an outer limit of 4 months from the date of receipt of the copy of this order, ordered accordingly.
Please. R4 and R5, we have done our job.
Very good. You have no adventure now. Yes.
Absolutely.
Yes, sir.
Number 20, Measures Gowda Associates, Girish Rathod.
20 ಆದ್ಮೇಲೆ next ನಾಳೆ ತಗೊಳ್ಳೋಣ ಇದನ್ನ ಬೇರೆ first list ಕೊಡೋಣ.
For respondent number 2, my lord.
This is a case, your lordships, by interim order, permitted my applications to be considered.
By my order?
Yes, my lord, the order dated.
2023 order?
Yes, now today, my lord, I am informed, the process has been taken. Today, yesterday, they have, my lord, uploaded the provisional selection list.
ನೀವು select ಆಗಿದ್ದೀರಾ?
ಅದ್ರಲ್ಲಿ ನಾವಿದ್ದೀವಿ.
Close ಮಾಡೋಣ?
No,
if there is anything, you file the petition if need arises.
No, now in pursuance of the order of your lordships, my lord, they have considered.
Yes. List this matter immediately after vacation. The learned counsel Sunil Desai submits pursuant to the interim order the petitioner participated in the selection process and his name figures in the provisional select list. Yes. ಆಮೇಲೆ ಇದು ಡಿಸ್ಮಿಸ್ ಆದ ತಕ್ಷಣ ತೆಗೆದು ಬಿಡ್ತಾರೆ ಲಿಸ್ಟ್ ಅದಕ್ಕೆ. Yes.
List number 1.
ಅದು 230 matter ತೊಗೊಳ್ಳಿ.
Bangalore bench matter. Further hearing, serial number 1. Lakmapur Mat. Murgeshwi Charati.
Respondent.
Respondent number 23 and 42-51, my lord.
Respondent 3 and 4, my lord.
Respond number 12 to 14, my lord.
ಎಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದೀರಾ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
Lordship, this is the matter wherein Mr. Chinandanaya.
Petitioner ಅಲ್ಲಿ
Mr. Chinandanaya had mentioned that he had mentioned that some other petitioners. Some other petitioners would want to complete their arguments. This is only on the issue of the void agreement. Anything subsequent to notification would be void. Therefore,
by my order.
In fact, in that, your lordship, that was one step ahead where they had cancelled that agreement. In ours, there's no such cancellation. Nevertheless, in Supreme Court's judgment itself, on the very same petitioner, Supreme Court has there's a finding, his application, intervention application, Supreme Court says, whether it is under Specific Relief Act or whether under Land Reforms Act or any other act, he will not be entitled to any relief. Supreme Court also said these agreements are all void. So nothing much left in this, your lordship. It was unnecessarily dragged on till date only to state that there would be other petitioners. An interim order is affecting all of us, your lordship.
Yes, madam.
Your Honor, I have the connected matter, your Honor. Petitioner.
Argue ಮಾಡಿ.
Your Honor, the senior is in other court, your Honor. He is in court hall.
I'll vacate the interim order. Interim order was granted only for the reason of a settlement that could be arrived at antashte. Otherwise, there was no case.
And that settlement, last time they had already rejected, they made a clear submission before this court. We are not interested in the money. They don't want the money.
Oh, they don't want the money.
They don't want the money. In fact, Mr. Chidananaya, I mentioned to your lordship. Your lordship, out of consideration, said, all right, let them. They don't want the money. He said, we don't want money, we want an order on merit.
Money, they don't want.
There, without any merits, Your Lordship, this matter has been, Your Lordship, might I request, if it is reserved, whatever written arguments they want to submit, they could submit. We will also file all our judgments along with it, Your
File a
Lordship.
written both of file a written arguments, madam. I've heard you enough.
Please.
Yes. Next.
Seal number 2, Poonam S. Patil, Sumana.
Kindly pass on, my lord. Is held up, my lord. In total.
ಈಗಿದ್ರಲ್ಲ ಮೇಡಮ್
ಎಲ್ಲ 6 ಅಲ್ಲಿ held up ಆಗಿದ್ದಾರೆ. Pass.
6
Total 6, my lord. Total 6.
Yes.
Seal number 3, Prakash M.H.
ಇದು list on 9th January for further hearing at 2:30 p.m. ತಗೊಳ್ಳಿ.
List number 1. List number 1, preliminary hearing in B group at 2:30, seal number 194, Srinande Pachapure.
AG ಅವರೇ, ನಿಮ್ದೇನಾ ಮೊಬೈಲು?
ನಮ್ದಲ್ಲ ಸರ್.
ನಿಮ್ದಲ್ವಾ? ಸರಿ. 2:30 ಯಾವ್ದು?
Please. 194.
ಕಣ್ಣೂರು ಸರ್ ತಾನೆ?
Please.
ಹಾ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮಿಕ್ಕಿದ ಮ್ಯಾಟರ್ ನಾಳೆ ರಿಪೀಟ್ ಮಾಡ್ಬೇಕು. ಉಳಿದಿದ್ದ ಮ್ಯಾಟರ್. ಎಸ್. ನಾಳೆ ಸ್ವಲ್ಪ ಮ್ಯಾಂಡಮಸ್ ಮುಗಿಸ್.
Age will appear, Your Lordship.
Ask him to come. Yes, sir.
Yeah, Lord, the matter, my lord, the petitioner, Lord, they had 24 acres, which, my lord, they had got through SHLC, and they put up a sponge and iron factory there. Sponge and iron.
Sponge and iron. Yes, sir.
Lord, then
ನಾನು ಸ್ಪಾ ಫ್ಯಾಕ್ಟರಿ ಯಾವ್ದಪ್ಪ ಆಗೋಯ್ತು.
it would have been very interesting if such a thing.
That is what innovative thought. Yes.
So then, my lord, they acquired another 19.34 acres of land. After the sale deeds were executed, KIDB sought to acquire a larger extent of land of about 4,000 acres of land. In that, this was part of, this 19 acres was part of that. Subsequently, my lord, they, the beneficiary, that is ArcelorMittal, my lord, they gave up a portion
ಇದು
of...
ArcelorMittal da?
ಇಲ್ಲ. ನಾನು, my land which was sought to be acquired. So what happened, my lord, was that since we had challenged the notification, preliminary and final notification, they said that since there is violation of 79A and B, my lord, by order, it was, our thing was saying that you have no right. Ultimately, my lord, it was set aside, 79A and B was struck, then our review petition was allowed, then that's how the writ is now being taken up for hearing. So, my lord, now, if your lordships were to see, ArcelorMittal, who is the beneficiary, they have said that we don't want this land. They have given a letter, and in the order also, my lord, they have, this honorable court has recorded the submission of, my lord.
Why is it pending since 12?
Yeah, beg your pardon.
Why is it pending since
No, my lord,
2012?
because after that, my lord, 79A and B, my lord, the single judge, my lord, allowed the writ petition filed, saying that it could not have been forfeited. Subsequently, my lord, the state filed a writ appeal. My lord, the writ appeal came to be dismissed, and by that time, my lord, it was struck down from the statute book 79A and B. Then, my lord, the review petition was filed. Review came to be allowed, and writ petition was restored. That is the reason why there was this delay. Now, here, now, my lord, what has happened is, KIDB, my lord, out of that 4,000 acres of land, the ArcelorMittal, my lord, they said that before the Honorable Supreme Court, they said that we don't want about this 2,000 acres of land. And they said this 19 acres of land, that which belongs to us, they said we have not got possession. We had an interim order. We are in possession. They said we don't want this land. And even before this honorable court, my lord, the learned advocate appearing for ArcelorMittal, my lord, there is this honorable court has recorded that they don't want that land. If your lordships were to see the order.
Yes, last time you have shown it.
Beg your pardon?
Last time
Yes,
you had shown
we have
that.
also filed our, my lord, even before the honorable Supreme Court, now the only question that would come up, my lord, where the learned AEG, my lord, would come in to say that since it has been acquired, it vests with the government, it cannot be given back to us. But the Honorable Supreme Court in ArcelorMittal case, I have produced that document also. They have very clearly said that this is not been acquired for any public purpose. This is only for the company. So, my lord, if the company doesn't want, and my lord,
Goes back to the landowners.
yes, my lord. So, like, and it's only 19 acres of land, my lord, out of total of 4,000 acres of land. And we have already, my lord, set up, and for our expansion, this is the land which we needed. In fact, if you, my lord, I've also filed, my lord, points for consideration, my lord. We given all the details and given the judgment, my lord. I'll not bother your lordships to that. But if your lordships were to only see the the memo which we had filed, where, my lord, before the Honorable Supreme Court, my lord, they have said that we don't mind forfeiting 270 crores, ArcelorMittal, my lord, because they had not paid, so they didn't want, the prices have gone up. So they don't want the land, my lord. KIDB has nothing much to say before your lordship, my lord, because it was only meant for them. Now the government, my lord, they have filed certain judgments which would say that it is, if it would vest, but my lord, that also I can distinguish and say that that would not be applicable to this. Because in ArcelorMittal itself, my lord, the Honorable Supreme Court and number of things they have very clearly mentioned. I'll just take your lordships to that, my lord.
ಯಾವ page ಅಲ್ಲಿ ಇದೆ?
Beg your pardon?
ಯಾವ page ಅಲ್ಲಿ ಇದೆ?
I'll just point. But it's with the amended petition, my lord, annexure J, page 190. But I'll just, my lord, just very quickly, I'll just read a few points. Act notifying lands totally ad measuring 4,993.65 acres specifically for acquisition for the purpose of development of respond number 3, that is ArcelorMittal company, ArcelorMittal India beneficiary company. The final notification under subsection 4 of the act was issued on so and so, which again specifically mentioned that the land subject matter of the notification are being acquired for the benefit of the beneficiary company. As a result of the notification under section 4 of section 28, the total land measuring 4,864 acres vested in the state government by virtue of so and so. Then, my lord, subsequently also.
Dharwad the matter.
Beg your pardon?
This is Dharwad matter, right?
Oh, the Dharwad matter. So, my lord, then at page 194, then they also, the Honorable Supreme Court says, apart from that, there is an agreement dated 2/6/2012 executed by and between the beneficiary company and the board, which contains clauses 5. The said clause incorporates obligation of the beneficiary company to pay the enhanced land compensation as per the decree of the competent court. The agreement also records that initial compensation has already been paid, deposited by the beneficiary company.
Now, the beneficiary does not want the land?
Yes, they don't want. They very clearly, my lord, they have written a letter.
When?
My lord, they have written a letter. I'll just point that out. Letter written, that is as per annexure H. That is page 189. On 22/11/2017.
Saying what?
Well, I'll just read that now. They write to the chief executive member KIADB. As you're kindly aware, ArcelorMittal has received the allotment letter and possession certificate of 2,659.75 acres of private land from KIADB. Out of this, area of physical possession of survey number so and so to an extent of 2 acres was not taken by the company due to existing ancestral samadhi of landowner so and so. Survey number 902 and 907 to the extent of 19, this is which belongs to us, belonging to Agarwal Sponge, that the petitioner, in respect of which court case is pending before Honorable High Court of Karnataka. Further, some portion of our land at Kurtini village, which is the national highway so and so, has acquired 16.53 of land for diversion bypass road connecting so and so. We therefore request KIDB to allocate an equal area of 37 acres of alternate land in KIDB industrial area located adjacent to the southwestern project layout. So they said that we don't want.
Alternate land kottidara.
Illa avrige subsequently, my lord, before the Honorable Supreme Court, my lord, in fact, they say we don't want this land.
Aithu alternate land adu alternative bad one.
Illa beda avrige 270 crores now beda adu forfeit adru chinte illa anta. They don't want those 2,000 acres of land also now. Because 4,000 odd acres ittu, they are not able to probably pay the prices having gone up and all that. So this land, my lord, and this is not, my lord, it is outside also, my lord. So this is not coming in the way. And I can understand if, my lord,
The
KIDB.
compensation is paid to you, is it? Landowners compensation ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ, ಕೆಲವರು farmers ಗೆ ಅದು ಕೊಟ್ಟಿಲ್ಲ. That's what also the Honorable Supreme Court records, that the compensation also has not been paid to them. So they are not paid and this is, my lord, separate. It is not that it comes in the center or something like that, my lord.
Why is it pending since 12 then?
No, my lord, as I said, my lord, earlier.
Put in the ವಾಪಸ್ ಬಂದಿದೆ.
ಅದೆಲ್ಲ division bench order ಆಗಿ ಎಲ್ಲ ಆಗಿ ಬಂದು then review we had to file, saying that on this ground it had to be recalled. After that, my lord, the writ petition. So we have challenged the preliminary and final notification.
Yes, Keshwar,
My lord,
beneficiary
my lord,
land
page
ಬೇಡ ಅಂದ್ರೆ
202. My lord, if your lordship were to take page 202 of the order of the Honorable
I'll get back to you.
Yes.
Keshwar, if the beneficiary is not wanting the land,
Please,
and it is
my
for a company,
The
not for
proposition
public
of law, my
purpose.
lord, I will place before your lordship.
ಅಷ್ಟೇ.
As per KIDB Act, my lord, once section 4 notification, that is the final notification, is issued, it vests with the government. My lord, there is a judgment, my lord, to show that when once it is vested, it cannot be reverted back to the owner. It
For
can be at best,
for
can be
whatever
used.
purpose the acquisition is.
Yes, my lord. It was for an industrial purpose, to set up an industry. He don't wanted to set up his industry there.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ?
But the
ಈಗ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
Allah, we are, my
The-
lord,
the-
for
the law is
expansion
well
of the
settled, my
existing
Law is
factory.
all right, but what is land
My lord, because
land
this
is
could-
vacant?
Yes, my lord, because we are for expansion, my lord. This is a Kurtini village, my lord, where all these iron and steel factories are there. So we are also putting up that only.
ನೀವ್
my lord.
ಯಾರು?
Beg your pardon?
ನೀವ್ ಯಾರು? ಲ್ಯಾಂಡ್ ಓನರ್ ಅಂತೂ ಅಲ್ಲ.
Allah, we had purchased the land.
When?
My lord, in the year 2000, we purchased it on 14/11/2007 itself. And the PN and FN was issued in the year 2010.
All right. Yes, sir.
My lord, I will pass on the judgment, my lord.
Please.
Sorry. My lord, ILR 2001, Karnataka 638, my lord. My lord, straight away I will take your lordship to page 644. Here, my lord, the section 28(5) is considered. What will happen, my lord, once section 28(4) notification is issued? In view of the above, the following points arise for consideration. One, you are not concerned, my lord. Two, whether section 11A of the Act applies to acquisition under KIDB Act. So if section 11A of the Land Acquisition Act is not applicable, whether the property is petitioner is entitled for any other relief. Regarding point 2, my lord, page 645. I will read only the relevant portion now. Subsection 1 to 7 of section 3 of the House Sites Act are similar to subsection 1 to 7 of section 28 of the KIDB Act, and in particular, this is 645. That is somewhere in the middle of that para. Subsection 1 to 7 of section 3 of the, they were comparing both, my lord, House Site Act and also
Industrial purpose.
Yes, my lord, KIDB Act. 1 to 7 of section 3 of House Sites Act are similar to subsection 1 to 7 of section 28 of KID Act, and in particular both sections 3(5) of the House Sites Act and section 28(5) of the KIDB Act provides that on publication of the final declaration in the official gazette, the land shall vest absolutely in the state government, free from all encumbrances. It is therefore contended that in the law laid down by so and so, my lord, section 11A of the land should be read. That was their contention, my lord. Next, my lord, I will take your lordship to 646. Decisions of the Supreme Court which hold that section 11A will not apply where the land has already vested in the government. The decision in Mariappa's case was rendered by 2 judges of the Supreme Court, and it's so and so, rendered by larger bench in Satyendra Jain and Pratap. These decisions have held that section 11A will have no application where the land vests in the government absolutely in pursuance of an acquisition, and where there is no provision in the act for divesting the title which has so vested in the government. Section 28(5) of KADB Act provides for such absolute vesting of title in government on publication of the final declaration under section 28(4) of KADB Act, section 11. That's all. Other things are considered. My lord, the law is very clear, my lord. When once 28(4) is published, it is automatically vests with the government. My lord, I have produced certain citations also. When once possession is taken, ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಕೊಡಿ ಕೊಡಿ
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ವಾ ನೋಡಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದರಲ್ಲೂ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಏನು ಫಂಬಲ್ ಮಾಡಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ, KADB and state, they have not even said they have passed an award in our.
ಅಲ್ಲ, it is only purely question of law.
ಶೀಲ್ವಂತರ ಅಪಿಯರ್ ಆಗಿರೋ ಒಂದು ಕೇಸ್
My lord,
12 ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು
my
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ. ಅದಕ್ಕೆ
I don't want to deliberate on that. But anyway, it is a purely question of law. So whether we file the objection or not, my lord, it makes no difference. Your lordship will consider only the question of law.
Correct.
So
Only the question.
according to the cited ಸಿಕ್ತಮ್ಮ,
Cited ಸಿಕ್ತಮ್ಮ.
bunch of citations ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. I have filed, my lord.
ಸರಿ ಸರಿ.
ಓಸಿ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ ನಾನು.
ಯಾವ್ದು ಸಿಕ್ತಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ.
ಅಲ್ಲಲ್ಲ, ನಾನು ಈಗ ಕೊಟ್ಟೆ ಇವ್ರಿಗೆ.
ಅದೇ ಗೊತ್ತಾಯ್ತು, ಸಿಕ್ತಮ್ಮ. ಕೊಡಿ.
ಎಲ್ಲಿದ್ದೀರಿ?
ತಗೊಳ್ಳಿ. ಹುಡುಕ್ತಾ ಇದೆ.
ಇಲ್ಲಿ ನಾನು ಕೊಟ್ಟಿದ್ದು ಕೊಡಿ.
ನಿಮ್ಗೆ ಸಿಕ್ಬಿಡ್ತಾ?
Citations.
Well, we can give our.
ಕೇಶವರೆಡ್ಡಿ ಸರ್ ಕೊಡ್ತಾ ಇರ್ತಾರೆ.
It was 2/4/2025, my lord.
ರವಿ ಕೊಡು.
My lord. Citations, my lord, 2003 1 ACC 335. My lord, para 9 and 12, my lord. I will read para 9 and 12 at page 5. My lord, looking to the facts of the present case.
ಕಂಪೇರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಇದಕ್ಕೂ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಪ್ರಿಂಟ್ಗೂ ಕಂಪೇರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Just 28(1)(2) and num points for consideration ಅದಕ್ಕೆ ಹೇಳಿ ತೋರಿಸ್ಲಿಕ್ಕೆ. This is still referred to the book only, not.
ಸಿಕ್ತಮ್ಮ.
Put up, sir.
Yes.
Please, my lord. I will take your lordship to page 5 of my compilation. There, para 9, my lord. My lord, in the middle of that para, there is no explanation whatsoever for the inordinate delay in filing of the writ petition, merely because full enhanced compensation amount has not been itself, in our view. High Court was also not right in ordering restoration of land to the respondents on the ground that the land acquired was not used for which it has been acquired. It is a well settled position in law that after passing the award and taking possession under section 16 of the Act, the acquired land vests with the government free from all encumbrances. Even if the land is not used for the purpose for which it is acquired, the landowner does not get any right to ask for revesting the land in him and to ask for restitution of the possession. My lord, for the same proposition, my lord, all the judgments are there, my lord. So under these circumstances, my lord, the land cannot be reverted back unless and until, even we cannot also denotify under section 48 because once possession is taken. So my lord, this
in whose possession the land is now?
That is with the KADB.
Symbolic, physical.
My lord,
symbolic
Possession is not, award also has not been passed. In none of the objection they have even
Lord,
said. So even it has not been completed. Award is also not been passed in respect of this land.
when once, like 17, my lord, in the Land Acquisition Act, like the provisions of section 70, when once it is invoked, the possession is also taken there
Gone are
immediately
those,
on the
gone are those
publication.
days, sir.
Yes, my lord. Here
To-
also.
That used to be the law. That used to be the law. ಯಾಕೆಂದ್ರೆ ಅವಾಗ ನೀವು 5 ವರ್ಷದಲ್ಲೆಲ್ಲ ಮುಗಿಸ್ಬಿಡ್ತಾ ಇದ್ರಿ. 25 ವರ್ಷ 30 ವರ್ಷ ಇಟ್ಕೊಂಡು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ law is changing.
In fact, the judgment which my learned friend relied on, that was a case where it was dismissed on the
That is
ground
not
of.
the only case I am depending him. So many other judgments.
ಎಲ್ಲ
have
ಅದೇ
produced.
ಅದೇ ತರದ್ದು ಅಂದ್ರೆ ಮತ್ತೆ
ಅವೆಲ್ಲವೂ ಸೇಮ್ ಅದೇ
ಮತ್ತೆ
ಪ್ರೊಪೋಸಿಷನ್
ಒಂದ್ ಹೇಳಿದ್ರೆ ಆಯ್ತಲ್ಲ.
ಸೇಮ್
ಒಂದೇ ಅದ್ರಲ್ಲಿ ಏನಂತಂದ್ರೆ, it is on the ground of delay in latches, award was passed, possession of the property was taken.
I will take another
The landowner had accepted the
another
compensation.
Another citation.
Yes, there
ಎಲ್ಲ
are.
ಒಂದೇ ಪರ್ಪಸ್ ಗದ್ಮೇಲೆ ಇನ್ನೊಂದು citation ಯಾಕೆ?
ಅಲ್ಲಲ್ಲ, he says that it can be distinguished because it was only on delayed latches. That is not the only judgment. Only the, see the, my lord, law laid down with the Supreme Court, I have only presented before no court.
ನೀವು ಸುಮ್ಮನೆ ಇರಿ ಸರ್. ಎಸ್ ಸರ್. ಅಷ್ಟೇನಾ ಸರ್? ಅಷ್ಟೇನಾ?
ಅಲ್ಲ, law says like this, it is left to your lordship.
You don't say anything? Yes, ಹೋಗ್ಲಿ, you say something.
Nothing much, my lord.
Ayyo.
My lord, I've given my lord, because your lordship's
will
time,
not say
I've given my
anything.
written submission, my lord, points for consideration, and also, my lord, distinguish the judgment, my lord, because this is a case where, my lord, Supreme Court in their own matters, in many of the orders that have been passed, so my lord, very clearly held. I can understand, my lord, when BDA acquires land for public purpose. Here also, my lord, it is not for public purpose. It is only for the company.
ಹೇಳಿದ್ರಲ್ಲ ಆಗ್ಲೇ.
Yeah, that's all.
No, that
So,
is settled, my lord. Even establishment of an industry is for a public purpose. There are judgments. I will produce before this.
4,000 acres for, and now 19 acres, which is.
Interpretation of that
And
provisions.
they've
has been.
gone ahead to.
What you say is not correct.
Because that particular section has been interpreted by the
Because
Supreme
award
Court.
has not been passed. Possession is
What
not
you
taken
say-
till
Even if
today.
award
Till
is
today,
not
award has
passed.
not been passed.
One ನಿಮಿಷ sir. What you say is not correct. The industrial purpose under the KIDB Act, it is acquired. It need not go back to the landowner. If the industry says, I am not setting up an industry there, it can be given to somebody else, some other industry.
So,
Industrial purpose
no,
acquisition
because
is
it is
industrial
not
purpose
being-
acquisition.
my lord, I
It
can.
does not vest back to the
No,
landowner.
true.
Other grounds only we will see.
Yes, no. Here, why I am saying that, my lord, is if, my lord, the entire acquisition was complete, here the acquisition itself has not been completed, award has not been
Yes,
passed.
that is a ground you can urge.
My lord, that we have
doesn't
urged.
change the beneficiary for whom the acquisition single window clear ಆಗಿರುತ್ತೆ. Our industrial set ಮಾಡಲ್ಲ ಅಂದ ತಕ್ಷಣ can it
No,
go back
because
to the landowner? No.
my lord, our first point for consideration is only that with regard to the award not being passed.
That's okay.
Yes.
That you submit, that will consider.
Yes, ma'am.
As Keshav Reddy sir said, it's certainly too rudimentary to say, sir. For acquisition is for the purpose of setting up an industry or private entity. That entity backs out and says, no, we're not going to set up the industry. So give it back to the landowner.
No, my lord, I'm submitting this.
that's
One submission, lord, to an extent, I'll only submit this one. Now, what happens is, when such a large extent of land, now, my lord, if my lord, they had acquired, my lord, then acquisition
Large-
also is not complete.
Large, small, all right. If you have other grounds projected saying that, yes, award is not passed, for possession is not taken.
Yes, ma'am.
Despite 25 years, 30 years, all that you say we will consider.
Yes, ma'am.
But to say that the beneficiary, the industry entity does not want to set up its industry, so give it back to the landowner, unheard of.
My lord, that, my lord,
Industry ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಇಂಡಸ್ಟ್ರಿ ಬರುತ್ತೆ.
ಅಲ್ಲ ನಮ್ದೇ ಇಂಡಸ್ಟ್ರಿ ಇದೆ ಅಲ್ಲಿ ನಮ್ದು. My under that SHLC only state high level clear.
ಯಾವುದೋ ಒಂದು ಇಂಡಸ್ಟ್ರಿ
ಅಲ್ಲ ಇಂಡಸ್ಟ್ರಿ ಬರುತ್ತೆ ಅಂದ್ರೆ ಈಗ my lord, may I just make one small distinction? Now, my lord, most of the time, my lord, KIDB was for earlier, my lord, for the formation of an, my lord, they acquire a land like how BDA acquires for formation of sites. So, my lord, they would make industrial plots and, my lord, call for auction them and call for allotment. That's what they would do. So now in that, if suppose somebody is allotted and they back out, it does not mean it goes, my lord, because the entire acquisition has been completed. Here, my lord, the acquisition is not completed. Award has not been passed. Possession has not been taken. There is no averment either by KIDB or by the government that award has been passed and that has been taken. All these things being there, My lord, now here, when the Honorable Supreme Court, my lord, very clearly, my lord, in 4 times, my lord, even there also, I just wanted to read, even the award has been passed in favor of, it is not for public purpose, my lord, the Honorable Supreme Court has held very clearly in their own matter. So, my lord, if it is not for public
Setting
purpose.
up an industry definitely is said to be for the public.
Well, the court, Supreme Court in their own matter, they have said, if your lordship permits, I'll just read that, my lord.
Well, I thought it anyway doesn't vest back to the landowner. Other lane, I have no doubts about.
Allah, why I'm saying is this.
E-industry and another industry.
Allah, now the industry is already there. It is at a side, my lord. Now if
industry
industry namdu agle nadita ide namdu. So this is, my lord, the next adjoining land only where for expansion which we have sought.
Expansion.
Allah, avaglene now togondidive. This, my lord, PN and preliminary notification, final notification has been issued way after we have purchased the land. So, my lord, and that also, my lord, all the things have been clear. So now what I'm submitting is this, my lord. Now what KIDB will have to do, my lord, now is, I can understand if everything has, it's there. Now they have to still pass awards, give it to the farm, thing from the farmers, and then, my lord, form a layout or allot it to somebody, my lord, when I'm already there. They have not even passed in, my lord, I filed my written submission, my lord, points for consideration.
I will mention because award is not passed. Even that is also covered under this judgment, my lord. In view of the aforesaid ratio, it follows that the provision of section 11A are not attracted in the present case, and even if it be assumed that the award has not been passed within the stipulated period, acquisition of land does not come to an end.
We have produced judgments
even
which
if
say,
award is not passed also.
I'll just read this line.
The old law. It is.
Yes, my lord, here,
if the award
what they have said very clearly, my lord, both the notification clearly laid on that the land was not to be acquired for the purpose of the development by the board. My lord, in this very same case of ArcelorMittal, Supreme Court has said, but for the activities of the beneficiary company, activities, so it is not for public purpose at all. The KIDB, my lord, starts with that for public purpose. So the Honorable Supreme Court has clearly held it is not for public purpose at all. And my lord, the points for consideration, where, my lord, we have also produced judgments.
Acquisition Act.
That, my lord, it will amount to abandonment and think that they don't want that land at all. And, my lord, the Supreme Court has gone to the extent of saying they had an agreement that this would be paid. So, my lord, it was purely between the government and the beneficiary company. So, my lord, mine is 19 acres of land, my lord. I'm already running. My lord, they don't even set up. They don't even do anything. And, my lord, it is not even, I can understand if it was coming in the middle, my lord, and it becomes an island. So even if they were to want the land subsidy, and they themselves, my lord, have written a letter, they have said before this honorable court, my lord, that has been recorded in the order that they don't want this land at all. So, my lord, I have also beg your pardon. These, my lord, are written submission points for consent, and the judgments relied on by learned friend, my lord, we have discussed. So that's all is our argument.
We'll dictate on 17th.
My lords, for a moment, my lord, I represent respond number 2 and 3 board, my lord.
Your moment will come on 17th, madam. Yes. List on 17th.
17th, if I can come on VC.
Oh, please come, sir. ಇದೊಂದಕ್ಕೆ ಬಂದ್ರೆ ಬೇರೆ ಕೇಸ್ ಇತ್ತ ಬೇರೆ ಕೇಸ್
ಇದು ಮೇನ್ ಇತ್ತು ಇದು ಬಂದಿಲ್ಲ
ಆಯ್ತು ಬೇರೆ ಎಲ್ಲ ಇತ್ತು
ಅಲ್ಲ ಇದಕ್ಕೆ ಬಂದಿದ್ದಕ್ಕೆ ಇನ್ನೊಂದಲ್ಲ ಒಂದಿದೆ ಅಷ್ಟೇ ಸೊ ಐ ನಾಟ್ ಲೈ ಟು ದಿಸ್ ಕೋರ್ಟ್ ಮೇಲೆ ದೇರ್ ಇಸ್ ಒನ್ ಮೋರ್ ಮ್ಯಾಟರ್ ದೇರ್
ಮತ್ತೆ ಹೋಗಿ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ ಅಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಆಗಿರುತ್ತೆ
ಮತ್ತೆ
so my lord we have filed all our returns, everything has been filed public.
We'll take it on 17th.
Lordships, sorry to submit your lordships. Previous matter, some technical glitch had happened, could not log in, your lordships.
Madam.
I'm sorry, your lordships. We request your matter to be taken up tomorrow or day after. We will make submissions, your lordships. Your lordships are permitted to file written.
Madam went away and...
Yes, your lordships. There was some technical glitch in connecting your lordships to the Dharwad bench. That's why we could not connect your lordships. Kindly, matter may be called tomorrow or day after. We will argue the matter, your lordships.
No, you file a written arguments. I have heard you, Allah, madam.
Your Lordship, senior wants to make some submission. That's the reason, Your Lordships, I'm requesting just 15 minutes, any time may be given, Your Lordship. Senior will complete the arguments. I'm sorry, Your Lordships, I should not be troubling, but I'm requesting, Your Lordships.
ಆಯ್ತಲ್ಲ ಬಿಡಿ ಮೇಡಮ್. List on 17th.
Lordships, interim order
17th.
granted to be extended, Your Lordships.
Will be extended. Yes. ಅದು ರಿಸರ್ವ್ ಬೇಡ 17th ಅದು. 17th.
Milords,
You
my
inform,
only reserve.
Interim order.
Lakshmi Angar madam. Yes. Inform the senior counsel.
I'll inform, Your Lordships. I'll inform, Your Lordships.
No, madam was
17th.
here. You have to inform.
Yes, Your Lordship.
Yes.
17th at 2:30, Your Lordships.
Huh.
Much obliged, Your Lordships. Interim order to be extended, Your Lordships.
Milords, my point is only that 28(4) is already notified, Milords, and land vests with the government.
Don't worry, madam. On 17th will pass out.
Please, my lord.
ಅದನ್ನೇ ಕೇಳಿದ್ದು ಈಗ ಅವರು. ಅದನ್ನು 17th. Yes.
Sorry, Your Lordship.
continue
I
the list.
inform, Your Lordship.
ಇನ್ನೇನಿದೆ?
Interim order to be extended.
Further hearing 195.
Further hearings, number 195, Vaibhavi Inamda.
Yesterday's matter, my lords.
Date ಅವತ್ತು ಕೊಟ್ಟಿದ್ದಲ್ಲ.
9th, it was 9 January.
ಈ 9th ಹಾಕಿದೆ. List on the date notified in the order was 9/1/2026. Out of inadvertence, the matter is listed today on 9/12. List this matter on 9/1/2026. Interim order subsisting will continue to the next date of hearing.
Obligements.
Still number 196,
For further hearing, my lords.
ಹೌದು.
Uruj Ahmad.
Please, my lords. Please, my lords. Matter pertaining to the payment of gratuity, my lords. Was listed
yes, sir.
yesterday.
My lords, one
Yesterday
submission,
you
my
were
lords.
not there.
Please, my
Please.
lords.
Yes, sir.
My lord, the proceedings before this court, the division bench and the Supreme Court were not on merits as to the computation, my lords. My lord, as per Annexure B, my lords, that was the first order. Against that, my lords, the bank preferred appeal. That was filed without complying sections 7, subsection 7, without depositing the award amount, my lords. That came to be dismissed as not maintainable. Against that order, writ petition came to be filed. In writ petition, my lords, since the provision was mandatory in nature, writ petition came to be dismissed. The same was confirmed in writ appeal. My lord, Supreme Court, the matter went up till Supreme Court. My lord, page number 54, my lords. My lord, the Supreme Court, my lord, ordered, my lord, after addressing some arguments, learned counsel appearing for the petitioner seeks leave to withdraw the present petition. While-
ಗೊತ್ತಾಯ್ತು ನೋಡಿದೆ.
Please, my lord, subsequent to that, the appeal before the first respondent came to be revived. My lord, first respondent stated that insofar as the forfeiture of gratuity, he confirmed the order. He reversed the order of the appellate authority. My lord, the gratuity was computed. In the department inquiry, my lord, forfeiture of gratuity was ordered in the disciplinary proceedings as the petitioner had caused financial loss to the bank. My lord, after deducting the same, 1,85,000 was paid back way back in the year 2012, which is admitted by him. He admits that we had paid amount. Subsequent to that, my lords, he challenged the forfeiture amount and the penal interest imposed on the forfeiture. Then, my lords, the second respondent holds that forfeiture is not permitted. You pay the entire amount. Against that, the appeal came to be filed without compliance of section 7(7). So the proceeding before this honorable court, the division bench and the Supreme Courts were not on merits, my lords. They were only on the point that.
Based on 17th, fresh matters.
Lords,
Please, my lords.
in further hearing, my lords.
Fresh matter 17th, sir.
Please.
December 17th.
My lords, what they are contending is, now, my lords.
17th, sir.
Please,
Yes.
my lords.
Please, my lord.
Highly
Grateful, my
obliged. What's the order? Interim order may be extended.
Interim order subsisting will continue to the next date.
Highly obliged.
List number 3, fresh matter, seal number 1, Abhishek K.
ಕೊಡಿ.
My lord, I appear for the petitioner in this matter, my lord. The petitioner, my lord, is a professor, my lord, in the Department of History in respondent number 2 University.
Where is the report of the internal complaints?
It's at page 15, my lord, extra A. Page 15, my lord, in extra A. 15, my lord. Your Lordships, my lord, the relevant part would be page 16, point number 6, findings of the committee. After reviewing the
Now-
evidence and test. Yes.
One moment. Where is the order of suspension?
Page 46, my lord. Page 46, my lord, dated 21/7/25. They've suspended me.
The act, the KCSCCA ಕೊಡಿ. Heard the learned counsel, Srimati Kirti Reddy, appearing for the petitioner. The petitioner is before the court calling in question an order of suspension under Rule 10(1)D of the KCS-CCA rules. Rule 10(1)D reads as follows. Rule 10(1)D permits the competent authority to place a government servant under suspension on evidence of gross dereliction of duty. The gross dereliction of duty has not sprung from any departmental inquiry or in contemplation of any departmental proceedings. The petitioner is alleged of sexual harassment of a student for close to 6 years. For 6
This, my
years.
lord, just have to point out, my lord, in the inquiry report, it says, my lord, it's consensual.
One minute. The findings of the committee is that the acts between the complainant and the petitioner were consensual. And the recommendation, the finding of the committee at para 6. The recommendation at paragraphs 7 of the said order reads as follows. Here to page 16. If the acts were consensual, it is ununderstandable as to how the recommendation could spring in. Be that as it may, the recommendation is for suspension from PhD guidance for a period of 3 years. What comes about is the suspension of the petitioner invoking Rule 10(1)D. As observed, Rule 10(1)D is not applicable even in the case at hand. Even otherwise, Sub-Rule 3 of Rule 10 requires the competent authority to apply its mind and then pass necessary orders of suspension. There is not even a semblance of application of mind in the case at hand except following the dictate of the committee. In that light, there shall be an interim order of stay as prayed for.
Hand delivery, my lord. Because, my lord, the only urgency is hand delivery, my lord, because now, my lord, they are taking a precipitative action based on that, my lord.
Who is there to give memo? So and so. Notice here, ignore. We'll have it released in the evening, madam.
Please, my lord.
One, Rani Chennamma University.
No, sir, petitioner.
New appear. Counsel Shiraj Mudol is directed to accept notice for respondent 1, 2, emergent notice to the 5th respondent, first respondent, AGA. State it. Yes.
Grateful, madam.
Yes, next.
Petition copy.
Petitioner to serve set of papers upon all the respondents' counsel forthwith.
Please, madam.
Yes, next.
Obliged, my lord.
Yes, next.
Order seal number 2, PG Chikkanargu.
Externment. Eradu, AG, 2 and 3 externment, Surat Saib order. Madam. Bad either. Externment. Yes, yes, post. For 2 and 3.
Seal number 4, Gudwala Sadiq Ali.
ಅದ್ಯಾರು ನೀವೇ ತಾನೆ?
Sadiq and Gudwala, I did Gudwala.
ಅದೇ
My lord, annexure K, my lord, IPS 31. Respond number 2, Deputy Commissioner directed respond number 4 to consider the applications filed by
unauthorized occupation.
unauthorized occupant.
Learned AGA is directed to accept
1 to
notice
5.
for all the respondents. The petitioners, if in possession as on today, shall not be dispossessed till the next date of hearing. Yes, next. ಮುಗಿದೈತೆ ಲಿಸ್ಟ್ 230 ಮುಗೀತಾ? ಏನ್ ಪ್ರಣವ್?
My lord, may I make
ನಿಮ್ದು ಯಾವ್ದು?
105, my lord.
Urgent ಆ?
Surface.
ಸರ್ಫೇಸ್ ಕೊಡಿ.
Yes.
ಮನೆನಾ?
Money. He has availed as car loan, my lord.
ಎಷ್ಟಿದೆ?
10 lakh.
10 lakhs ಕೊಡಿ ಕೊಡಿ. Not 5 ಕೊಡಿ ಮಾಡಿ.
Please.
ಕಾರ್ ತಗೊಂತಾ ಇದ್ರ ಮನೆ ತಗೊಂತಾ ಇದ್ರ?
ಅಲ್ಲ, ಕಾರ್ ತಗೊಂಡಿದ್ದ, ಆಮೇಲೆ ಅದು ಆಕ್ಸಿಡೆಂಟ್ ಆಯ್ತು, ತುಂಬಾಕಾಗ್ಲಿಲ್ಲ.
ಕಾರ್ ಲೋನ್ಗೆ ಏನ್ ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡಿದ್ರಿ?
ಮನೆ.
ಕಾರ್ ಲೋನ್ಗೆ ಮನೆ ಮಾರ್ಟ್ಗೇಜಾ? ಬೆನ್ಸ್ ತಗೊಂಡಿದ್ರಾ?
ಅಲ್ಲ, ಲೋನ್ is of only 10 lakh, my lord. Why they have not?
ಮತ್ ನೀವು ಕಾರ್ ಲೋನ್ಗೆ ಮನೆ ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡಿದಿರಿ ಅಂದ್ರೆ ಬೆನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ.
The petitioner is before this court calling in question 14
My lord.
ಏನ್ notice issued
14.
calling in question an order ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Surface.
Magistrate
My
order
lord,
ಏನು?
at annexure D, my lord.
Called in question a notice issued indicating the amount of loan being in due. It transpires that the petitioner to secure a four-wheeler had mortgaged his house. Four-wheeler vanishes due to accident. House is now being hunted down by the respondent bank under the provisions of the Surface Act. Eštide 10 lakhs?
10 lakhs.
2.5.
Please.
The petitioner shall deposit 2.5 lakhs within the next 4 weeks.
Please.
In the event the petitioner would not deposit by the 2.5 lakhs by the next date of hearing, the interim order would stand automatically vacated, and the petitioner would run the risk of the petition itself getting dismissed. Honor before the 15th of January 2026.
Please, restoration.
List Kara.
ಅಲ್ಲ, ಮನೆ ಸೀಸ್ ಮಾಡಿ.
ಕಾರ್ ಸೀಸ್ ಮಾಡಿದಾರೋ ಮನೆ?
ಮನೆ ಮೇಲೆ.
14 list on 15 January 2026. The moment the petitioner pays the amount of 2.5 lakhs, the bank shall consider restoration of the possession of the house of the petition to the hands of the petitioner.
Please.
ಯಾರು respondent ಯಾರು?
Equitas, Sachin Angdi.
Sachin Angdi is directed to accept notice for the respondent. Next.
Hand delivery. Please.
Memo.
I'll put it.
ಕೊಟ್ಮೇಲೆ
Please.
hand delivery ಕೇಳ್ಬೇಕಾದ್ರೆ memo should be in your hand.
Please.
Serial number 90, my lord. It is rowdy cheater.
Rowdy cheater. ಹೇಳಿ fresh matter ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಇದು fresh.
We'll try because this is meeting at 5 o'clock. I have to get up. ಎಲ್ಲಿದ್ದೀವಿ ನಾವು? ಸೀರಿಯಲ್ ನಂಬರ್?
Seal number 53.
96. All right.
Salary, your lordship.
53.
Please, your lordship.
ಕೊಟ್ಟಿಲ್ವಾ?
62 years, your lordship.
UGC ದಾ?
UGC, my lord.
ಅದೇ ಇಂಟರ್ ಮಾಡೆಲ್ ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಅದು ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
After 62 years, your lordship.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅದು?
ಕೊಡೋದು, your lordship. It is.
ಇಂಟರ್ ಮಾಡಿರೋದ್ರಿಂದ ಕೊಡಲ್ಲ ಅಂತನಾ?
interim order, now they
We
are
will
working,
refer
your
it to the
lordship, let
contempt bench,
the your
madam.
lordship, because it is from the internal sources, government, university will pay. Because now they are taking the work from the petitioners.
Previously, my
Government
lords
has
have
already
already
fixed the
given
62 years, your lordship. It is, matter is pending for consideration up to 65 years, your lordship.
ಹಾಗಾದ್ರೆ ಸೀರಿಯಸ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. 1 ಲಕ್ಷ ಕಾಸ್ಟ್ ಹಾಕಿ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟು ಎಲ್ಲ ಮಾಡಿ ಬೆಳಗ್ಗೆ
Because, your lordship,
ಅಲಂಕೃತವಾಗಿ ಆರ್ಡರ್ ಮಾಡೋಣ ನಾಳೆ ವಿತ್ ಆಲ್ ಎಂಬೆಲಿಶ್ಮೆಂಟ್ಸ್ ಟುಮಾರೋ.
Please, madam.
Fresh matters.
Number 54, Pranav Sukadev, Katagiri.
Lordships, in this case, the petitioner has got the voting rights, your lordships. Voting rights have been granted to the petitioners, and the petitioners have voted in the elections, and elections have been concluded, your lordships.
But the petitioner not challenging.
Your lordship.
Elections concluded ಅಂದ್ರೆ ಅದೇನಾ?
ಅಲ್ಲ ಇದು annual general body meeting challenging.
No, your lordships, I will restrict.
AGM challenge ಅಂದ್ರೆ
I'll restrict my prayer only to the voting rights. Liberty may be reserved to challenge the AGM before the authority, your lordships.
The petitioner is before this court seeking the following prayer.
On submission.
Petitioner would restrict his prayer to his right to vote in the elections. The voting elections are already over, and the petitioner has cast his vote. The learned counsel submits that the other prayer with regard to challenge to the annual general body meeting would be agitated before the appropriate fora. In the light of the said submission, reserving liberty to the petitioner to approach the appropriate fora in the event of him being aggrieved or still being aggrieved by prayer number 2, the petition stands disposed. In the light of the elections being over, the election shall be taken to its logical conclusion. The petitioner is, however, reserved liberty to challenge the same if he is so aggrieved. Accordingly.
Don't pray. Exclude, the counting has to be made not by excluding the votes of the petitioner. But they are not, their name is not appearing in the voter list. They are, by virtue of the annual general body meeting, they are not a member at all. They are loses their membership. Therefore, their name is not appearing either in the provisional voter list or final voter list. And when that is the annual general body meeting, their name has been removed.
ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ
ಅದನ್ನ ಮಾಡ್ಲಿ. Therefore, by excluding their votes, not
ಎಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಅದು ಯಾವ್ದು excluding vote judgment ಬರ್ತಿರಲ್ಲ court.
Excluding, your lordship, what has happened is, without prior any intimation or anything, they have removed us from the
they
society, your lordships.
They appeared before the AGM and took a part in the
No notice was issued before the disqualification, your lordships, and the agenda was itself was not for the disqualification, your lordships. The complaint also we have given to the DRCS. The DRCS therefore issued a notice to the society also, your lordships, to initiate to question, your lordships.
Yes, same order. ಎಲ್ಲ ಅಲ್ಲೇ contest ಮಾಡಿ.
By excluding ಆಗ್ಬೇಕು ಅದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿನೂ ಇಲ್ಲ. Their name is not appearing either in the provisional voter list.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಅಲ್ಲೇ. Yes. Next.
55, Prasad Patil, Viresh Budhi.
My lords, in this matter, I appeal for the.
Not on submission. For 2 minutes, Lord. Their name, Lord, the petitioner's name, Lord.
Again, dispose ಮಾಡೋದು ಬೇಡ. List after vacation. Yes. Next.
Your lordships,
interim order ಇದೆಯಾ?
Interim order ಇದೆ, your lordships.
Interim order subsisting will continue to the next state of affairs. Yes.
My lords, in serial number 55, I appeal for the petitioner, my
In
lords.
this case, I represent respondent 3 and 4, sir. I have preferred appeal, sir.
My lords, the appeal, my lords, there's no stay, my lords. If your lordship remember, my lords, on the previous occasion, your lordship was pleased to direct the respondents to open the financial bid of the petitioner, my lords. Then it was the
Okay,
submission on part.
what has happened? What has happened now?
My lords, my instructions are that the financial bid has not been opened, my lords.
I have preferred appeal, sir, against.
You preferred appeal against this order. ಏನಾಯ್ತು?
It is pending compliance, sir.
Pending compliance. The learned counsel appearing for the respondent submits that the respondent has preferred an appeal against the interim order granted by this court on 18/11/2025, and the writ appeal is pending compliance to be to get it posted before the vacation bench. Correct?
Yes.
So and so. Therefore, list this matter after vacation. Interim order subsisting will continue to the next date of hearing. ಯಾಕೆ ಈಗ ಪೋಸ್ಟ್ ಮಾಡ್ಸಲ್ವಾ ರಿಟ್ ಅಪೀಲ್? ಈಗ ಪೋಸ್ಟ್ ಮಾಡ್ಸಲ್ವಾ ರಿಟ್ ಅಪೀಲ್?
ಮಾಡ್ತಿಲ್ಲ ಸರ್, ಈಗ ಮಾಡ್ತೀನಿ.
ಸುಮಾರು ಜನ ಕಾಯ್ತಾ ಇದ್ದಾರೆ ವೆಕೇಶನ್ ಬೆಂಚ್ಗೆ ನನ್ನ ಆರ್ಡರ್ಗಳು ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕೆ. ನೀವು ಒಬ್ರದ್ರಲ್ಲಿ ಮಾಡಿ.
Jagdish Patil, GV Baramgowda.
After vacation.
No, after 17th, your lordship.
17th,
After-
17th.
Yes, lord.
Seal number 57, Bhatt Ganpati.
Fifty?
57.
After vacation, yes.
Seal number 58, AC Chaklabi, Prashant Osmani.
Transfer.
Transfer order has been challenged.
Transfer, my lords, has been transferred from Bagalkot division to
Uttar
Uttar
Kannada
Kannada division.
And the punishment.
You are not permitting him to work on last time.
My lords, the interim order was subject to, my lords, if he is not relieved by then, he was already, before passing of the interim order, my lords, he was already relieved. This clarification.
No, lords. They are not relieved from the.
He was already, no,
Have
relieving order.
you filed your objections?
I'll file.
Why do you take?
This, my lords.
Case illa anta artha. ಮತ್ತೆ ಲೇಟ್ ಮಾಡಿದಷ್ಟು ಕೇಸ್ ಇಲ್ಲ.
And it is a covered by judgment of this division bench of this honorable court.
ಎಲ್ಲಿದೆ?
I will produce, lords. Punishment transferred without inquiry can't be done.
This is not a punishment transfer.
Punishment transfer.
No, this is, my lords, a
For a
transfer.
moment, kindly see the transfer order, lords. Annexure page number 13. ಮೇಲಿನ ಉಲ್ಲೇಖದ ಬಾಗಲಕೋಟೆ ವಿಭಾಗದ ಈ ಕೆಳಕಾಣಿಸಿದ ಚಾಲನಾ ಸಿಬ್ಬಂದಿಗಳು ಪದೇ ಪದೇ ಕರ್ತವ್ಯಕ್ಕೆ ಗೈರು ಹಾಜರಾಗುವ ಪ್ರವೃತ್ತಿ ಹೊಂದಿರುವುದರಿಂದ.
Lords, as far as
anything else?
No, as far as, my lords, that absenteeism cases are concerned, already, my lords, penalty orders are passed. He has accepted the penalty. Lords, those all matters are closed.
ಆಯ್ತು ಪದೇ ಪದೇ ಅದೇ ಅಂತ ಯಾಕೆ?
No, taking into consideration, my lords, the performance of the workman.
ಪದೇ ಪದೇ.
Even after, my lords, penalty being, my lords, imposed upon him, he has not corrected himself. Therefore, my lords, to improve his performance and also, my lords, for the proper delivery of service to the public, my lords, we have taken this administrative decision.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಪರ್ಫಾರ್ಮೆನ್ಸ್
No,
ಇಂಪ್ರೂವ್ ಆಗುತ್ತೆ ಅಂತ.
He is here for, my lords, petition number 1 is working.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಇಂಪ್ರೂವ್ ಆಗಲ್ಲ.
No, but, my lords, we have to.
ಎಲ್ಲಿ ಇರ್ತಾರೆ ಅಲ್ಲಿದ್ರೇನೆ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಇರೋದು.
Lords, what has happened in this particular case, my lords, what has happened is, in fact, these two petitions, 4 employees. Lords, there are several cases wherein, my lords, we have also my lord, conducted an inquiry and imposed penalty on them. They haven't improved. Now, my lords, they have working in that place for the last more than 5 years. In case of, my lords, second petitioner, he's here there for, my lords, 2015 he's working there. Now, at the same place, my lords, they have found their comfort zone, and, my lords, they are continuing with their own old habits. Now, my lords, my lords, even after, my lords, imposing penalty on them, they haven't shown any improvement. Now, my lords, we have to extract proper work from them.
That doesn't mean you transfer as a measure of punishment, sir.
But this is, my lords.
You can't do that, plain and simple. You initiate proceedings against them, not a problem.
But I'll file, my lords, because I'll file there, my lords. Interim order was, my lords.
This court on 21/11/2025 has passed the following order. The learned counsel Prashant Osmani submits by the time the interim orders were granted, the petitioner had stood relieved from the place where he was working to get himself to join to the transferred post. The learned counsel of the petitioner would dispute the position that he had not yet been relieved. In that light, objections would become necessary at the hands of the respondent. Interim order subsisting would continue to the next date of hearing. List on 18th in the fresh matters list.
Please.
Yes.
File objections.
Astral objections, if any, by then failing which the petition would be answered, dehorse the objections.
Please.
Next.
Number 59, Yadwad Girish, Chetan Murali.
Hand summons, my lord, was ordered. I had gone to serve. I filed an affidavit. Respond number 7 is my husband, my lords.
Your husband?
Writ petition is seeking a direction to, my lord, enter our names in the service book of respond number 7.
Let the husband come. Yes. Post immediately after service of notice upon the 7th respondent. By interim order, it can't be done anyway.
Please. Yes. No, my interim order, though I have not sought, my request would be that, my lord, the representation is submitted saying that he has now taken a second marriage.
Let the husband come.
Their names, if entered, my lord, then we will be subjected to.
Correct. He may say, I have a third wife also. Who knows? Him come. Yes. ನೀವು ಯಾರಿಗೆ ಸರ್?
ಸ್ಮಾಲ್ ಇಂಟರ್ಫಿಯರೆನ್ಸ್, ಸಾರಿ. ನಿನ್ನೆ 120 ಬಾಗಲಕೋಟ್ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್
ಲಿಸ್ಟ್ ಆಗಿದೆ ಇವತ್ತು.
ಅಲ್ಲಿ 121 ಲಿಸ್ಟ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ಜಸ್ಟ್ ಐ ಆಮ್ ಸಾರಿ ಫಾರ್ ಮೆನ್ಷನಿಂಗ್ ಇಟ್.
ಅದು ಕ್ಲೋಸ್
Now, my lords, the inquiry officer has come to the court and they are asking for presence of the advocates for inquiry. ನಮ್ದ್ರಲ್ಲಿ ಅದಕ್ಕೆ
ಗಂಗಾಧರ್ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ ಇದ್ದೀರಾ ನೀವು? ಕೊಟ್ಟಿದ್ ಯಾವುದು? ಓ, ಒಂದು ಜಿಮ್ಸ್ ಒಂದು ಕಿಮ್ಸ್ ಕೊಡಿ ಕೊಡಿ. ಒಟ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಜಲ್ದಿ ಬರಿಬಾರ್ದು ಅದಕ್ಕೆ. ಎಸ್ ಸರ್, ಅದೊಂದು ಇಟ್ಕೊಳ್ಳಿ. ದಿಸ್ ಇಸ್ ಒಂದು ಡೆಂಟಿಸ್ಟ್ರಿ ಅಂತ ಬರ್ತಿದ್ದೀನಿ ಫೈಲ್, ಅದ್ರ ಮೇಲೆ.
In this 59, my lord, office has sought for payment of fresh process. Office maybe I'll take fresh steps.
I'll take it. On 5 o'clock a full court meeting is there. I have to get up. So we'll take whichever is possible. Nale I'll sit up to 7 o'clock. Not a problem.
And fresh matter ಬಂದ್ರೆ
Fresh ಎಲ್ಲ ನಾಳೆ fresh matter ಲೇ ಹಾಕ್ತೀನಿ ಎಲ್ಲ. ಇವತ್ತು ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ. 5 o'clock full court ಇದೆ. I have to go. ಇಲ್ಲರೆ I would have missed it. Not a problem. ನಾಳೆ 7 ಗಂಟೆವರೆಗೆ ಕೂತ್ಕೊಂತೀವಿ. 7:30 we'll sit tomorrow. Not a problem.
41 ಒಂದು.
ಎಲ್ಲ ಇವತ್ತು ರೀಚ್ ಆಗದೆ ಇರೋದೆಲ್ಲ ನಾಳೆಗೆ ಹಾಕ್ಸ್ತೀನಿ. ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತಾನೆ ಹಾಕಿಸ್ತೀನಿ. ಆಲ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ವಿಚ್ ಎವರ್ ಇಸ್ ನಾಟ್ ರೀಚ್ಡ್ ಐ ಕಂಪ್ಲೀಟ್ ಎವ್ರಿಥಿಂಗ್ ಅಂಡ್ ಗೋ ಟುಮಾರೋ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಟುಮಾರೋಸ್ ಮ್ಯಾಟರ್ಸ್.
Serial 176, my lord, tax matter, it has come in B group, my lord. Covered by a circular.
ಎಲ್ಲ ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
Tomorrow in fresh matters. ಅದು B group ಅಲ್ಲಿ ಇದೆ.
ಯಾವ್ದು ನಾಳೆ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಯಾವ್ದು ಇಲ್ವೇ ಇಲ್ಲ ಬೇರೆ, ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Today it is in B group, that's why I made a.
Tomorrow it won't be in B group.
Yes.
ನಂದ್ರಲ್ಲಿ annexure
ಇದು ತಗೊಂಡ್ಬಿಡ್ತೀನಿ ತಾಳಿ. This I'll take.
I'm at
Lordship, serial number 94, section 55 of KP Act it is.
KPID?
Karnataka Police Act, Lordship.
Externment ಅಂತ ಹೇಳಿ 50?
Serial number
55 dispose Surat Sahib order.
Serial number 94, Lordship.
94 externment ಆ? 55 after vacation. ನೀವು ಇರ್ಲಿಲ್ವಾ?
No. Serial number 94, Lordship.
94 or 55 ಆ?
94, Lordship.
94.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್.
94 externment ನೋಡಿ ಅಜ್ಜಿ. ಇವ್ರು ಹೇಳಿದ್ಮೇಲೆ externment ಅದು.
Serial number 82, my lord.
Candy, my lord. Serial number 192 and 3, my lord.
ನಾಳೆ ಸರ್.
Writ of mandamus, press matter, my lord.
ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ನಾಳೆ.
I'm at serial number 126, my lord. Meet with tomorrow. Serial number 191, my lord.
ಎಲ್ಲ ಮುಳಿಮನಿ ಸರ್ ವೇಟ್.
Please. 59 notice may be issued. Office has sought for a fresh process.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
59 just which concluded. Process is sought again. They have not stated what happened to the earlier, but anyway I'll take fresh steps. Office may be direct.
Finish Shilvan sir's matter.
ಅದು notice my lords have taken it. It has concluded.
ಎಲ್ಲ ನಾಳೆ ಬರುತ್ತೆ.
59 got concluded. It is urgent, my lord. 59 is urgent. 59 is urgent.
May I make a request?
Awaiting service to respond number 7.
Oh, husband.
Office has sought for fresh process. I'll take it, my lord. Office may be directed to issue notice. ಅದು ಆರ್ಡರ್ ಅಲ್ಲಿ ಬರಲಿಲ್ಲ.
The petitioner is permitted to take out fresh steps for service of notice upon the 7th respondent.
My lord, serial number 76 and 77.
ಎಲ್ಲ ನಾಳೆ ಮೇಡಮ್.
Tomorrow.
ನಾಳೆ ಬೇಡವಾ?
ಇಲ್ಲ ಸರ್, ವಿಡ್ರಾ ಮಾಡ್ಕೋತಿದ್ದೀನಿ ಅದ್ರ.
Thank you. ಈಗಲೇ ತಗೊಳ್ತೀನಿ. 76, 77.
Liberty to file a fresh petition.
ಯಾಕೆ?
Liberty to.
ಏನ್ liberty?
ಅದು actually respondent ನಾವು ಮಿಸ್ಟೇಕ್ ಆಗಿ ಹಾಕಿದ್ವಿ ಸುಮ್ಮನೆ.
Oh, sorry. The learned counsel appearing for the petitioner seeks leave of this court to withdraw the petitions and prefer fresh petitions on the same cause of action owing to certain inadvertent omissions in the petition. The memo is taken on record. Liberty so sought is granted. Petition stands disposed as withdrawn. ಎರಡು ಅಲ್ಲ?
My lord.
ಎರಡು.
ಹಾ, ಎರಡು.
My lord, 174 ಅಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್. Serial numbers ಯಾವ್ದು ಮೇಡಮ್?
76 and 77.
Prithvi case.
Priyanka. 77 and 70. Sorry, my lord.
ಯಾರ್ದೋ petition withdraw ಮಾಡ್ಬಿಟ್ರೆ.
My lord, one request make, my lord. 126, my lord. Tomorrow, my lord, I shall be able to attend through VC, my lord.
However you want, you can attend, sir.
Today I waited.
What to do today?
Very well. Tomorrow I shall attend over VC.
Can be disposed before 4:50. I will take it. That's all.
174 serial number lordship had specifically.
1 minute, sir. VC, I will come back.
Serial number 174, lordships had specifically directed to list it in fresh matters list.
Tomorrow fresh matters, sir.
Please.
Yes. Tomorrow fresh matter.
My lord, serial number 72.
Record ಮಾಡ್ಬಿಡ್ಲಾ? Tomorrow fresh matter, tomorrow fresh matter, tomorrow fresh.
My lord,
My lord, list number 2, serial number 25.
My lord, serial number 72.
List number 2 ಅಲ್ಲಿ ಉಳಿದಿದ್ದ ಮ್ಯಾಟ್ರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಬರುತ್ತೆ ಎಲ್ಲ.
Please.
My lord,
Serial number 83, wherein Jaykumar is.
Tomorrow,
72.
Anxiety is that, my lord,
tomorrow,
they should not announce the calendar of.
tomorrow, sir. Yes.
My lord,
serial number 172. Entry matter may kindly be extended, my lord.
Yes, sir, it will be extended.
Serial number 60, my lord. It's a mandamus, my lord. Serial number 60, my lord.
60, my lords, it may be allowed, my lords, with the direction to consider the same.
Wait, yes, ಮಿಕ್ಕಿದೆಲ್ಲ
my lord, serial number 72.
Serial number 52 passed over matter. Serial number 52.
ಅದೇ 21 years.
27 years.
ನಾಳೆ
27 years.
ನಾಳೆ
First or on the.
107.
ಇಲ್ಲ tomorrow pass over.
72, my lords.
ಬೇಡವಾ ನಾಳೆ?
ನಾಳೆ.
ನಾಳೆ. ಯಾವುದು? ಪ್ರೇಯರ್ ಏನು? ಯಾವುದು? Serial number 80 ಬರ್ಕೊಳ್ಳಿ. The petitioner is before this court seeking the following prayer. The learned AGA submits that a crime is registered on the complaint registered by the petitioner, therefore the petition is rendered infructuous. In the light of the registration of the crime, the petition is rendered infructuous. The petitioner is reserved liberty to approach the appropriate fora in the event of need, ordered accordingly. ನಾಳೆ ಬೆಳಿಗ್ಗೆ ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಬರುತ್ತೆ. If it doesn't come, we'll vacate it. Tomorrow fresh matters. ಎಲ್ಲ ಯಾವುದೇನು ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ. Unless you want some disposal now, urgency ಇದ್ರೆ. Yes. Otherwise everything tomorrow. Entire list, remaining list will be repeated tomorrow.
It's serial number 97.
ಅದು ಇವತ್ತು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ವಾ? ನಾಳೆ ಬರುತ್ತೆ.
I for bringing a last application filed. After saying delay in filing application, within 90 days I have filed. I may be allowed, then I may be permitted.
ನಾಳೆ ಮಾಡ್ಬೋದು ತಾನೆ ಅದು?
Serial number 184. Mandamus ಇದೆ, fresh matter ಅಲ್ಲಿ ಹಾಕೋಬಹುದು.
ಎಲ್ಲ ಫ್ರೆಶ್ ಸರ್ ನಾಳೆ. ಎಸ್ ಮೇಡಮ್, ಯಾವ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಇರಬಾರ್ದು ನಾಳೆ, ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Serial number 68.
ಮೇಡಮ್ ಅರ್ಜೆಂಟ್ ತಗೊಂಡ್ರೆ ಹೋಗಿ.
Serial number 89, lords. It is an Surface Act and
ನಾಳೆ
fresh matters.
ಎಲ್ಲ ನಾಳೆ ಫ್ರೆಶ್
Please,
ಮ್ಯಾಟರ್ಸ್.
please.
ಎಸ್ ಶ್ರೀನಿವಾಸ ನಾಯ್ಕರಿಗೆ
ಇಲ್ಲ 41 ಒಂದು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು, ಅದು ನಾಳೆಗೆ.
ನಾಳೆ
ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಮ್ಯಾಟರ್ ಅದು.
ನಾಳೆ
ಪ್ಲೀಸ್.
Serial number 68. Similar matters are pending before the principal bench, Your Lordship.
ಯಾವುದು?
68.
ಏನದು?
ಮಲ್ಲಡ ESI ಮ್ಯಾಟರ್ ಮಲ್ಲ.
ನಿಮ್ದು ಅದು ಮೊನ್ನೆ 160 ಮ್ಯಾಟರ್ಸ್ ಹೇಳಿದ್ರಲ್ಲ, ಯಾವ್ದು? ಅಲ್ಲ ಅದೇನು ಮೀಡಿಯೇಷನ್ ಹೋಗಿದ್ಯಂತ?
ಅಲ್ಲ ಮೀಡಿಯೇಷನ್ ಫೇಲ್ ಆಗಿ ಮೀಡಿಯೇಟರ್ ಇನ್ನೂ ಸೈನ್ ಹಾಕಿರ್ಲಿಲ್ಲ, ಇವತ್ತು ಹಾಕಿದಾರೆ ಸ್ವಾಮಿ. ಮಂಡೇ ಆದ್ರೂ ಲಿಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದಿದೆ.
ಮಂಡೇ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಅದನ್ನೆಲ್ಲ ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು ತಾನೆ?
100% my lord. Section 10 CPC has no application to the labor code. My lord, reference is my lord state and KID is also state, my lord, for that purpose.
ಆಯ್ತು, ಸೆಕೆಂಡ್ ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ.
Please.
Serial number 70.
ನಾಳೆ
ಅಲ್ಲ ನಾಳೆ take the instruction from the cantonment.
ನಾಳೆ ಹೇಳಿ ಅದನ್ನ.
ನಾಡದು 16th.
ನೀವು ನಾಳೆ ಏನ್ ಬೇಕು ಹೇಳಿ, ಒಂದೊಂದನ್ನೇ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನಾಳೆ ಎಲ್ಲ ಎಂಟೈರ್ ಲಿಸ್ಟ್ ವಿಲ್ ಬಿ ರಿಪೀಟೆಡ್. Yes.
Lords, serial number 60, my lords. It can be disposed of, my lords.
That I will do now. Yes. 60 ತಗೊಳ್ಳಿ. The petitioner is before this court seeking the following prayer. The heard so and so.
Consider to
The petitioner
representation.
ಏನು ಕೊಟ್ಟಿದ್ದ ಕಾರಣ?
Lords, there is a difference, my lords, of the
We had availed
amount,
of
my
2
lords.
crores.
The petitioner submits a representation owing to the fact that their petitioner has been short paid, or there is a difference of amount that the petitioner is entitled to under the deductions. The representation is submitted to the respondent which is yet to meet its consideration. The learned counsel Girish Hulmani submits that if reasonable time is granted, representation will be considered in accordance with law and necessary orders will be passed thereon. In the light of the said submission, I deem it appropriate to dispose the subject petition with a direction to the respondents to consider the representation in accordance with law and pass necessary orders thereon within
8 weeks.
within 12 weeks from the date of receipt of the copy of the order. It is made clear this court does not assist the claim, merit of the claim of the petitioner, ordered accordingly.
Till then, my lord, let them not take any precipitative steps.
It
Because,
is
my
needless
lord-
to observe that till the consideration of the representation, no precipitative action will be taken against the petitioners.
That's another one submission, my lords. List number 2, serial number 2 has been disposed of, my lords.
ಏನದು ಗಿರೀಶ್?
My lords, in that, my lords, I had filed an application for early hearing. That has not been put up, my lords.
ಈಗ
So-
ಏನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರು?
ಅಲ್ಲ, dispose ಆಗಿದೆ, my lords. Pending applications, if any, may be.
ಅಯ್ಯೋ ಅಷ್ಟೇ ತಾನೇ.
And my
All
lords-
applications pending stand disposed.
And my lords, outer limit, my lords, at least for 8 weeks. To consider.
10 weeks.
Please, my lords.
ಅದ್ರಲ್ಲಿ ನೋಡಿ ಮೇಡಮ್ ಯಾರಿಗಾಗಿದೆ 10 weeks outer limit.
Serial number 2, my lords.
ಗೊತ್ತಾಯ್ತು.
Please, ma'am. Much obliged.
My lord, serial number 67, another 2 matters are pending, my lord, connect.
Let's it may be taken next week, my lords.
ಯಾವ್ದು ಮೇಡಮ್?
Monday, 67.
67.
Interim order.
Administrator,
ಏನದು?
Administrator
appointment
appointment.
of administrative paid by this honorable.
Next week.
Interim order may kindly.
Interim order subsisting will continue to the next.
Great.
Connects.
May I make a submission, my lords?
ಒಂದು ನಿಮಿಷ. ಏನಮ್ಮ?
ನಾನೇ ಇದನ್ನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ ವಕೀಲ್ ಇಟ್ಟಿಲ್ಲ
ಹಾ.
ನಾನೇ ನಡೆಸ್ತೀನಿ.
ಮೈಕ್ ತಗೊಳ್ಳಿ. ಅದೇ ಹೇಳ್ಕೊಳ್ಳಿ. ಹಾ. ಏನ್ ಹೇಳಿ?
ಈಗ ವಕೀಲ್ ಇಲ್ಲ ಸರ್ ನಾನು.
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು?
108.
ಏನ್ 108? ಏನ್ ತೊಂದರೆ ಆಗಿದೆ?
ಏನಿಲ್ಲ ಸರ್ ಮೇಂಟೆನೆನ್ಸ್ ಹಾಕಿದ್ವಿ ಸರ್.
ಹಾ.
ನನಗೆ ವಕೀಲ್ ಇಡಕ್ ಆಗಲ್ಲ. ಅದು ಮೊದ್ಲೇ ಇಟ್ಟಿದ್ದೆ ಸರ್. ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರೆ ಸರ್. ಅದ್ರ ಮ್ಯಾಗ ನನಗೆ ವೆಕೇಟ್ ಮಾಡ್ಕೊಡ್ಬೇಕು ಸರ್. ನಮ್ ಕೆಳಗಿನ ಕೌಟುಂಬಿಕನ ಇಲ್ಲದಾಗ ನಡೆಯಕ್ ಕೊಡ್ಬೇಕು.
ಆಗಿದೆಯಾ?
ಅಷ್ಟೇ ಆಯ್ತು ಸರ್.
2023 ಮ್ಯಾಟ್ರಾ?
ಹ್ಞೂ ಸರ್.
ಮತ್ತೆ ಯಾವಾಗ ಬರ್ತೀರಾ? ನಾಳೆ ನಾಡಿದ್ದು?
ನೀವು-
ಬೆಳಗ್ಗೆ 10:30ಗೆ ಹಾಕ್ತೀನಿ.
ಏನ್ ಸರ್?
ಯಾವತ್ ಬರ್ತೀರಾ?
ನೀವ್ ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
ಶುಕ್ರವಾರ ಬರ್ತೀರಾ? ಶುಕ್ರವಾರ ಬೆಳಗ್ಗೆ 10:30ಗೆ ತಗೊಂತೀನಿ ಬನ್ನಿ.
ಆಯ್ತು ಸರ್. ನಮಸ್ಕಾರ.
ಫ್ರೈಡೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕಿರಿ. ಆಯ್ತು.
Serial number 104, my lord. Chit funds have put my property to the auction, my lord.
ನಾಳೆ.
Where, please.
Tomorrow it will come, sir. Yes. ಅವರು 14% ನಾಡಿದ್ದು ಅಂತ ಹೇಳಿದ್ರು. ಶೀಲು ಅಂತ ಅವ್ರಿಗೆ ಕೊಡಿ.
My lord, serial number 110, I am seeking an adjournment. It is up to my lord. 110, my lords. I represent Mr. Hebbaldi. But 3 matters are there. In one matter, he is for petitioner, and in other 2 matters, he represents the respondents. It requires, from my side, it requires a submission. May I request, may be called after?
After vacation.
Maybe, mas. Only for that purpose, I'm.
Bangalore bench, Bangalore bench, serial number.
After vacation.
The first matter.
After vacation.
ಅಲ್ಲ 121 ಅಲ್ಲಿ.
ಈ matter. Yes.
The first matter. Lord, there are certainly, Lord, allegations against the Lord present committee. Lord, out of 569 members, Lord, I just want to make.
Clashes.
Allala, it is not a ego class. Your Lordship may kindly, Lord, appreciate. Lord, out of 569.
Enquiry summon ಮಾಡಿದ್ದಾರೆ, sitting in the, why society, registrar or somebody should come.
It is for them, Lord, misdeed what they have committed. Lord, it is for them. Your Lordship may kindly, Lord, see. Lord, 569 members are there, Lord. Out of 569, 2, Lord, 58 have signed the resolution, Lord, seeking for, Lord, inquiry to hold inquiry, Lord, by the registrar.
Really, sir?
Allah, they have no confidence, Lord, of the members.
No confidence motion.
Allah, not no confidence. They have
provision illa andre.
Allah, provision Allah. Confidence of the members are required to, Lord, hold the office.
Disqualification.
Allah, that is apart. But here, your Lordship may kindly see the inquiry to conduct the inquiry. Lord, 1/3 majority is required as per Lord Section 25. Lord, 258 have signed the Lord resolution. They are agreeing to, my lord, hold the inquiry. And your lordship,
Which matter is that?
121. ಅದಕ್ಕೆ ನಾನು, I requested your lordships to delink that 121. So far as, my lord, other matters are concerned, my lord, I am not, my lord.
You are not a party even.
No, I am not a party in those matters.
Adhe Shivlan sir. What are the other matters?
Other matters, my lord, the disqualification is challenged.
You are the Oh, that stay
that I have stated, my lord, that order is wrong. That resolution is wrong, that may be allowed. Not, I have no grievance about, because the bylaws does not provide for that.
ಸ್ವಲ್ಪ ಸೈಡ್ ಗೆ ಇಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದು ತಗೊಂತೀನಿ.
Please.
ಅದು ಫಸ್ಟ್ ಮುಗಿಸ್ಬೋಣ.
Please.
ಅಲ್ಲ ಮೇಡಮ್, ಇದ್ರ ಜೊತೆಗಿರೋದು 121 point something something something. ನಿಮ್ಗೆ ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಬರಲ್ಲ? ಅವಾಗ್ಲಿಂದ 5-6 ಸರಿ ಪಾಸ್ ಓವರ್.
98299.
ಎಸ್. ಶೀಲೋನ್ ಸರ್, ಇದ್ಯಾರು?
986, my lords.
ಅಲ್ಲ, 107,991.
991.
ಹಾ.
ಇದು disqualified members.
ಅಜೆಂಡಾನು ಇರಲಿಲ್ಲ, ಏನೂ ಇರಲಿಲ್ಲ.
ಇಲ್ಲ, ಈ ಮೂರು ಇವರು lordship can allow those.
The petitioner is before this court seeking the following prayer heard so and so. The petitioner is an advocate, a member of the Belagavi na Bagalkot Bar Association, is before the court calling in question his disqualification. The disqualification admittedly is not preceded by any agenda note for the date on which the meeting was held. Without there being an agenda and deliberation upon the said agenda, to the shock and surprise of the petitioner himself who was present in the meeting, the disqualification order is passed. In the light of the disqualification not preceded by any agenda or deliberations upon it and it having serious civil consequences, the order of disqualification could not have been passed by the respondent association. In the learned counsel appearing for the respondent association, Shilwant is not in a position, no, Shilwant, though would at the first blush seek to defend the action of the association, would ultimately.
Consider ಮಾಡ್ಕೊಂಡ್ರೆ I have no objection. Melissa.
Sir. The learned counsel, Shilwant representing the bar would admit that the order could not have been passed without there being an agenda or a deliberation for the disqualification process, as disqualification undoubtedly entails in civil consequences. In that light, the order being in utter violation of principles of natural justice, I deem it appropriate to obliterate the same. For the aforesaid reason, the petition stands allowed, the order stands quashed. Yes.
Mine is
Resolution stands.
1008.
Resolution stands quashed. Next.
Mine is 100958, wherein inquiry is initiated, based on this.
ಅಲ್ಲ, 1 minute. ಈ ಮೂರು ಮುಗಿದ ಕೂಡಲೇ ನೀವು ಈಚೆ ಕಡೆ ಬರ್ರಿ.
ಒಂದು ನಿಮಿಷ. KL ಪಾಟೀಲ್ ರದ್ದು ಇನ್ನೊಂದು ಯಾವುದು?
107,986.
ಅದು ಸೇಮಾ?
ಎಲ್ಲ ಸೇಮ್.
Same reasons, Kavita madam.
And
107,986 same reasons cost.
982.
So ಇದು ಅಷ್ಟೇ. ಇನ್ನೊಂದು KL ಪಾಟೀಲ್ ಸರ್ದು ಅದೇನೆ ಸೇಮ್. ಈಗ ಶಿಲ್ವನ್ ಸರ್ ನಿಮ್ದು ಯಾವುದು?
108958.
ಅದೇನು?
ಇದರಲ್ಲಿ kindly see page number 50.
ಇದರಲ್ಲಿ
ಎಲೆಕ್ಷನ್ ಆಗಿ
ನೀವು ಪೆಟಿಷನರ್ ಈಗ?
ನಾನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ 2 and 3.
ಯಾವುದು? ಶಿಲ್ವಂತ್ ಅಂತ ಇದೆ?
108958.
ಹಾ.
ಈ
ಕಡೆ ಬನ್ನಿ. Yes.
Lordship can turn to page number, the inquiry initiated for these reasons, page 50.
But all of you should see, ರಿಜಿಸ್ಟ್ರಾರ್ ನ ಬಿಡಬಾರ್ದು ಅಸೋಸಿಯೇಷನ್ ಒಳಗೆ ನೀವು.
ಅಲ್ಲ, ಬಿಡಬಾರ್ದಂತ ನಮ್ದು ಇಂಟೆನ್ಷನ್.
ಅಲ್ಲ, ಅದು inquiry based on this resolution is quashed now, there is no question of holding an inquiry.
Which resolution?
Very resolutions.
ಈಗ ನಾನು
ಇದು quashed, other the inquiry ಮೇಲೆ and allegation misappropriation, no particulars are furnished. Hey, he want to hold an.
Want me to take it on merit? I will take it.
No
problem. No issues. If there is no material for calling disqualifying these members, you can't.
Yes.
And writ is not maintainable ಅಂತಿಲ್ವಲ್ಲ?
ಇಲ್ಲ. ನಾನು
maintainable ಇದೆ.
ನಾಳೆಗೆ ಹಾಕೊಂಡ್ಬಿಡಿ.
ಆಯ್ತು. 121 ನಾಳೆಗೆ. In 3 disposal, 121 ಮಾತ್ರ ನಾಳೆಗೆ.
121.
Now the enquiry officer coming to the Malad Bar Association, they are holding.
1 minute.
and they may be
In the right of the matter being heard, the respondent state shall hold its hands and not precipitate the matter till the next date of hearing.
There,
In the event it precipitates, the matter would be viewed seriously.
ಅಲ್ಲ
Tomorrow
ಅವ್ರೇನೆ
fresh
ಹಿಯರ್
matter.
ಮಾಡ್ತಾ ಇದೀನಲ್ಲ.
ಅಲ್ಲ
Tomorrow fresh
ನಾನು ಇಲ್ಲಿ
matter.
ಹಿಯರ್ ಮಾಡೋದು ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಮಾಡೋದು
ಇಲ್ಲ
ಆಗಲ್ಲ.
not like that, your lordship.
Yes.
There is a direction to furnish a report within 30 days. They are so influential.
ಈಗ ಆಯ್ತಾ?
ಅಲ್ಲ
ನಾಳೆ fresh
ಅವ್ರ
matter.
ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್.
ಅಲ್ಲ ನಾಳೆ fresh matter.
ಎಲ್ಲ ಫ್ರೆಶ್
ಇದ್ರಲ್ಲಿ ಯಾರು ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ಇಲ್ಲ. ಹೋಲ್ಡಿಂಗ್ ದ ಆಫೀಸ್ ವಿದೌಟ್ ದ ಲಾರ್ಡ್
ನಾಳೆಯಿಂದ ಮುಗಿಯೋವರೆಗೂ ಸೆಷನ್ ಬರೀ ಫ್ರೆಶ್. ಅದು 2010 ಆದ್ರೂ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆ.
ಅಲ್ಲ ನಿಮ್ಗೆಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆ, ಹಿಯರಿಂಗ್ ಬಂದ್ರೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆ.
ಯಾವ್ದಾದ್ರೆ ಏನು ಮುಗಿಸ್ತಾ ಇರೋದು ಅಷ್ಟೇ ಕೆಲಸ.
Only anxiety, my lord, this bar association should not indulge in this.
That is
my anxiety.
But Lord, your lordship, Lord, no, it is equally not correct on the part of Lord what. Yes. No, what your lordships are not observing is absolutely correct. But yes, but they are inviting to do so. Allah, adike let them be present. The president and Lord the secretary, entire members, let them be present before the court tomorrow and let them.
Why their presence is, I am here.
Allah, affidavit ಹಾಕೋದು ಬೇಡ. affidavit ಹಾಕೋದು ಬೇಡ. ಅಲ್ಲ ಆ ಬೈಲಾದಲ್ಲಿ ಯಾವುದು ಇಲ್ಲ
ಇಲ್ಲ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇಲ್ಲ ಇಲ್ಲ ಸರ್ ಇದರಲ್ಲಿ ಇಲ್ಲ ಇವು ಬೈಲಾದಲ್ಲಿ ಇಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಬೈಲಾಸ್ ಅಲ್ಲಿ ಹೌದು ಅದನ್ನ ಹಾ ಇದು ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಮೇಡಮ್ ಅದರಲ್ಲಿ ಎಕ್ಸ್ಪಲ್ಷನ್ ಇದೆ.
We are also not eking out because
what they say is
yes.
Now Malase, as recent 2 or 3 months, this has arisen.
No, what they
earlier
have
Malase, there were no disputes.
Whatever
like
it is there out of the court.
I don't know Malase.
I don't want to just bring it, just for a sake of Lord, without notice they have disqualified some of the members. Not even some. ಅಲ್ಲ ಈ ಪ್ರೆಸೆಂಟ್ ಕಮಿಟಿದವರು ಆಮೇಲೆ ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಅದನ್ನ ಕಾಪಿನೂ ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ
majority members
they have not even served the ಅಲ್ಲ they have not even served that resolution and they have circulated through entire Karnataka in the WhatsApp that stating the so and so fellows have been disqualified. What is the integrity of the practicing advocate? All the committee members, the present committee members, how do?
No.
Undo the harm which has been caused for my integrity, my lord. Yes. Yes.
It is the worst thing that can
Yes.
happen to an advocate saying is when disqualified.
Yes.
This definitely takes away his honor.
Yes.
If you have done that, then the committee should immediately recall it. You recall and report.
If that is done, Malas, I'll make inquiry. Whether I don't know exactly what happened.
I can just.
If that is done, Malas, I'll ask them to.
An eye for an eye will lead the bureaucrats into the.
If that is done, Malas, that is wrong.
If that has happened.
I can produce the WhatsApp messages, my lord, throughout which has been circulated throughout the Karnataka. Yes.
If you say disqualified for XYZ reasons.
I'm regularly standing.
That should not happen. Malas, I was not aware of this, whether committee has done or.
I am a standing practitioner before the court. My integrity is entirely lost.
Plus, if committee has done it, Malas, I'll undertake.
If that is the case, I explain that justified.
Yes, Malas, if that is the case, Malas, I'll ask them to recall it and publish it in the paper. I absolutely know that is wrong. According to me, that is wrong.
Yes.
That will happen, then we'll say all bygones be bygones.
And yes, tomorrow let them be produced before produced before this court, and let them seek an undertaking.
I am representing, sir. I am undertaking before this court. If that is there, I don't know why they are insisting their presence.
Yes, so I will do it.
Friday I take it, by then everything will be done.
Yes.
Right? Friday thoda Monday thoda.
Friday. Friday or Thursday, Lordship can have it. I'll ask them to.
ಅಲ್ಲ ಮಂಡೇಗೆ Lordship. Friday I have some.
Thursday.
Tomorrow.
Thursday, Lordship can.
Thursday, day after tomorrow.
No, sir, I'll undertake before. If that is the committee has not published it, they are bound to publish it for saying that it is recalled. It is my words before.
That should not restore the complete wrong,
At least, my lord.
ಇಲ್ಲ I was not aware of this. Since you have said, my lord, I will make inquiry. If that is there, I will see that it is.
I can produce the WhatsApp message.
It is published.
If it is.
I am not disputing him. If that is the committee has done, that is the wrong thing which I said. I will see that it is.
Please, great.
we close it on Friday or Thursday.
Thursday. Please.
Serial number, my learned respondent concedes regularization matter, teachers. Yes, sir. Tomorrow, please.
Serial number 10 entry model.
Yes, please.
Entry model expires.
My apologies, because I missed. I was seeing the list notes just skipped. Anytime next week, if Lordship may have it for me, it's 10 minutes. Yes.
Serial number 82, 95, and 191, my lord. We will listed in fresh matter, my lord, tomorrow.
Lords, I have one request, Lord. Lords, I have one request.
Further hearing, it's in the same category. If it were to be listed, further hearing.
Further hearing only 9th January.
Please, understood.
Serial number 101.
230 list notes. Yes, great.
Serial number 101, my lord.
ನಾಳೆ
Entry model expires, my lord.
ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Lord, one request, Lord. Serial number 149, my lord. There is some urgency. 149. That is a contract with the.
No, I represent respondents in that case. I pray for
ethanol, Lords. They had agreed to receive.
ethanol ಇತ್ತಲ್ಲ.
That
matter
was over, my lord.
149, Lord, I represent, Lord. R2 to R4. I pray for.
ಇದು identical ethanol ಅಲ್ಲ?
ಇಲ್ಲ, it's not identical.
Tomorrow, my lord.
Tomorrow. Prabhu sir, ಇವಾಗ ಟೈಮ್ ಇಲ್ಲ. I have a full court meeting at 5 o'clock.
I request tomorrow.
I will take it tomorrow.
Please.
Tomorrow in fresh matters.
I pray for, Lord, one submission. Serial number 149, I pray for 2 to 3 days time, Lord. I have to receive instructions.
ನಾಳೆ ಕೇಳಿ sir. Tomorrow you ask. Yes.
Yes, please.
List number 2 ಮಿಕ್ಕಿದ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಫ್ರೈಡೆ ಬರುತ್ತೆ, ಥರ್ಸ್ಡೇ ಬರುತ್ತೆ. ಏನು ಎಕ್ಸಿಟ್ ಟೈಮಲ್ಲಿ ಬರ್ತಾ ಇದೆ.
Entry model ನಾಳೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್. ನೀವು ಜಸ್ಟ್ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ ನಾಳೆ.
Court officer. Madam, 108.
Madam.
Court officer.
ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ನಾಳೆ.
Madam, 120.
Entry model, sir.
Instruction, sir. Where is entry model extended?
ಎಲ್ಲ ರಿಮೈನಿಂಗ್
Court officer. Bangalore bench serial number 1 ಯಾವತ್ತು ಡೇಟ್ ಅಮ್ಮ?
ಸರ್ ಹೇಳಿ ಸರ್.
ಹಲೋ.
Court officer.
Serial number 1 Bangalore bench. ಯಾವ ಡೇಟ್ ಅಮ್ಮ? Serial number 1 Bangalore bench. 10th Court officer ಕೇಳ್ತಾ ಇದೀಯಾ?
ಹೇಳಿ ಸರ್.
ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ್ serial number 1 ಯಾವ ಡೇಟ್ ಅಮ್ಮ?
Serial number 1 ಸರ್?
ಬೆಂಗಳೂರು bench 21 rule 46. Serial number 1 ಯಾವ ಡೇಟ್ ಅಮ್ಮ? ಡೇಟ್ ಅಮ್ಮ?
17 ಡಿಸೆಂಬರ್ ಸರ್.
Right. Madam, serial number 108. Court officer.
List number 12.
Court officer.
Entry model. ನಾಳೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಜಸ್ಟ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. 73.
Court officer. Court officer.
ಮೇಡಮ್ 129 ಮೇಡಮ್ ಅದು
Court officer, madam.
Madam, entry matter.
Serial number 145.
ಮೇಡಮ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ 129.
Court officer.
Court officer.
ಮೇಡಮ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ 129.
ಮೇಡಮ್ 77, 78.
Court officer, madam.
Court
Court
officer,
officer
madam.
145. Serial number 145. Can you hear me, court officer?
Sir, ಹೇಳಿ sir. Sir, ಹೇಳಿ sir.
145 ಮೇಡಮ್ ಕೈಂಡ್ಲಿ 12th ಇಟ್ಕೊಳಕ್ಕಾಗುತ್ತಾ ಮೇಡಮ್? ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ. 145 12th ಸೀರಿಯಲ್ ನಂಬರ್ 145 ಮೇಡಮ್. ಶಂಕರ್
77.
ಆಯ್ತು ಸರ್, ಆಯ್ತು.
Madam,
Thank you.
108.
Court officer, madam.
Court officer, madam, 108.
Court
ಹೇಳಿ
officer,
sir.
madam.
108.
82, 95, 191. ಮೂಲಿಮನಿ ಸರ್ ರೀ madam.
ಅದೇ ನಾಳೆಗೆ ಹಾಕಿದೆ ಸರ್, ಅದು ರಿಪೀಟ್ ಆಗಿದೆ ನಾಳೆಗೆ.
Thank you, madam.
ಮೇಡಮ್ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಯಾವುದು ಮೇಡಮ್?
Court officer, madam. Court officer. 108 ಸಾಹೇಬ್ರು ಫ್ರೈಡೆ ಇಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು. ಅವರು 14% ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರಲ್ಲ. ರೆಡಿ
28 40
108.
ಸೀರಿಯಲ್ ನಂಬರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 108.
ನೀವೇ ಕರೆಕ್ಟ್. ನನಗೆ ಮೈಂಡ್ ಇಲ್ಲಿದೆ ನನಗೆ.
108.